Well, good morning, everyone. My name is Scott Bullock. I'm President and Chief Counsel of the Institute for Justice. And as many of you know, the Institute for Justice is the national law firm for liberty. We are a public interest group that is in court every day defending Americans' essential constitutional liberties. Our four areas of focus, or the pillars as we call them, are economic liberty, private property rights, free speech, and educational choice. We also have two new projects that we started just in the past few years, one dedicated to challenging these unfounded immunity doctrines that exist in the law, including qualified immunity and absolute immunity. And then we just started a project a few years ago to greater recognize and restore protections for the Fourth Amendment rights to be free of unreasonable searches and seizures. The topic of today's conference, of course, is Meyer versus Nebraska. And welcome to all of you for attending, and thank you for being here. You know, the reason why we're having this conference is not because we think of Meyer as some type of historical curiosity that we happen to be interested in. We are very interested in its origins, but Meyer is a case that we as public interest lawyers use in almost all of our work, in particular in our work defending the right to earn a living and the right of parents to direct and control the upbringing and education of their children. But it really impacts all of the work that we do. We are inspired by its soaring rhetoric. We love the approach that it takes to the Constitution, including the recognition of unenumerated rights, which we're going to be talking about a lot today. We also like the fact that as litigators, it hasn't been overturned. It is still an active precedent. Its meaning and its import is still widely debated. We're going to be talking about that, of course, today, but it is a precedent that, even though it's 100 years old, has withstood the test of time. And as like so many important constitutional cases, it all started with one person, Robert Meyer, who stood up for his rights against then a rising tide of xenophobia that was sweeping the nation. And by standing up for his rights, in so doing, protected the rights of all Americans then and on into today. He sounds a lot like an IJ client, and if the Institute for Justice was around in 1923, we might have had the privilege of representing him like we do for so many other people who are fighting for their rights. We're really happy to have such a distinguished cast of scholars and practitioners with us here today to talk about Meyer and what it means for constitutional litigation today. And so I want to introduce to you Anthony Sanders, too. Anthony is really the fountainhead of this conference and somebody you're going to be hearing from throughout the day. And Anthony heads up IJ's Center for Judicial Engagement, a really important project of IJ that is dedicated to the kind of radical notion that judges should actually judge and that facts matter, and that the courts should not just reflexively defer to government officials, whether that is a federal bureaucrat, a city planner, a state prosecutor, or a cop on the beat. Anthony, as you'll be hearing about next month, and in May, actually has a new book coming out that is very appropriate for the discussion of today's topic and also what is happening in constitutional law at the Supreme Court, especially in the last year or so. It's called Baby Ninth Amendments: How Americans Embraced Unenumerated Rights and Why That Is Meaningful. So, Anthony, we look forward to hearing from you. We look forward to the publication of the book. And thanks to everybody for coming here today and joining us to discuss this seminal constitutional Supreme Court case. Thank you.
Well, thank you, Scott, for that introduction, and thank you, everyone, for coming today. A couple quick notes before we introduce our keynote speaker. I have very little to say. You'll hear from me at the end of the day, so I should be very brief right now. This event could not have been possible without a lot of people's help, but I especially want to name two people right now. One is our events manager, JoJo Tompkins, back there. JoJo has done incredible work bringing this together. The other is Erin Norgal, who is one of our artists at IJ, and she is responsible for this image that I have behind me here and that is on the screens of the children in the classroom. We asked her to come up with something that typifies this case, and she did that, and we said, okay, we got to do that now. One other note is we have a couple people, as often happens at conferences, at the last minute had a family emergency, something came up, they just couldn't make it. One is Julie Silverbrook, who was going to be a moderator for our second panel. The other is Professor Dale Carpenter, the man who taught me constitutional law over 20 years ago at the University of Minnesota, who was going to talk about free speech. So both of those parts, instead of them, will today be played by my colleague, Robert McNamara, who is going to moderate the one panel, and then he is a First Amendment lawyer, so it seems like he can slip into that role and give a few thoughts about free speech, will be on our third panel. But now, I'm very privileged to introduce to you our keynote speaker. I cannot think of a better person to be talking about Meyer versus Nebraska at a century than Professor William Ross. He is the Albert B. Brewer Professor of Law and Ethics at Samford University's Cumberland School of Law. He's the author of numerous books on different areas. Often they are on early 20th century constitutional history, but one of them especially is about this case. So he wrote the book on Meyer versus Nebraska. You often heard that term thrown around, but he literally wrote the book. And if you want to know more, after today, if you do nothing else, you should find this book at your local law library or get it through interlibrary loan. It's called Forging New Freedoms, published by University of Nebraska Press. It was published in 1994, and he did extensive archival research to put this together. You'll find on Lexis his earlier article that has a lot of the same material, but in the book, it really goes into detail on research for the background of Meyer, and that you'll hear about in just a moment, and also for Pierce versus Society of Sisters, a case we'll hear a lot about today, and even the third case in the trilogy of language cases, the Farrington case from Hawaii from 1927. As part of that research, he did interviews, and he even interviewed a man who was then in his 70s, but in 1920, when the county attorney walked into the classroom, Robert Meyer's classroom in rural Nebraska, was a man who then was 10 years old, Raymond Parport. And Raymond is actually mentioned in the opinion, in the Supreme Court's opinion, as the child who Meyer was speaking German to when the county attorney walked in, and Meyer continued speaking German, and thus later he was cited. So I'm very pleased to hear today that we have, for want of a better term, a bit of apostolic succession from that classroom to Raymond Parpart to then later when Professor Ross spoke to him in an interview and recollected what happened in the case, and then Professor Ross today speaking to all of us. So I'm very privileged to introduce to you Professor William Ross.
Well, thank you, Anthony, for that introduction, and very much appreciate the opportunity to speak today. I'm delighted that the Institute for Justice is marking this important occasion. Really deserves attention at the centennial, and we really should honor Mr. Meyer and all those who successfully fought the language laws. So Meyer versus Nebraska, one of the most important civil liberties decisions in American history, began in a one-room schoolhouse in rural Nebraska And when Robert Meyer, a Lutheran parochial school teacher, courageously defied a law that prohibited the teaching of German to elementary school children. This statute had its origins in the anti-German hysteria that swept the nation during the First World War. During the war, as most of you probably know, there were significant attacks on German ethnicity, which often found expression in efforts to suppress the German language. And so the governor of Iowa, for example, issued an edict banning any public expression of German whatsoever. And many states and localities repressed the speaking of German in various ways. The United States government decimated the German language press by refusing to give it mailing privileges on many occasions. And then in the wake of the First World War, there was the nation was swept by a recrudescence of nativism, which also found reflection in these laws that restricted or prohibited the teaching of foreign languages. So 23 states, shortly after the war, prohibited the teaching of foreign languages in schools, particularly German. And this had a particularly baneful effect on the numerous German-American Lutheran schools, because many of the Lutheran churches at that time still had services in German, and the German-American children were taught the catechism in German in preparation for their confirmations. So this had a severe impact upon the ability of these parochial schools to carry out their religious mission. And so it was that in Hamilton County, Nebraska, the county attorney found that the Zion Lutheran Church was defying the law by continuing to have German lessons. And so on May 25th, 1920, he entered Meyer's classroom. And he found Meyer teaching German to a dozen fifth grade students, including Raymond Parpert. And county attorney listened for a while, and then he went over to Raymond and asked him to read out of the German language book. And then he asked him to translate. And then, according to Parpert's recollection, he and Meyer had a long whispered conversation. He then seized the book, which he never returned, and left the classroom. Shortly after that, Meyer was convicted of violating the language law in local court and was fined $25. He appealed to the county court and lost there and took his case up to the U.S. Supreme Court. Now, Meyer knew that the county attorney didn't want to make trouble with the large and thriving and otherwise law-abiding German-American community. And so he knew that if he switched over to English, when the county attorney entered his classroom, the county attorney would leave him alone. And he later told his attorney, "I had my choice. I knew that I wouldn't prosecute me if I switched over to English, but I felt that I should not flinch, and I did not flinch. I went on in German." And he explained that he felt that he had the same duty as a pastor, to instruct the children in the language of their forefathers, so that they could learn their religion in the language of their ancestors. So Meyer refused to pay the fine. Raymond Parpert's father put up bail so he didn't have to go to jail. And the members of the congregation would have paid the fine for him, but again, he just absolutely refused. Now, I don't know exactly why, but I suspect that Meyer had to leave his job at the school because of controversy about his defiance of the law. Apparently, many members of the German community didn't want to make trouble, and Meyer's defiance of the law was somewhat controversial. And so he left that school a year later to take a job elsewhere, probably because of controversy within the congregation. And found this also in another case that Anthony mentioned in the introduction, the Hawaiian case. The territory of Hawaii enacted a law at approximately the same time that prohibited the teaching of Asian languages in schools. And when Asian American parents defied that law, some of them were ostracized by other members of the Asian American community for making trouble. And so often, persons who stand up for their rights are not honored even in their own communities. I had an example of this many years ago when a German attorney visited our school, and I thought he'd be pleased and proud to hear about the Meyer case. So I told him the story. And he was absolutely dumbfounded. I mean, he was so puzzled. And he said, well, I don't understand. The congregation was willing to pay the fine for him. Why didn't he just pay it and shut up? I mean, why would he take a case all the way to the U.S. Supreme Court over $25? And I think there you see an example of the difference of German political history and American political history. I just think that speaks volumes of the difference in the histories of the two countries. Meyer appealed his case to the Nebraska Supreme Court. And at the same time, there had been Lutheran parochial school teachers in Iowa and Ohio who had likewise defied laws in those states. And they too took their cases to the state Supreme Courts. They were just as courageous as Meyer, but Meyer was lucky enough to get his name on the caption of the case. So the other teachers are not nearly as well known, but probably no less courageous in their defiance of the laws in their states. For the schools that challenged these laws, this was really all about religion. Again, they wanted to teach the German language so that the children could prepare for their confirmations and participate in German language services. But they realized that that argument might not get very far with the state Supreme Courts. They relied on the state constitutions because, of course, at that time, the First Amendment had not yet been incorporated into the state law. That none of the provisions of the Bill of Rights had yet been incorporated into state law, and so they couldn't rely on the freedom of religion clause of the First Amendment. They had to rely on the state constitutions, which they did. They also, though, relied very heavily on a theory of property rights, recognizing that at this time in history, the courts were very protective of private property in cases involving government regulation. They argued that this violated the due process rights of the schools and the teachers and the parents, insofar as they deprived them of economic interests. The right of the teacher to pursue his occupation, the right of the parents to enter into a contract with the schools, and they also argued that these laws would diminish the economic value of the schools, insofar as it was less likely that parents would send their children to parochial school if the parochial schools did not provide instruction in the German language. All of these arguments lost at the state court level. All three of the states, Nebraska, Ohio, and Iowa, said that the schools had failed to present sufficient evidence that the economic value of the schools had been diminished by these laws. They also rejected, almost out of hand, the religion arguments, said that there was no reason why religion had to be taught in German. It could be taught just as easily in English. And all three of the states relied very heavily upon a theory of the police power, that the states had an interest in assimilating ethnic communities and inculcating patriotism in young children, which could better be done in the English language. So having lost at the state levels, these cases were all three appealed to the United States Supreme Court. The Supreme Court, in its decision in Meyer on June 4th, 1923, ruled, of course, in favor of Meyer. in sweeping language, said that the 14th Amendment's due process clause is not altogether clear, but it does denote the right to contract, the right to engage in the common occupations of life, the right to acquire useful knowledge, the right to marry, the right to have children and raise a family, the right to worship God according to the dictates of one's own conscience, and the right to engage in those occupations of life long recognized by the common law as essential to the happiness of free persons. And so Meyer's attorney, Arthur Mullen, rejoiced and said he felt like the father of septuplets. He'd asked the court for one liberty, the right to teach German, and the court had given him 7. And he described this as a fenceless land of freedom. Well, some people might want at least some fences, particularly if the Supreme Court's going to be the surveyor. But in any event, of course, the program today is going to discuss just how far these freedoms go and what they mean. Meyer is a strange decision in many ways because I probably could call it Janus-faced. In one way, it looks back to the old doctrine of economic due process. At least to some extent, it seems to be based on economic liberties, and yet at the same time, it looks forward, to the court's emerging role, as a guardian of non-economic, personal liberties. By the way, since I'm here at the Institute of Justice, I'd like to say what I always say to my classes: that very often, constitutional scholars distinguish between economic liberties and personal liberties, and I think one of the glories of the Meyer case is it recognizes the connection between the two. That economic liberties and personal liberties are in many ways one and the same. So I like to use the phrase non-economic personal liberty, to emphasize that economic liberties too are personal liberties. And so it's interesting that the court doesn't distinguish strictly between the economic liberties and the personal liberties. It links the right to contract, and the right to engage in the common occupations of life, which are economic liberties, places those together with the right to raise children, the right to worship, and so there's kind of this indivisible scheme of liberty that's enunciated by the court in Meyer versus Nebraska, which is so very important and has had such enormous consequences, as we'll see later today. So the decision was particularly important at the time, because there was a nationwide effort to repress non-public schools, and the court's decision was recognized by Arthur Mullen, a Roman Catholic layperson, as important in his efforts to try to stop states from enacting laws that would have essentially put parochial and secular private schools out of business. One of the most interesting aspects of the Meyer case is the why the court used such broad language. Where did this come from? The court could have relied on much narrower grounds. It could have treated this just as another economic due process case. It could have said that the liberty of the teacher, liberty of contract, liberty of the teacher, liberty of the parents, standard and contracts had been abridged. But instead, Justice McReynolds' opinion went much farther than it really needed to. And one of the issues that I explored in the book is why the court did this. And at the time that Meyer was decided, the court was under widespread attack by progressives and labor unions for its decisions, striking down economic regulatory legislation and restricting the rights of trade unions. And just 2 months before the Meyer case was decided, the United States Supreme Court, in the Adkins decision, had struck down a District of Columbia law that regulated the wages of women. And this decision created a firestorm of criticism. This was a classic, substantive, due process decision. This was in line, with the Lochner decision, and the Supreme Court in more recent years, had seemed to have become, somewhat more amenable to economic regulatory legislation. Seemed to have backed away at least a little bit, from economic due process. And then along came Adkins, and the court seemed to have returned with full force to its very strict scrutiny of economic regulatory legislation. So in the wake of Adkins, there were many proposals, many of which we're seeing today, for curtailment of the institutional powers of the Supreme Court. Senator LaFollette of Wisconsin, just the previous year, had introduced legislation to allow Congress to overturn Supreme Court decisions by a two-thirds vote. Senator Borah, just shortly before the Meyer decision was decided, had introduced legislation to require a 7-2 majority to strike down, for the Supreme Court to strike down any legislation, state or federal. The court, of course, as always, is very keenly aware that it has neither the power of the purse nor the power of the sword. My theory is that the breadth of the language in Meyer was partly a response to the criticism of the court at that time. I've earlier published a book about these attacks on the court during this period. What I've found is that defenders of judicial review, and particularly political conservatives, for lack of a better word, argued that the same power of the court to strike down economic regulatory legislation could be used to protect the most cherished non-economic personal liberties, particularly freedom of speech and freedom of religion. And yet the problem was there weren't any cases like that. So the defenses of the court are just replete with this argument that, the court can strike down a wages and hours a law, but the court can also protect your freedom of religion. But there weren't any cases. And then along comes Meyer. So finally there is a case in which the court actually does invoke the due process clause of the Fourth Amendment to protect non-economic personal liberties. And so I think that's part of the reason why the language of the court is so sweeping. I think in a way this is an answer to the critics of the court at the time. That raises another question, though. Why not simply incorporate the freedom of religion or freedom of speech or freedom of assembly provisions of the Bill of Rights at this time? And the court began to do that, curiously enough, just 2 years later. Just a week after the Pierce decision, the Supreme Court, for the first time, held that freedom of speech and freedom of the press apply to the states. So it looks like the court could have easily hastened that process by using Meyer as the occasion for incorporating at least freedom of religion and maybe freedom of speech and freedom of assembly into state law. And there really is no particular answer as to why the court didn't take that step. It obviously wasn't ready to do it yet. It wasn't ready for another 2 years. And I think part of it may be that the court did not, at a time when there was widespread fear of political radicalism, the court did not want to seem to give license to political radicals. It was safer to simply invoke the due process clause in the 14th Amendment in this case than to open the door to greater liberties of speech. Although of course the court was willing to do that just 2 years later. In any event, after the court began to incorporate the Bill of Rights into state law just 2 years later, the Bill of Rights became the primary basis for protection of non-economic personal liberties for another 40 years until the court began to incorporate, began to rely on substantive due process again as a protection of non-economic personal liberties. So the case again was important in terms of the growing effort to try to suppress parochial and secular private schools. And just a few months before the Meyer decision, the state of Oregon had enacted a law that required all children to attend public schools. And that law was challenged, of course, and led to Pierce versus Society of Sisters in 1925. And the Meyer case was cited heavily in the Pierce case. When the attorney for the plaintiffs in the Pierce case asked Chief Justice Taft if they could have more time to argue the case, he said, "Why? This is just Meyer all over again." So Pierce is better known than Meyer. I think part of that is because the facts are more dramatic. I mean, to require all children to attend public schools is a much more radical measure than to simply say that German can't be taught in schools. But the doctrinal foundation it was very much laid in the Meyer case, and so Meyer is obviously an important decision and one that as we'll see this afternoon, has been used in many different ways. It's cited in numerous Supreme Court cases, often in support of both the majority and dissenting opinion. One can find almost anything in Meyer, and again, its enduring legacy is the subject of today's conference. So I guess there's time for questions,
For our live streaming audience, we should use a microphone for questions. So if you show yourself to JoJo and get going.
Yes.
Hi, I'm David Wagner, Free Families Foundation. I'll be speaking later this afternoon. But I want to say that your judicial Janus article was one of the most important and helpful pieces that I encountered in my research. And you've done the deep dive, right, on not only the Nebraska arguments, but also the Supreme Court oral argument. Do I recall correctly that at one point Chief Justice Taft pressed Mr. Mullen on, are you asking us to find that the Free Exercise Clause applies to the states? And I'm wondering if you can address that, because my recollection is that Mr. Mullen didn't want to seem to be making too big an ask. On the other hand, he didn't want to divert the court in case it did want to go down that way. So just how did that cash out?
Yeah, Mullen actually did advocate incorporation of freedom of religion into state law in his argument before the Supreme Court. That argument was also raised in some of the briefs at the state level, but I think they knew that it was a losing argument. And as I think you suggest, maybe they were looking to the future. Mullen obviously hoped that freedom of religion would be incorporated along with other provisions of the Bill of Rights. So he in a way, even though he realized he probably wouldn't succeed, he at least wanted to raise the issue, if nothing else, to give it perhaps more legitimacy in hopes of eventually succeeding. Yeah. So you had a question over there? With your hand up? Yes.
Yeah, Eyal Moses, no affiliation. So I was wondering, was the law that was struck down in Meyer, was it a specifically anti-German law? Or, I mean, was it a law in general against foreign languages or specifically anti-German law?
Really both. Of the 23 state laws, some of them prohibited only the teaching of German, others prohibited the teaching of the foreign languages generally. So it was a combination of anti-German feelings and also kind of xenophobia and nativism as well. So different laws reflected different aspects of that. Yes.
Hi, Susan Lawrence. I want to thank you too for your extraordinary work on the history of Meyer. How did Mr. Meyer afford to get all the way to the Supreme Court? I mean, surely even in 1923, it cost more than $25 to get to Washington.
Right.
And
right.
I realize that, the $25 isn't why he was unwilling to pay it.
No.
But how did this
Yes,
is a
well,
question that always interests me. I've had a long history of interest in public interest litigation and how litigants actually get to the court.
Yeah. Meyer was a member of the Lutheran Church Missouri Synod, which was the largest German-American denomination, and it was very concerned, not only about these language laws, but also like the Roman Catholics and other religions that maintained parochial schools, very concerned about the growing anti-parochial and private school movement, and so it financed litigation for him. Yes.
In looking at the history of this again, I think this is right, but you will certainly know that Justice Sutherland was in dissent.
Yes.
Which seemed surprising,
Right.
given what he was doing with unenumerated rights and just kind of his general reaction toward this. But I don't think he wrote the opinion for it.
No.
Why do you think that is the case?
Well, Justice Sutherland joined Justice Holmes in dissent, and one of the I'm so glad you mentioned that, because one of the ironies of Meyer is that Justice McReynolds, the strong conservative, for lack of a better word, conservative, wrote the decision, and Justice Holmes, who's known as an icon of civil liberties, was in dissent. But McReynolds, of course, was a very strong opponent of economic regulatory legislation, and a very, I think, it had very strong libertarian tendencies, and so he was offended, by a law that interfered with property rights. And I think he was also offended by a law that interfered in this way with civil liberties. Justice Holmes, on the other hand, said in his dissent that he didn't agree with the law, but he nevertheless deferred to the legislature. So I think this is a classic example of Justice Holmes's philosophy of judicial restraint. And Sutherland also, I think, went along with Holmes partly out of a belief in judicial restraint, but also perhaps because of a fear that the court was expanding civil liberties farther than he'd like to see it go, particularly since that could have been used, and indeed was used, by political radicals at a later time. It was very easy for the court, in a way, to sustain the civil liberties of farming people, who represented no threat, to the social or political or economic order. The court was bolder, later on, in defending the rights of persons who did.
One other question about the oral argument that I learned from your book was there. Of course, we all know reading tea leaves of oral argument is a bit of a fool's errand, but it seemed like early on, it was very questionable which way the court would go, and that McReynolds really perked up when, I think it might have been Mullen, started talking about how this makes us more like Soviet Russia.
Yes.
And there was this
Right.
response to this, and of course this is very early in the Red Scare period. So how did that, those geopolitics maybe play into this in your opinion?
Yeah, well, I think that Justice McReynolds found this to be far too intrusive, and I think it did remind him of what the Soviets were doing at that time in interfering with families and personal liberties. Absolutely. So I mentioned my encounter with Mr. Parpert. I went to the Zion Lutheran Church in Hampton in 1990 to interview him, and I arranged the meeting through the pastor, and he rode to the church in a tractor. He was still farming at age 81, and he brought with him a man named Clarence Hyden, who had been a student at the other school. I'd never known this before, but Zion actually had two schools, and the teacher in the other school, started speaking in English as soon as the county attorney entered his classroom that day. He wasn't as bold as Meyer was, and so I asked Parpert, what the Meyer case meant to him, and he said it shows that the government, can't just make up any law it wants, to force people to do what they don't want to do. It shows how valuable our Constitution really is, and I think that's probably as good a summary of Meyer as I've ever heard, right there from Raymond himself. So.
Thank you. Todd Gotziena from Pacific Legal Foundation, and I have at least one other colleague here and hope a few others for this very, very fine conference. Your answer to Scott intrigued me. I want to hear a little bit more about Holmes's dissent. I'm going to read the entire opinion and some others that I don't know that I've ever read. I certainly am well aware of Holmes's judicial restraint or pro-democracy and economic liberties, but I would have thought this may have been a bridge too far. So did he draw no lines? Did he, in his dissent, hint how far could you go? What else does it say about Holmes? What else did he say in his dissent as to why this didn't cross the line?
One of the central issues in the case was the scope of the police power. To what extent can the state prohibit the teaching of foreign language in order to promote assimilation, and to encourage so-called American values, so the proponents of the law, claim that the German language, poisoned minds. That this corrupted children. They said that this is the language of the Kaiser, and of course the opponents of the law said, well, yeah, it's the language of the Kaiser, but it's also the language of Bach and Beethoven and Goethe and Schiller and Kant. In a way, this was kind of a balancing test. I think everyone agreed that the states could promote assimilation, but how far can the state go in doing that? And Holmes's dissent, I think, was fairly limited in that respect. He said that although he thought the laws were wrong-headed, he thought that people should be allowed to learn language at an early age. That the state nevertheless did have a legitimate interest in fostering so-called Americanization, and that this particular law did not go too far. Now, in the Pierce case, he was in the majority. So so I guess that answer, in a way, that's answered the question: what's the bridge too far? Well, shutting down the parochial schools as opposing to not allowing them to teach German.
Just to follow up, Bill, isn't it? He did mention that the Ohio law, right, which specifically spelled out German, was too far for him.
Yes.
Though he doesn't really say
Right.
why. Is that right?
Yeah. So the law that specifically prohibited German. Yes. So. Yeah, sure.
Sorry, not to, I guess, organizer's prerogative here. One other question that you talk about in your book, the kind of back and forth in several states, but especially Nebraska, of the legislature and the courts. And there was a first round that went to the Nebraska Supreme Court where they didn't use the state or federal constitution, but they kind of went out of their way to read the law to give the churches a little bit of wriggle room.
Yes.
But then it seems like they gave up after that. If you could tell a little bit about that.
Yeah, so actually, the Nebraska Supreme Court had already adjudicated the constitutionality of the law at the time that Meyer was prosecuted. And so immediately after the law was passed, the Missouri Senate challenged it, and the Nebraska Supreme Court sustained the constitutionality, but did so in a way that is essentially tried to allow the schools to continue teaching German by saying that the law only prohibited the teaching of German during regular school hours, thereby suggesting that the schools could teach German at some other time. And so many of the schools, including the Zion Church School, started teaching German during the recess period. The Zion Church extended the recess period by a half an hour, from 1 hour to 1 hour and a half, and then used that extra half hour to teach German. So they contended that they were technically within the law by doing that, and the county attorney disagreed, and ultimately the state Supreme Court, when the case came back to the court, said that that was just too clever by half, that that's not what it had meant originally, that this would have to be strictly outside of school hours as opposed to during the recess period, and so the court essentially revisited and expanded upon many of the issues that it had addressed originally. Is that so? Yes.
Hi, Jack Brown. I'm also from Pacific Legal Foundation. And reading the case, it always kind of struck me that teaching any kind of foreign language is a form of speech. It's occupational speech, but it is still a form of speech. So I was wondering if you had any insight into why, I guess, like a First Amendment argument didn't play more of a role in the case, or if you had any insight into that, that would be appreciated. Thank you.
Thank you. Yes, there was some discussion of free speech in some of the briefs presented to the the three state Supreme Courts, but the focus on non-economic personal liberties was primarily on religion because that's what the schools were primarily concerned about. But again, the schools emphasized their economic rights more than their non-economic personal rights, particularly religion, because they just thought that had probably get more traction. Turned out it didn't, but they thought it probably would, which made sense at a time when the court was striking down laws on the basis of economic due process and had not yet assumed its modern day role as the protector of liberties prescribed in the Bill of Rights. And again, it's a curiosity. We'll never know why the court it began to incorporate the Bill of Rights just a week after Pierce, when they had such a good opportunity to do it in both Pierce and Meyer. In fact, in a way, a better opportunity because both Pierce and Meyer did not involve political radicals, and of course, the Gitlow case did. The Gitlow, the case in which the court finally began to incorporate the Bill of Rights and involve the prosecution of a left-wing radical. So it seems like a strange occasion for beginning in the incorporation process when the court could have done it 2 years earlier. But for whatever reason, the court just wasn't ready yet. So. Thank you.
Right, well, let's thank our keynote speaker. We'll have a very short break, and then we'll be back on at the top of the hour.
My name is Renee Flaherty, and I'm a senior attorney at IJ. And I have the distinct pleasure of moderating our first panel of the day. And I'm joined by Professors David Bernstein and Kermit Roosevelt. Professor Bernstein is a professor at Antonin Scalia Law School, just right across the river, and a graduate of Penn Law. And Professor Roosevelt is a professor at Penn Law and a graduate of Yale. And I'm very excited for them to both bring their deep historical knowledge to bear on Meyer and the right to earn a living. And before I turn it over to our panelists, I want to make a confession. Until very recently, I didn't think of Meyer as a case about the right to earn a living. I thought of it in terms of, like Pierce, about the right to bring up your children. And until very recently, I didn't think of Meyer that way, but then I was litigating a case involving the right to earn a living right here in DC. And that case was a challenge to DC's new regulations that require daycare providers to get a college degree in order to continue caring for children. And so IJ challenged that law under substantive due process and equal protection in federal court. And we fought that case really hard for 5 years, going up to the DC Circuit twice. And unfortunately, we were ultimately dismissed. And so I was drafting this past fall a cert petition to the US Supreme Court. And I thought, well, since the Supreme Court has been emphasizing the importance of fundamental rights, I would reread Meyer and Pierce, thinking about the right to direct the upbringing of your children. And I was rereading Meyer, and I thought, well, this case is actually about the right to earn a living, the right of Meyer to teach German to earn his living. And so I was very surprised and delighted by that. And even though the court didn't take our case, it gives me hope that going forward in the future through cases like Meyer, the right to earn a living might have a kind of renaissance. And so I'm very excited to hear what Professor Bernstein and Professor Roosevelt might have to say about that. So I'll turn it over first to Professor Bernstein to speak for a bit, and then Professor Roosevelt, and then we can have some questions.
Thanks. The previous remarks made me think that someone needs to write a book about German Americans and the Constitution and the connection between Lochner and Meyer, that a lot of Germans involved in Lochner. The Bakers Union that supported the Hours Law in Lochner was a German-dominated union. Their union newspaper was published primarily in German. Lochner himself was a German immigrant from Bavaria. His lawyer, the lawyer for the head of the Bakers Union was Henry Weissman, who was also a German immigrant. And then Henry Weissman later went to law school, got fired from the Bakers Union for alleged corruption, and then became a lawyer at Brooklyn Law School and actually helped co-write the Supreme Court brief. And he later became the head of the largest German American organization in the United States, and there's a lot of articles from the New York Times, and early in World War I, he's sort of defending the German side before the U.S. entry. And it actually makes me wonder, I'm not sure when he died, I was trying to look it up on my phone before, I couldn't figure it out right away, whether he actually had something to say about the anti-German laws that were passed and Meyer versus Nebraska, just as a sort of interesting aside. So we already talked about how Meyer was a, in part, at least, a liberty of contract, economic liberty case, and not only in the sense that it talked about the right to earn a living, but that it has a long string cite to cases like Lochner and so forth, and the briefs rely on Lochner. And one question is, well, we know the court turned away from Lochner in the 1930s. How did Meyer versus Nebraska survive both the constitutional revolution of 37 and also the Warren Court? And the answer is that the court did so by reinterpreting Meyer and subsequent cases like Pierce v. Society of Sisters as not having anything to do with economic liberty. So in Caroline Products, footnote 4, in 1938, the court reinterpreted it along with Pierce v. Society of Sisters and Farragon versus Tokushige as cases involving, quote, review of statutes directed at particular religious or national or racial minorities, which certainly was true of the law. It just didn't play any role in the actual decision of the Supreme Court. Later in Griswold versus Connecticut, Justice Douglas reinterpreted the cases once again, this time as cases involving the right to privacy, which I don't think anyone even knew existed in 1923 and certainly wasn't mentioned in the case. So it turns out that despite the fact that Meyer was in that line of cases that was reinterpreted, and then the Legal Academy played its own role in this regard. Now, Gerald Gunther had the most popular constitutional law case book in the 1970s and 60s, and after Griswold, and then again after Roe, he purposely put Lochner, and then Meyer, and then Griswold, and then later Roe, just to show how he's the old progressive, they're all in the same boat, and we should get rid of all of them. But then if you go to, and he said this in a letter to Randy Barnett, that's why I know he did this on purpose. But then if you get to Lawrence Tribe's 1978 constitutional law treatise, he has separate chapters in the treatise on economic liberty and non-economic liberty. He just sort of arbitrarily decides that Meyer and Pierce go in the other categories. We could keep them as good precedents for cases like Roe without actually understanding that they really did have a basis in the same sort of police powers jurisprudence as Lochner. Another interesting point about the case is that while Justice Holmes dissented in Meyer, his ally on most matters due process, Justice Brandeis, actually joined the majority opinion. And the standard explanation for this is that Justice Brandeis felt that, well, I would normally not vote for this because I don't like the due process clause, or for that matter, he wasn't a big fan of the 14th Amendment in general, but that if the court's going to protect economic liberty of the sort I don't like, I do like sort of freedom of conscience as shown in his First Amendment cases, so I'm going to vote this way. I don't know, I'm speculating here, but I came across a very intriguing biographical detail of Justice Brandeis. His parents were German-speaking immigrants from what would now be Czechoslovakia, and his father, the Czech Republic, sorry, to show my age. His father was actually the founder of a German-language school in Louisville, Kentucky, that Justice Brandeis himself attended as a child. And you have to think that Justice Brandeis would have been especially offended by the notion that somehow un-American to be going to a German language school, since that's exactly what he attended. Contrary-wise, Justice McReynolds, very interesting, I found an interesting biographical detail about him. Justice McReynolds was a man of many prejudices, and one of them was that he hated Germans. And nevertheless, he voted in favor of Meyer, and actually wrote the opinion, which I guess shows that he was able to overcome his prejudices, at least at times, in favor of what he thought was the right answer, legally speaking. Other progressives who are not on the Supreme Court, people like Learned Hand and Felix Frankfurter, said, yeah, this law is kind of stupid, but we're good progressives. We think the legislature should be able to do whatever we want, which was the progressive position at that time, and they opposed Meyer on that grounds. And years later, someone asked Felix Frankfurter about when he was on the Supreme Court. He still said he thought that Meyer versus Nebraska was wrong. This is part of why Frankfurter went down in history as being a conservative, because by then opposition to substantive due process was considered conservative, but he just sort of still remained an old progressive. In the first session, it was remarked upon that the court was under political attack at the time, and there is an obscure article from the 1960s by a political scientist who suggests that one reason why the court was forthcoming in Meyer was that they wanted new allies among various immigrant and ethnic and religious minorities to help stop this anti-court movement. And he hasn't really provided any evidence other than this is the political climate of the time and it makes sense. But I would say, if nothing else, that one of the real important factors of Meyer historically is that whether that was on the court's mind or not, because of cases like Meyer and Pierce and some subsequent cases in the early 1930s, by the 1930s, the court was seen as a protector of individual rights of minorities. And as a result, when Roosevelt proposed his court packing plan in 1937, that there were actually opposition from Catholics and Jews and African Americans who thought, well, the court is actually serving this role, and but for the shift from Meyer on, that might not have been the case. But what I really want to talk about more than anything today is the way that Meyer reflects a shift in constitutional jurisprudence with regard to the police powers that have dramatic effects that continue to this day. Meyer marked one of the first and almost certainly the most important time that the Supreme Court held that a law could be invalid under the Due Process Clause as a violation of liberty rights, even if the state asserted a valid police power interest in the law. So the first case that did this was actually Buchanan versus Warley in 1917, which was a case involving a law requiring private housing segregation in Louisville. And when that case came up to the Supreme Court, and it was part of a wave of segregation laws throughout the border states and some southern states at the time, the laws were very popular. They were upheld almost everywhere, and public, legal opinion was that they should obviously be upheld either because segregation is a reasonable exercise of the police power, some would say on racial grounds, but then also we should allow the government to experiment with different kinds of economic modalities. That's what our opposition to Lochner is all about, that we should allow for this sort of experimentation. But when the case got to the Supreme Court, Kentucky filed this really extensive brief on the rationales for segregation, and they talked about public health, they talked about property values, they talked about preventing racial conflict, and there were a series of race riots in the United States around this time, and they talked about preventing interracial marriage, which the Supreme Court had already held was within the police power by upholding laws banning interracial marriage. And the Supreme Court, very interestingly, didn't deny that at least some of these rationales for the law were within the police power. Yes, you can protect property values. Yes, interracial conflict is a problem, but they said you can't address those issues under the police power in a way that interferes with the fundamental rights of American citizens, in this case to buy and sell property, both as a property right and a contract right. And this was really a new thing. As much as we think of Lochner as being the epicenter of this aggressive judicial review, the Supreme Court in Lochner recognized quite explicitly, even though Justice Peckham, probably the most libertarian justice on economic issues on the court, wrote the opinion, said, yes, if this law was within the police power, if it were really a health law, we would uphold it. But it turns out that the connection to public health is extremely remote, and that neither common sense nor the data that we've been presented by the plaintiffs, by our friend Henry Weissman, who I'm sure wrote that part of the brief about the health effects of baking, neither of those things tell us that baking needs to be regulated. Contrary-wise, 3 years later, in Mueller versus Oregon, the Supreme Court says, you know what, common sense tells us that women have different physical capabilities than men, and we're going to uphold an hours law on that basis. And even if we didn't know that from common sense, Louis Brandeis has also submitted this brief with all this data, and surely a reasonable legislature could rely on that sort of data. So historians, including me, have pointed out that the Lochner era was really pretty tame to the extent that it invalidated laws under the Due Process Clause through 1917 or so, because as long as the government was asserting a valid police power, the court would then defer. Now, once we get to Meyer, before Meyer, then we have Adkins versus Children's Hospital. And in Adkins, the court had a variety of reasons for saying a minimum wage law for women was unconstitutional, but more importantly, for my purposes, they also said that freedom of contract is the general rule and restraint the exception, and abridgments of freedom of contract could only be justified by the existence of exceptional circumstances. Now, exceptional circumstances is quite much a more limiting factor than just saying anything that comes within the police power to protect the public health, the welfare, etc. So this is a fairly radical rhetoric from the court in 1923, which brings us to Meyer versus Nebraska. Now, Meyer versus Nebraska, the state asserted what might seem on the surface to be some pretty important police power reasons. They said we have a large foreign-speaking population in the United States. I think in 1923, we had more or less the largest percentage of immigrants as a percentage of the American population of any time until basically right now. They move in foreign cultures. They are immersed in foreign ideas. There was this very prominent notion in during World War I and thereafter that the problem with the world is that ideas like communism and later fascism are being imported to the United States in part by immigrants, and we want to assimilate them into Anglo-American culture, but in a way that would be a little bit more sympathetic sounding than just assimilation, because we want to preserve Anglo-American liberty. The Anglo-American people have this long tradition of individual liberty and skepticism of government power that is just not shared by people coming here from places like Poland or Lithuania or Belarus, which that happens to be where my great-grandparents came from. So I'm alluding to that, which is, to some extent actually true. That their culture did not, have these things. They were under the dominion of the Tsar, who wasn't exactly a classical liberal. So interestingly enough, the Supreme Court didn't say, oh, that's just nativism, that's just, racist, or whatever you would say today. They said, yeah, those are actually valid valid issues, something that the government should be worried about people being educated properly in Anglo-American liberty. But you can't do it in a way that violates people's fundamental rights. Now, when the Supreme Court talked about fundamental rights in 1923, I should hesitate to add, they weren't talking about fundamental rights the way we learned about them in constitutional law, which is that, fundamental rights is a buzzword, which means that strict scrutiny is applied, the government has to satisfy a compelling interest test. That comes much later. But the idea, though, that there are such a thing as fundamental rights that we recognize as a court, and that we don't just say when those fundamental rights are involved, yes, but anytime the state attaches a police power rationale, and the police power rationale seems plausible, we're going to uphold the law. The fact that they said that from now on, when something that we deem fundamental to Anglo-American liberty is involved, that we're going to be very skeptical of such legislation and not allow it to infringe on fundamental rights was really important. And I think that, this case has gotten the least attention of sort of the trilogy, but Farrington versus Tokushige from 1927 is really indicative that they really meant this, because that law banned Japanese language schools in Hawaii. So first of all, Hawaii is a federal territory. The Japanese population is not eligible for citizenship if they were born or brought under current law. So you could easily have seen this as just coming within the immigration power of the federal territorial government, which is a federal government, right? That to the extent we have these immigrants, we have to, and worse yet, as far as if you were a plaintiff in this case, unlike the German language schools, which were really purely American in origin, the Japanese language schools were actually, in fact, sponsored by the Japanese government to try to help Japanese subjects, because they didn't recognize, they said, once you're Japanese, you're always Japanese, even if you become an American, to actually promote loyalty to the emperor. So this was actually, if you ever think that the court would say, okay, there are real interests involved by the government here that are going to overcome the right that we recognized in Meyer and Pierce, they would have said so, but still 9-0 in favor of the Japanese plaintiff. So we could see a few things relevant here, one of which is that 1923 was probably not, there was definitely some reaction to World War I and the suppression of various liberties, economic and otherwise, at the time, which probably helped lead the court to a more radical opinion. But the fact that Lochner, as we call it, like the Lochner live due process cases, had gone from, well, as long as you have a valid police power rationale, we're going to uphold the law, to, hey, liberty of contract is the rule and you have to have exceptional circumstances, meant that it was more vulnerable to attack by the 1930s. So on the one hand, this may have actually undermined economic liberty to some extent. The other thing is that the court's greater protection for economic liberty in cases like Buchanan and Meyer and Atkins versus Children's Hospital, by recognizing this notion that the police power is not the be-all and end-all, and that rights could be protected even when the government does assert a valid police power interest, set the stage for modern liberal jurisprudence. They got rid of the economic liberty part. They artificially separated the economic part from the personal liberties, but without that change, you don't really get, I think, things like incorporation of the First Amendment or cases like Griswold. So that's my remarks. I look forward to seeing what Kim has to say.
Thank you.
Thanks. So thanks first to the Center for Judicial Engagement and the Institute for Justice for hosting this. Happy to be here. Thanks to all of you for coming, and thank you for the introduction, and thank you to David for very interesting remarks. I think I agree in large part with what David said, and I'm actually going to cover some of the same ground. I disagree maybe on some things. I mean, I've talked to David about these topics for years, and I've learned a lot, and my views have changed. I don't know if his views have changed. But anyway, as I was preparing my remarks for this conference, a quote came to mind from Frederick Douglass, which is, "We have to do with the past only as we can make it useful to the present and the future." And I was thinking about that, actually, because I was doing a debate with someone else about whether the 1787 Constitution was pro or anti-slavery, and Frederick Douglass is relevant to that, and I thought the quote was relevant to that. But I also thought it was relevant to this conference, because here we are celebrating the 100th anniversary of Meyer v. Nebraska, and of course there's a reason that we've chosen Meyer. Maybe I shouldn't say we, because I'm not one of the organizers of the conference, so I might have a different view, actually, about why Meyer is worth celebrating. And that's sort of the theme of my remarks. So one of the things that I do with my constitutional law students as we work through the cases that we read is we'll talk about the case at a relatively superficial level, just so they can sort of understand what the court said and what it did. And then I'll ask them, and how do you think this case is perceived in the legal academy or the legal world more broadly? And for some cases, that's a pretty easy question. The students know what people think about Brown or Loving, or on the other side, Plessy and Korematsu. But then there are some cases that are harder. Marbury, for instance. The students often don't know what to make of Marbury, just reading it. And they're a little bit more puzzled because I tell them it's a terrible decision also, which I can explain later if you're interested. And I also have to admit, I tell them also, right, the Supreme Court thinks this is a great decision, which shows you that sometimes the Supreme Court is wrong. And Lochner puzzles them too. And what I end up telling them about Lochner basically is, I do think Lochner is a bad decision, but not for the reasons that many people say. And some people think it's a good decision. And someone actually wrote a whole book called Rehabilitating Lochner, which is a great book, and I tell them they should read it, right after they read my books. And I guess I should add Anthony's book. There's a lot of books I want my students to read. So there are some cases that are good or bad, and the legal community agrees on that, and we also agree on why. And this is maybe a smaller category of cases than I thought, because Brown, which is what I would have put at the center, it turns out the meaning of Brown is now contested. Everyone still agrees Brown is good, but there's a strong disagreement about what Brown actually stands for now. And then there's some cases where we agree on the meaning, but we disagree about whether they're good or bad, and maybe Lopez, some of the Supreme Court's recent federalism decisions would fall in that category. And then there are some cases where people agree that they're good, but don't agree about why. And I think that Meyer is such a case. So I don't know of any constituency, any group in the legal world that's against Meyer. If you're having your conference celebrating Meyer, everyone will be like, yes, that's a good decision, it should be celebrated. But I think that different people like it for different reasons. Different people would choose to celebrate it for different reasons. And it's great, I think, that the conference has different panels on different aspects of the decision, because it's very important to understand what those different aspects are and why they appeal to different groups. And the divide that I'm concerned with now, which I think is most appropriate for this panel, is between people, you could call them progressives, who like Meyer because they think of it as a forerunner of other cases about the right to make decisions free from governmental interference, cases like Griswold and Roe and Casey. And progressives want to say those cases are very different from Lochner. And then there are other people, who you could call libertarians, maybe, who like Meyer because they think it's part and parcel of an approach to judicial review that is more engaged on economic issues, in particular, than current rational basis review is, and they think it's similar to Lochner. So what that means for progressives, at least, is that Meyer is a bit of a challenge because they want to endorse Meyer, but they don't want to endorse Lochner. And a celebration of Meyer is sort of like the banquet in Macbeth, where the specter of Lochner is lurking there, like Banquo's ghost. My daughter is in high school, and they just read Macbeth, and she wrote an essay about it. So I been thinking about Macbeth along with Frederick Douglass. So progressives have sort of mixed feelings about Meyer, maybe, in almost the same way they have mixed feelings about Mueller v. Oregon, where progressives liked the deference to economic regulation, but they didn't like the language about women. In my experience teaching Mueller over the past 20 years, I feel that it's sliding into the anti-canon. I find it harder to present it to the students without getting the reaction that it's really based on these creepy ideas about the vigor of the race and the governmental interest in supervising women's reproductive capacity. But setting Mueller aside, what do we think about Meyer? I thought I would focus on the challenge that progressives face, which is how can you say that Meyer is right but Lochner is wrong? Well, I think there are several different arguments you could make for that point, depending on which elements of the decision that you focus on. And I was going to try to give you some of those different ways and tell you which one I think is more persuasive, and then try to wrap up with some concluding remarks. So first question, like, what is the test the court is applying? In both cases, the court gives you a pretty standard formulation, I would say, of Lochner-era police power jurisprudence. So in Meyer, the court says liberty may not be interfered with under the guise of protecting the public interest by legislative action which is arbitrary or without reasonable relation to some purpose within the competency of the state to effect. And in Lochner, the court describes the question as, is this a fair, reasonable, and appropriate exercise of the police power of the state, or is it an unreasonable, unnecessary, and arbitrary interference with the right of the individual to his personal liberty? And I agree actually with David that there's also language in Meyer that suggests that there's some heightened significance being given to the right that's asserted, so that maybe something like an ordinary police power justification isn't enough. And I'm not sure that the court really has that well theorized. But in the language that I just quoted to you, at least, it sounds like they're just asking, is there a police power justification? And this is not the question that the court would ask now, right? This is not the question, does a fundamental right exist, in the sense that it's going to determine the level of scrutiny, in the sense that Roe and Dobbs ask that question. So the question here, based on the language that I quoted, is just whether the law is within the police power. And the court answers it the same way in both cases. It says, no, there is not a reasonable relation to a legitimate purpose. Now, reasonable relation to a legitimate purpose, that formulation doesn't quite capture what's going on, I think, and it's maybe misleading, particularly to a modern audience, because translating doctrine across different eras of Supreme Court decision-making is difficult. What the court says there sounds like modern rational basis review, and that seems to be, I think, how Justice Holmes understands it, because Holmes dissents in both cases. And he says the question here in both cases is really just, could a reasonable person believe what the legislature claims to believe? And in both cases, he says yes. And I think he's actually right about that. Doesn't show that the court is wrong, but it shows that something else is going on in the majority opinions. So the court is reviewing the legislative judgment more skeptically than modern rational basis review would tell it to. So then the question is, are there differences between this underlying similarity, beneath this underlying similarity, that might support more skeptical review in Meyer, but not Lochner? So the conventional answer, the modern answer, is, well, we're not really asking about the limits of police power, we're asking about the strength of the individual's interest. That is, does the individual have a fundamental right, and there is a fundamental personal right to direct the education of your child, but not a fundamental economic right to liberty of contract. And maybe there are some justifications for that. Other people will say there isn't a meaningful difference between economic rights and personal rights, because economic liberty is very important to human flourishing. It's essential to personhood and making your way in the world and finding meaning in life and all of the things that someone like Anthony Kennedy says in Casey about non-economic liberties. And I actually agree with that in terms of the importance of the individual interest. I think maybe there is a case to be made that economic and non-economic rights should be treated differently because there's typically a greater ability to find substitutes with economic rights, and there's typically less reason to worry about prejudice. But that line of reasoning is actually going into a different justification that I'm going to try to give later. So for now, on this point, I'm just going to say the superficial formal distinction between economic and non-economic rights that modern analysis endorses, or maybe I should say modern progressive analysis, because I'm not sure the current Supreme Court buys that anymore. That distinction needs more elaboration if it's going to be persuasive. So another way to approach the question would be to say, even if we are applying the same test that the court does, should the cases come out differently? And I think if you look at the evidence in support of the legislative judgment, there are different things to say in Meyer and Lochner. So what's the harm that the New York legislature is trying to avert in Lochner? If you take them at their word, they're trying to protect the health of bakers. And there is scientific evidence to support their judgment. Justice Harlan's dissent invokes this treatise on the diseases of the workers that makes baking sound terribly dangerous. And there's something else he cites about how bakers inhale flour dust and are pasty and pale-faced. So it sounds like something's going on there. And what's happening in Meyer? Well, the opinion discusses some different justifications for the state regulation, but the main one is to promote civic development by inhibiting training and education of the immature in foreign tongues and ideals before they could learn English and acquire American ideals. It is also affirmed that the foreign-born population is very large, that certain communities commonly use foreign words, follow foreign leaders, move in a foreign atmosphere, and that children are thereby hindered from becoming citizens of the most useful type, and the public safety is imperiled. So the public safety is imperiled, civic development is hindered. Those are bad things, sure, but is there a treatise explaining how learning German contributes to that? No. And it's hard to imagine one. Also, it's hard to imagine the data that would support that claim, which is to say the Lochner statute is based on factual claims for which there is some basis, and the Meyer statute is based more on value claims for which evidence is going to be hard to come by. And I think it makes some sense to say that courts could be more skeptical of claims that we can't really imagine being verified or falsified than of claims that are susceptible to factual confirmation or disconfirmation. And this is not quite the difference between economic and personal rights, but I think maybe it gets you some distance towards that distinction, because often when legislatures are restricting what we think of as non-economic personal rights, they're doing so based on value claims rather than fact claims. So that's what it looks like if you take the legislature at its word. I think you could draw a distinction there that gets you some distance towards where progressives want to go. But in both cases, the court was also not prepared to quite take the legislature at its word. So in Lochner, there's an explicit invocation of the idea of pretext. The court says it is impossible for us to shut our eyes to the fact that many laws of this character, while passed under what is claimed to be the police power for the purpose of protecting the public health or welfare, are in reality passed from other motives. In Meyer, it's a little bit more subtle, but the court mentions unfortunate experiences during the late war and aversion toward every characteristic of truculent adversaries. So in each case, the court thinks that while the legislature is putting forward these legitimate goals, as of course it always will, there's also some illegitimate purpose at work. And what are these illegitimate purposes? Well, in Meyer, as we've heard, it's anti-German animus. It's hostility, prejudice against a group based on their national origin. What is it in Lochner? It's a desire to respond to an imbalance of bargaining power. It's the belief, as the Harlan dissent puts it, that employers and employees in such establishments were not upon an equal footing. And the legislature is trying to respond to that, in essence, by putting them on an equal footing, or giving the outcome you would have gotten if they were on an equal footing, redistributing bargaining power, you could say. So if we think that those purportedly illegitimate motivations are different, we might distinguish between Meyer and Lochner on that ground. And I do think they're different. So Meyer is saying hostility based on national origin is bad. And I agree with that. And Lochner, as I read it, and I think maybe I do differ with David on this, but Lochner, as I read it, is saying redistribution based on nothing more than a desire to promote equality is bad. And I don't agree with that. But I should say, in Lochner's defense, I think this idea comes from the Declaration of Independence via Justice Chase's opinion in Calder v. Bull. And the idea is people create governments to secure their rights. That's what comes from the Declaration. And therefore, they wouldn't give the government the power to arbitrarily interfere with those rights, which seems reasonable. And thus, that an act of the legislature that purports to do so is a mere act and not a law, and hence can't be dignified with the name due process of law, which is how you get substantive limits out of the due process clause. And that's some language from Calder. It's also some language from Dred Scott, which people probably don't want to rely on as much. And then the last step, redistribution in the name of equality, is the sort of arbitrary interference that no one creating a government would give it the power to do. So I follow that argument basically up to the last step, right? I agree, arbitrary interference with rights is bad, but I don't think that redistribution to promote equality is arbitrary. And I think that does set me against the Declaration of Independence and the vision of the founders, but I think it aligns me with the Gettysburg Address and the vision of Reconstruction. And if you have to pick a side there, and I think you sort of do, this is the theme of the book that I tell my students to read right before Rehabilitating Lochner. If you have to pick a side, I'm happy being on the Reconstruction side rather than the founding side. So the second point, my second point there, is we can distinguish between the two decisions in terms of what counts as an illegitimate purpose, and in particular, the question of whether it's legitimate for the government to act to promote equality. So if you say that's what's going on in Lochner, but it's okay, then there's no justification for heightened scrutiny as a means of smoking out this impermissible purpose, because it's not an impermissible purpose. And in Meyer, by contrast, if we say, we think the law is motivated by hostility against a minority subject to prejudice, and that justifies heightened scrutiny, then we're in very familiar territory. As David said, we're in Caroline Products footnote 4 territory. And Caroline Products does, as you've heard, cite Meyer as an example of a law targeting a national group, and it cites Pierce as an example of a law targeting a religious group. And this is why I said I think that the attempt to distinguish personal from economic rights bleeds into the justifications I was going to get to later. I think what the analysis of personal versus economic rights is really getting at is a set of factors that tell you when judicial review should be deferential and when it should be non-deferential. And the strength of the individual's interest is not the most important of those factors. So I think that concerns about prejudice, the ability of the individual to find a substitute for the prohibited behavior or exit from the targeted group, and an analysis of the political process, and a look at whether there's a history of discrimination, all of those are more important. And those are the factors that you get from something like a Caroline Products analysis rather than modern fundamental rights jurisprudence. And that is especially true if your fundamental rights jurisprudence says define the right narrowly and look at history and tradition, because if you look at the history of a group that has been subjected to discrimination, like women, for instance, you will, of course, find that they didn't have a lot of rights when you look at the history. So the history and tradition approach to the 14th Amendment, what did people think in 1868? Well, we know that the drafters of the 14th Amendment explicitly sort of endorsed the denial of the right to vote for women, which we would now find shocking and unconstitutional. And it's not 1868, but it's 1873. That gives you Bradwell against Illinois, where Justice Bradley, concurring, upholding an Illinois law excluding women from the practice of law, writes that the paramount destiny and mission of woman are to fulfill the noble and benign offices of wife and mother. So I'm ending with this point because if we're talking about unenumerated rights, I think maybe this is on people's minds. Roe is another ghost at the banquet, you could say. I taught Dobbs relatively recently in my constitutional law class, and I'm not a fan of that decision. So one thing that I think the analysis I was sketching here maybe suggests is Meyer could be a guidepost to rehabilitating something, not Lochner necessarily, but substantive due process. Because if we understand the sin of Lochner as unjustified judicial second-guessing of a legislative assessment of the public interest, which is basically how I understand it, then looking at things that make that second-guessing justified in Meyer could give us a theory about when judges can strike laws down as violations of the Due Process Clause without committing the sin of Lochner. And that kind of analysis might actually lead you to the conclusion that non-deferential review is justified in Roe and Casey, which is it would lead you towards something more like an equality-based argument for abortion rights. So I'll end there. I hope you found that interesting, and now I guess we'll have some discussion.
Thank you both so much for your remarks, and we've got lots of time for questions, so I'll use my prerogative as moderator to ask the first. What do you think that moving forward, courts will be inclined to kind of break down that distinction between economic and non-economic rights, or is that just trying to read the tea leaves?
I think actually it's Anthony has this very interesting article about about economic rights in the states after. Tell me if I'm getting the argument wrong here, but basically until 1973, state courts that were dominated by more conservative judges were still applying something more like a Lochner kind of standard to economic regulations that were challenged under state constitutions. And then they stopped doing that. And the question is, why did they stop doing that? And the year 1973 should be the hint, because then the Supreme Court decided Roe, and Roe was considered a substantive due process case like Lochner. And how could you defend, if you want to attack Roe, you have to also, at least it was seen at the time, attack Lochner. So all of a sudden, all these conservative judges in the state level who had been in favor of some level of non-deferential review of economic regulations stopped doing that. On the other hand, if you go back to the late 70s, to Lawrence Tribe and Leonard Levy and a bunch of other people, there was actually some movement on the left to say, we went too far in separating economic rights from personal rights, and things like occupational licensing are often overbroad, and they hurt people who don't speak English well, and people who have the skills but not the education. There's special interest kind of legislation. And Jimmy Carter, of course, was the most deregulatory president that we've had because for some of these same reasons. But then once conservatives started to regain power of the judiciary with Reagan, I think there was a shift. Oh my God, if we say anything nice about economic liberty and there are crazy people like Richard Epstein and Bernie Siegel running around, we're sort of inviting a revival of the kind of economic liberty that we don't like. So the liberals abandoned that too. All of which is to say that I think the complete abandonment of review of economic rights was a product of particular historical political factors which are now fading into oblivion, but most likely, to the extent that such rights are revived, they won't be, history rhymes but doesn't repeat, so they'll be revived in areas like First Amendment. So we have this whole literature, people complaining about First Amendment Lochnerism, which I think is a misnomer, but they're getting to something real, which is that the court's not going to go back to the Due Process Clause that's over to bring back economic rights, but they might be more sympathetic to economic rights that are in the guise of or at least are brought to the court under other constitutional provisions, whether it be the First Amendment with regard to occupational speech, which IJ is taking the lead on, or saying that a baker doesn't have to bake the cake not because he has the economic right to decide, but because of religious freedom.
So I would say if you're trying to predict the future direction of case law, you can think about it either doctrinally or politically. And thinking about it politically often has more explanatory power, I think. So the distinction between economic and non-economic rights never made sense doctrinally to me. I mean, it's something that courts just sort of said, but if you look at the questions that they were asking to determine whether a particular right was fundamental, under the sort of Casey sweet mystery of life approach, there's no necessary distinction there between economic and non-economic rights. The court managed to do it somehow anyway, I guess for political reasons, and I would defer to David on his assessment of the political climate and the political factors at work. So if Dobbs really means what it says, and now we switch to a narrowly focused history and tradition analysis, well, again, I think there's no doctrinal reason to distinguish between economic and non-economic rights. I'm not sure what the history and tradition analysis would look like, because there are cases, and Lochner is one, talking about the traditions of liberty of contract. There are also a bunch of cases where that argument was made and was rejected by the Supreme Court, like Slaughterhouse. So I don't know what the court would do with that history. Doctrinally, I think it's sort of unclear, which means probably the political factors will end up driving it. And I'm just not sure how that calculus is going to play out.
Questions from the audience? Get a microphone.
Hi, thank you. Zachary Schnapp of Berger Harris. So, Professor Roosevelt, it sounds like you're suggesting that, and to borrow from Professor Ross's term the last session, non-economic individual liberties are generally considered jurisprudentially and or politically on the vector of personal or maybe moral values. Can you just explore that a little bit further, please?
Yeah, so if you look at some of the cases, and this is not true of all of the cases, and I think abortion is maybe meaningfully different from other cases, but if you look at, say, sexual orientation cases, and you ask what's the justification that the government is putting forward for restricting individual liberty, I don't think that there's ever been much of a meaningful clash of experts on the question of does the government have a valid concern about public health. So for whatever reason, debates about the government's justification in cases like Lawrence and Romer and Obergefell even tend to take place more in the realm of values. And what happens there is that you've got a national consensus on one side, usually, where the state's justification seems like common sense and it's widely accepted. And when that's the situation, you get a decision like Bowers v. Hardwick, where the court, without very much investigation, is just like, yes, we agree with the government. But then typically a social movement will arise to challenge that consensus. And if the social movement succeeds, then national attitudes shift, and that's reflected in judicial decision-making, and you get to a moment like the moment in Lawrence where Justice Breyer is asking the Texas lawyer, do you have anything other than morality that you can offer in support of this law? And they could have tried to make a scientific argument, and if it had been a different kind of issue, maybe they would have. But the lawyer actually didn't say anything else. He was like, no, this is just morality. And at a certain point, and it does totally depend on shifting national sentiment, I think, at a certain point the court is going to say morality is not enough. So I think that there's a difference there in the kinds of justifications that the government puts forward. And with respect to the non-economic personal rights, you get social movements driving changed outcomes in ways that you don't with respect to economic rights.
Thanks. Nigel Ashford, Institute for Humane Studies, George Mason University. I should make it clear I'm a political scientist and not a lawyer. Professor Roosevelt tried to argue that, sorry, that's an unfair way of putting it. He argued, that we should make a sharp distinction between economic and non-economic liberties. I want to ask David, did he find those arguments compelling? And if not, why not?
Okay, well, I am actually going to make a very controversial argument right now that I've never said in print or I think in public, so you get to hear it, which is that I would actually say that if you're going to ask me, does the government, could I justify the government having a greater interest in regulating morals issues or the government regulating economics? That if anything, morals issues are more, first of all, just historically speaking, more clearly within the police power. More important, when it comes to economic activity, the public interest and self-interest tend to be pretty much aligned, right? That if you do economically stupid things, you will lose money, and everyone will become poor if everyone does that. But to the extent that one engages in economically efficient behavior, that makes a person wealthier and also society wealthier. And then if the government, and if we assume that markets work pretty well, the government interfering in that process is not likely to go well. On the other hand, when it comes to morals issues, if you think about any given issue where the government regulates morals, be it sexual activity or drug use, or a whole bunch of other things, one's personal interest may very well be, yes, I would like to have sexual intercourse with as many people of the opposite sex as I can. I would like to be able to divorce without any big legal process or consequences. I would like to be able to get high and I have enough money in my trust fund or whatever, or I'm a college student, I don't really care. But to the extent those things undermine a public culture of morality, that winds up affecting other people who have fewer resources and so forth, and they don't really have a choice in the fact that the culture has gotten bad. So if I'm not a social conservative, but if I were, I'd say if I'm a young woman now who wants a traditional kind of courtship and marriage and no sexual activity before marriage, I want to be pretty sure my husband's going to stay with me for a really long time unless there's a really good reason not to, or forever really. That's, culture, that you could have done that 50 years ago pretty easily, 60 years ago. Now, not so easy. So so if anything, I'm a libertarian, I'm still a libertarian, so I think government tends to be incompetent about these things. And I think that's maybe where, if I was going to try, from my perspective, to save Kim's idea, I say maybe the government, maybe because social issues are so complicated and so personal, that the government and there's so little data really about what will be good for culture and what will be bad, that the government will be especially incompetent about doing that. It'll be really hard to measure whether the government's being competent or not. Where with regard to economic rights, we may have actual data about antitrust violations or about workers in particular industries being subject to dangerous conditions, and maybe that would justify it. But the general, I've always found it interesting that the general presumption of modern jurisprudence has been that it's obviously the government should get involved in economics because people don't know what they're doing with, people have so much ignorance about economics, but with culture, well, people know. Your 15-year-old is deciding whether you use pot or not. Do you really trust that your 15-year-old knows what they're doing? But your 15-year-old is actually pretty good at negotiating if someone asks them to babysit, how much they're going to get paid, right? So I actually think, like I said, that the presumption at least would be the opposite.
Oh, well, I'd just like to say, I'm not trying to draw a sharp distinction between economic and non-economic rights. I was trying more to sort of explore that distinction because I think it doesn't really hold up. I think we need a better theory about why some cases should come out one way and other cases come out the other way. So what I was saying really was, I think you can distinguish Meyer and Lochner, but I don't think that economic versus non-economic is the right way to do it. And I'd like to focus more on sort of the quality of the government's justification and the quality of decision-making you can expect from the government in particular contexts, which is why I would think about things like prejudice in the political process. So what I was suggesting was we can get some of the same results, but maybe not all of them, right? Because maybe some of the results the court has been getting are wrong. And like the burdensome licensing restrictions, I am concerned about those and the burdens on people who don't speak English that we were hearing about before. So I think some issues with economic rights can get fit into the category of we don't trust the government to make this decision accurately. And that's sort of what I was trying to reorient it around.
Thank you again. David Wagner, Free Families Foundation. My question is mainly for Camilla. First, I want to say to David, whose book was very important to my paper and whom I interact with on Twitter sometimes. Welcome to social conservatism. That's how it starts. And my own thing, the Free Families Foundation, will sort of be social conservative libertarian, and I'll be fleshing that out hopefully in months and years to come. My main question is for Professor Roosevelt. I thought I heard in the speech a distinction between founding constitutionalism and Reconstruction constitutionalism. And I wonder if you could cash that out a little bit more, particularly with regard to this. I always have understood, maybe wrongly, that Reconstruction constitutionalism has clearly a strong anti-slavery flavor to it, but then you can make a very short bridge between that and the free labor values that are clearly at play in Lochner. And yes, no, maybe.
So I think free labor, yes. The distinction, or the issues where I see a distinction between founding constitutionalism and Reconstruction constitutionalism are more inclusion versus exclusion and individualism versus equality. So if you look at the Declaration of Independence and you ask, what's the view of outsiders? It seems to me there's a view of outsiders as threats to the lives of the colonists. So it talks about Hessian mercenaries, it talks about Native Americans, it talks about enslaved people who are being incited to rebel. All of them are going to kill the colonists. So that's a danger, and the colonists have to unite against these dangerous outsiders. And if you look at the 1787 Constitution, what does it say about inclusion and exclusion? Well, not that much explicitly, right, about who can become a citizen, but if you believe 7 justices in Dred Scott, it says black people can't become U.S. citizens. So founding constitutionalism, I think, is pretty exclusive. And then I think it's also individualistic in the sense that I described before, which is the idea is the purpose of government is to protect the rights of the people who form it, and that means you can't take from one person to give to another because we all get together and we create this government to protect our rights. We wouldn't give it the power to violate our rights just to benefit other people. And then Reconstruction, I think, kind of gives you the opposite perspective on both those issues. With regard to inclusion and exclusion, it gives you birthright citizenship in the 14th Amendment. So even if the states want to exclude the formerly enslaved from their political community, which of course they do, they have to accept black people as full and equal citizens. And then with respect to redistribution, I think the 14th Amendment, the 13th Amendment, uncompensated emancipation is really a very striking example of redistribution in the name of equality, redistribution from insiders to people who used to be, at least, outsiders, which is something that the Declaration, I think, the theory of the Declaration kind of condemns.
One last question.
Hi, thank you for a great discussion. Julia Mahoney, University of Virginia School of Law. I wonder if you can say a bit more about the future of equal protection. I was struck that, as Renee noted, you included an equal protection claim in your recent litigation concerning the District of Columbia daycare provider regulation. And Professor Roosevelt mentioned equal protection in the Dobbs opinions, and to me, the equal protection clause was analyzed and underwritten in the Dobbs opinions, and I would love to hear more about where you think things might be going with respect to the equal protection clause.
That's a really great question. What I tell my students is that before the New Deal, the Equal Protection Clause was you can't arbitrarily classify people, but the government classifies people all the time. So we don't think that race, by the way, is inherently arbitrary classification. So we really don't do much with the Equal Protection Clause. It's only when you're taxing Jim at 10% and taxing Joe at 30%, and you can't really explain why. That's just, if you don't have an explanation, it's arbitrary. But when Caroline Products comes down the pike, and other cases in the late 1930s, the court, there had been a huge amount of progressive hostility to the Equal Protection Clause because it was occasionally used to invalidate things like taxation. And Justice Brandeis even privately said he wishes that the Equal Protection Clause would be repealed entirely because it's even more mischievous than the Due Process Clause. But by the late 1930s, again, the court now, to some extent, sees itself as the protector of minority groups, sees that as a base, and the fact, someone needs to write the article on this. There are hints of it in other people's work, but the effect of the rise of the Nazis on American liberalism and progressivism, because progressive ideas in law in the United States primarily came from Germany and people who had studied in Germany, and it has to be the case that people noticed that things weren't going, and very anti-natural rights, very anti-individual rights. People had to notice that this wasn't working out so well in Germany. There are some hints of that. So in any event, after that, the Supreme Court said, we don't want to get rid of the Equal Protection Clause entirely, but we also don't want to willy-nilly be invalidating things as arbitrary. So we'll pick out particular classifications in particular race where we believe that this is so inherently arbitrary. There's a strong presumption of arbitrariness. And then from race, they added alienage, and they added something that's not a big issue today, but illegitimacy as intermediate scrutiny, and eventually they came up with a compromise for women and sex classifications, which is also intermediate scrutiny, although they almost did strict scrutiny. And since then, there has not been this was in the early 70s, has not been a single new suspect classification involved, but the court does sometimes say that, laws that seem to be hostile to gay people or to the mentally disabled or a bunch of other classifications, even hippies in a famous case, Marino, from the early 70s, are unconstitutional. So what they've really done, I tell my students, is they say, well, this is animus. But what does this mean, animus? There's nothing, why is the classification of animus problematic? I think ultimately what I've come to, this is my novel, maybe my next article, is that what animus means is the government has not expressed a legitimate government interest. What used to have been called the legitimate police power interest, now we'll just call it legitimate government interest. If the only reason that you're stopping this home for the mentally disabled from being in your neighborhood is because you're afraid of them for no good reason, that's not a legitimate government interest. So I think this idea of non-legitimate government interest in the guise of animus or otherwise with a conservative court is where equal protection is going. If somehow liberals took control of the court for the first time in however many, it's already been 5 decades, I think clearly they would be inclined to say that group like sexual orientation, mental disability, and a whole bunch of other things are also, age perhaps, also gets something above rational basis scrutiny. But we've been in this netherworld where we want some sorts of arbitrary classifications to be unconstitutional without changing the 3-tiered scrutiny system, and I think that it's sort of incompatible, but they've just sort of done a mishmash, and eventually but I tell the students the 3-tiered thing is really a lot less potent than you give it credit for, because we just, again, even though we've recognized all sorts of new groups as being subject to arbitrary discrimination, we haven't added a single one to the beyond rational basis since 73 or so.
Just briefly, so I think the interesting question for equal protection going forward is how the embrace of history and tradition affects it. So we see that in due process with Dobbs, and we're seeing it with the Second Amendment in, I think, a somewhat surprising way in Bruin, and we're seeing it in Establishment Clause cases. So what happens if you say our approach to equal protection is guided by history and tradition? I think what that gets you is basically the Scalia dissent in VMI, for instance, where you look at what was being done in 1868 and you say, if this kind of discrimination was considered acceptable then, it can't become unconstitutional as time goes by because our analysis is guided by tradition. And that is something that some justices, obviously Scalia and VMI, have said about the Equal Protection Clause before. It's not the way the Equal Protection Clause has worked, particularly in cases that people like Brown, like Lovin. And I think the barrier to the court adopting this approach right now is that they want to be anti-classificationist with respect to race. And so they're not actually that interested in looking at the history of the Equal Protection Clause because it's harder to justify colorblindness as practiced in 1868. And so it would be a barrier to striking down affirmative action. But who knows, once that happens, and it might happen soon, you might see history and tradition playing a more prominent role in other areas of equal protection. And they might move to something like that, because Scalia, for instance, seemed to be able to say, on the one hand, if schools were segregated in 1868, that can't become unconstitutional, right, when he's talking about sex, and somehow think that's consistent with his view that Brown is correctly decided. So you might end up with some kind of differential treatment for racial discrimination where there's like colorblindness, that's what we say, and then other kinds of discrimination where you do get this history and tradition analysis that looks back to 1868, which would have the effect, I think, of licensing a lot of discrimination that wouldn't now be allowed.
And just to elaborate on that, I mean, it does go all the way back to the slaughterhouse cases, where when the equal protection was raised there, they said we can't imagine any case not involving the freed slaves and their descendants that would come within the equal protection clause. There is actually some tradition of the idea that race is treated differently than everything else.
So I'll defer to Anthony and Jojo about whether we have time for a couple more questions, because I saw a couple more hands, but. Sounds good. Thank you both so much.
Thank you. So.
Okay. Welcome back, everyone. I'm Bob McNamara. I'm the Deputy Director of Litigation here at the Institute for Justice. This is the first of my appearances as a substandard substitute for the person who's actually in your program. But I am happy to be here moderating our panel on the right to marry, establish a home, and bring up children. I expect some fireworks. I expect some ad hominem attacks, some cheap debaters' tricks. This is going to be a fiery panel. So immediately to my left is Dean Susan Lawrence, who is an associate professor of political science and the current interim executive dean at the Rutgers University School of Arts and Sciences Office of Undergraduate Education. She is the author of the award-winning book, The Poor in Court, the Legal Services Program in Supreme Court Decision Making, publishes widely in a variety of other areas. Immediately to her left, we're joined by David M. Wagner, who taught constitutional and administrative law at Regent Law School for 16 years. Outside of that, has worked as a speechwriter at the Department of Justice, counsel to a House subcommittee, and as assistant legal counsel at the EEOC. And last, but certainly not least, is Michael Bindus, a senior attorney at the Institute for Justice, who leads our educational choice team, which helps design constitutionally sound educational choice programs and then defend those programs in courtrooms nationwide. Most recently, perhaps most prominently, Michael successfully argued for the petitioners in Carson v. Macon, but he continues to litigate in federal and state courts nationwide in defense of individual rights. With that, I am going to remove myself from the show and turn the floor over to Dean Lawrence.
Thank you. Do you want me to use the podium?
Wherever you want. You can sit, you can stand.
I want to thank you for the invitation and the opportunity to revisit a work I published in 2006 called Substantive Due Process and Parental Rights from Meyer versus Nebraska to Troxel versus Granville. And in that article, I traced all of the Supreme Court citation of Meyer up through 2005. And here I have updated Meyer's use by the Supreme Court up through the present, which brings us to 122 citations in majority, dissenting, and concurring opinions. Obviously, Meyer and the cases it cited have had a much farther reaching impact in the state and lower federal courts, but I confined my analysis to the Supreme Court. So notwithstanding, as we've heard this morning, notwithstanding the current view of Meyer in the Supreme Court's reasoning in 1923, there wasn't really a right to marry, establish a home, or bring up children at stake. There was no parent litigant in that case. It was really just about the right of Mr. Meyer to teach German. So unsurprisingly then, this Lochner-era case was largely used to uphold the right to earn a livelihood before the demise of Lochner and West Coast Hotel versus Parrish in 1937. Out of the 16 cases citing Meyer before 1937, only 3 of them involved something besides right to earn a living, public school economic rights, or private school economic rights. And those were 3 unsuccessful freedom of speech cases. This was, as was mentioned, before incorporation of the First Amendment. Things obviously changed markedly after 1937. The court never relied on Meyer to find a denial of the right to pursue a livelihood or professional calling again. It's been cited 106 times after 1937, and this is when Myers first found a place in the pantheon of revered civil liberties cases through the Justice Stone's use of it in the famous Caroline footnote, as Kermit talked about earlier today. And it was cited for the protection of national minorities. I will trace Meyer's use as key in the court's post-Lochner substantive due process jurisprudence and suggest that Meyer's substantive due process is likely at risk. At the same time, we need to expand the analysis in parental rights cases to include consideration of children's liberty interest. So Meyer was first cited in a dozen school cases after 1937, most notably in Wisconsin versus Yoder, where Chief Justice Berger's reasoning focused more on the Amish parents' right to direct the religious upbringing of their children
than on a direct parental right to direct the education of children. Hence, under Wisconsin, it's not clear that parents enjoy a right to trump the educational choices of the state, absent an additional constitutional liberty claim. Indeed, nearly all the Myers cases involving schools, the court's decision rests heavily on other First Amendment claims. Tinker versus Des Moines, freedom of speech protection, Runyon versus McCary in 1976, where the court held that Meyer and any parental right that it protects does not shield private schools from a Section 1981-based prohibition on racial discrimination in the admission of students. Meyer has also been read broadly to protect a number of parental rights not associated with the education of offspring. Beginning in 1972, the court invoked Meyer in a set of cases that involved procedural due process rights of parents, generally in the context of unwed fathers or of the rights of parents to act in their child's interest or on their child's behalf. One particularly interesting case involved a biological father who had, in fact, taken on much of the roles and duties of fatherhood, but was not able to garner 5 votes to protect his claimed parental liberty interest and visitation rights. In Michael H. versus Gerald D. in 1989, the court upheld a California statute which presumes a married woman's husband is the father of her children. In Justice Scalia's plurality opinion, Meyer is cited only for the proposition that the term liberty in the Due Process Clause extends beyond freedom from physical restraint, as he warns of the dangers of the judicial discretion this would unleash. In contrast, Justice Brennan's dissenting opinion cites Myers in response to Scalia's rejection of the, albeit adulterous, biological father's liberty claim as not an interest traditionally protected by our society, noting that we confront an interest, that of the parent and child in their relationship with each other, that was among the first that the court acknowledged in its cases defining the liberty protected by the Constitution. Now, this reveals what we already know, right? That this return to looking at history, tradition, depends upon how you frame the question. So, since it was framed as an adulterous father's right rather than a biological father's right, Scalia could reject it. In 2000, the Supreme Court decided Troxell versus Granville, and the court, arguably for the first time, was squarely faced with the question of the scope of parents' constitutional right to control the upbringing of their children, separate from any other substantive or procedural constitutional claims. Meyer versus Nebraska was not merely cited in Troxell, it was relied on as the foundational precedent, and the court invoked the Blackstone-Kent presumption that parents act in the best interest of their children. Briefly, Tommy Granville and Brad Troxell shared a relationship that resulted in 2 daughters, Natalie and Isabel. Under Washington state law, when Tommy and Brad broke up in 1991, the 2 parents agreed to and filed a parenting plan that provided that the girls would spend every other weekend with Brad Troxell, who was living at his parents', the girls' grandparents' home. In May 1993, Brad committed suicide. Disagreements about visitation arose, and the grandparents sought a court order allowing visitation under a Washington statute that provided that the court may order visitation rights for any person when visitation may serve the best interest of the child, whether or not there's been any change of circumstances. A fractured U.S. Supreme Court affirmed the judgment of the Washington Supreme Court, overturning the trial court's visitation order. Justice O'Connor's plurality opinion openly and directly accepted substantive due process, and citing Meyer and his prodigy, insisted that it cannot now be doubted that the Due Process Clause protects the fundamental right of parents to make decisions concerning the care and custody of their children. The most intriguing part of the Troxell decision, to my mind, are the 2 dissenting opinions that reference the interest of the child. It's worth noting that as far as the legal record shows, nobody represented Natalie or Isabel's interest as individuals in the litigation. There was no guardian ad litem appointed for them. Justice Stevens, in dissent, noted that it seems to me extremely likely that to the extent parents and families have a fundamental liberty interest in preserving such intimate relationships, so too do the children have these interests, and so too must their interests be balanced in the equation. Justice Kennedy, also writing in dissent, said, cases are sure to arise in which a third party, by acting in a caregiving role over a significant period of time, has developed a relationship with a child which is not necessarily subject to absolute parental veto. Those relationships can be so enduring that in certain circumstances where a child has enjoyed a substantial relationship with a third person, arbitrarily depriving the child of that relationship could cause severe psychological harm. States may be entitled to employ a best interest standard to avoid such harm. However, it won't surprise you to hear that the Supreme Court has not taken up the invitation to view these family disputes through the eyes of the children involved. And perhaps that's not surprising, since custody, visitation, and parental rights are generally resolved in state courts. Troxel did play a key role in a 2002 failed petition for writ of certiorari in Roughton versus Roughton. In this case, the North Carolina courts denied a divorced mother all custody and visitation rights to her child under a statute that required the child judge to make a finding of fact that the parent is an unfit person or that such visitation rights are not in the best interest of the child. The court awarded the father custody and granted the mother no visitation rights without an actual finding that the mother was unfit. Now, petitioner's brief reported that the state courts of last resort are split on the issue of whether a finding of unfitness is required to deny a parent visitation. A lengthy appendix classifies 12 states as using a judicial best interest of the child standard, 17 states as using an actual harm the child rule, and 11 states as requiring a finding of unfitness. There are not bright lines separating these three categories, and some of these classifications are arguable. But none of the quoted passages from the state high courts provide a fulsome definition of fitness, nor set a standard of evidence. It's not clear that unfitness and harm are any better defined than best interest. A review of the trial court record in Roughton versus Roughton shows the fuzziness of these terms. While the trial judge only invoked the best interest criteria, the record very clearly demonstrates that all was not well between the mother and the 12-year-old daughter, and that the daughter had become increasingly emotional and distraught when living with her mother. The 4-year-old son was ill-supervised, and there were numerous other causes for concern. A case of harm to the children could have easily been made, and perhaps even a finding of unfitness. But do we want to force the courts into making such dramatic and possibly irreversible findings? Findings that would also likely prohibit the custodial parent from allowing some non-mandated visitation, as the trial court did here. And again, there's no evidence that a guardian ad litem was appointed for the children, although the daughter was in counseling and a psychiatric evaluation of the mother had been ordered. So I wonder if we can keep the legal presumption that parents act in their children's best interest while also acknowledging that, in fact, some parents don't. According to the CDC, at least 1 in 7 children have experienced child abuse or neglect in the past year, and that year was 1999, so it was pre-COVID. And that's statistics from just the United States. And it's likely an underestimate because many cases are unreported. In 2020, 1,750 children died of abuse and neglect in the United States. The total lifetime economic burden associated with child abuse and neglect was about $592 billion in 2018. This rivals the cost of other high-profile public health problems such as heart disease and diabetes. Of course, this is fraught because we know that rates of child abuse and neglect are higher for families with low socioeconomic status, families that are vulnerable, and unsupported in a host of ways. And we also know that the state is not always able or willing to provide any alternate placements, and perhaps a better solution would be to address the precarious economic status of these families. Now let me turn to the ways that Meyer has been used to protect rights related to families that go well beyond parental rights. It's here we see the threat to Meyer. In the 1960s and beyond, the Supreme Court frequently returned to Meyer in recognizing a general right to marital and sexual privacy. In 1967, the court invoked Meyer to remind the states that their power to regulate marriage was limited by the 14th Amendment in Loving versus Virginia, striking down Virginia's anti-miscegenation laws. Meyer was also used in support of broader claims about the fundamental importance of the marital relationship in cases such as Bodie versus Connecticut and Zloblacki versus Red Hail. A general right to privacy in family relationships grounded in Meyer was recognized in cases striking down a mandatory employment termination provision for pregnant teachers and a zoning ordinance that prohibited two cousins from living with their common grandmother. In 2003, the court invoked Meyer in perhaps its broadest substantive due process decision since the days of Lochner. In Lawrence versus Texas, the court announced a liberty right of autonomy in intimate physical relationships, including homosexual relationships, tracing its lineage to Meyer versus Nebraska, and also relying heavily on Meyer's precedential descendants in the reproductive rights area. And in 2015, in Obergefell versus Hodges, this court extended this to hold that same-sex couples have a fundamental right to marry, citing Meyer. So one of the most ironic uses of Meyer's as a parental rights case has been in the reproductive rights cases, which in fact have been about the right not to reproduce, the liberty to not bring up children. In Roe versus Wade, Blackmun cited a long list of cases that protected personal privacy, but Meyer was the only one that rested on the 14th Amendment substantive due process protection of liberty. The court's subsequent abortion rights cases, it continued to reference Meyer in support of a constitutionally protected right to privacy in areas somehow related to the decision on whether or not to bear and beget a child. In 4 abortion cases, though, Meyer was invoked regarding parental rights qua parents. These are cases that challenged parental notification and consent requirements as applied to an unmarried minor. In all but one of the cases, HL versus Matheson, the court found such regulations unconstitutional unless they also provided an alternative procedure. In Matheson, writing for the dissent, Justice Marshall noted that Meyer and his prodigy sought to shield the family from state interference, whereas here it was used to insert the state into the family. Of course, writing last year in Dobbs versus Jackson, Justice Alito criticized and overturned the court's decision in Roe versus Wade. He rejected the precedential import of the substantive due process line of cases involving matters such as intimate sexual relations, contraception, and marriage, and argued that abortion is fundamentally different because it destroys fetal life. He seemed to exempt cases like Meyer and Pierce as involving personal decisions very far afield from the one protected in Roe. The court invoked Washington versus Glucksberg in holding that substantive due process only extends to those liberties deeply rooted in the nation's history and tradition and implicit in an ordered scheme of liberty, concluding that they do not include the right to abortion. So what does this mean for substantive due process and parental rights? Justice Thomas continues to argue that the court has no basis upon which to protect unenumerated rights. Under the Glucksberg-Dobbs standard of limiting substantive due process to rights deeply rooted and fundamental to an ordered scheme of liberty, some parental rights may continue to be protected if they can be linked to the family of 1791 or 1868, or some other constitutional right. It's worth noting that there are many rights claims that have deep historical roots that have at times been considered fundamental to an order scheme of liberty that perhaps we should not embrace, and ones that perhaps we should that we have not. Recall Justice Scalia's refusal to recognize a deeply rooted parental right of an adulterous biological father in Michael H. Can Loving versus Virginia, Lawrence versus Texas, and Ogerfeld versus Hodges be sustained under the Glucksberg-Dobbs standard of review? Justices Breyer, Sotomayor, and Kagan are quite doubtful. And if not those cases, why in any of the other cases that rely on Myers? Can we give up substantive due process and rely on other constitutional provisions to protect the same set of rights? One might wonder why custody and visitation rules and other parental rights cannot be trusted to the democratic process. Parents are hardly a discrete and insular minority. Why can't we rely on the democratic processes and procedural due process guarantees to protect parental rights claims from intrusion by the state? Why shouldn't parental rights claims be determined at the level of the state? Is it time to recognize constitutionally protected liberty interest of children as well as of parents? Oh, that seems quite unlikely with the current court. Now, let me be clear, I am a parent, and I do not want my parenting decisions surveilled by the state. But I also want our children to live in a country in which parents are able to care for their children and act in their best interest, and one in which parents are held accountable for their children's welfare. One that doesn't let Joshua DeShaney suffer such severe brain damage at the hands and feet of his biological father that he's left profoundly mentally disabled and institutionalized for the rest of his life. One in which there is help and hope for the 1 in 7 children who experience child abuse, and one in which every child learns to read, write, and calculate to function in modern society, whether that's achieved in public or private or religious schools. I don't have any easy answers here. One of the things that intrigues me with this is how many things are in tension here. There are no easy answers here. But today's parents are yesterday's children, and their behavior reflects how they were raised, and today's children are tomorrow's parents, and will pass those traits on as well. I want to suggest that we should treat the child with the dignity and respect we would want from her as an adult citizen of our democratic polity. So, thank you.
Thank you very, very much, and thank you to IJ for inviting me. I think I'm here because I have written in the past about Meyer and Pierce. One of my first outings there was an attempt to trace the way it's been permuted in later cases, but my achievement there was nothing Susan's is the reference article there. More recently, I've written about whether these cases support a constitutional right to homeschool, and on that, well, my answer was a definite maybe, but hold that thought, I'll come back to it. Yes, I taught for a long time at Regent Law. Now I'm sort of in a limbo between that and retirement, and I'm starting this thing called the Free Families Foundation. But I'm not here to do a commercial for that, but I want to be able to say this conference helped to get off the ground. And at the same time, I'm teaching part-time at a school that exemplifies Meyer Pierce values, Holy Family Academy in Manassas, Virginia. I'm grateful to them for the day off. This would normally be a teaching day for me. There I teach American history and Aristotle's Nicomachean ethics to middle schoolers. If you want to look it up, you certainly can. It's Holy Family Academy in Manassas, not to be confused with Holy Family Parish School in Woodbridge, same county, different institutions. All right, so this thing about the constitutional right to homeschool. It's not about whether the Meyer Pierce holdings concerning parents are broad enough, to coin the phrase, to cover such a right, because I think it's clear they're not. But whether their actual holdings neither broadened nor narrowed by subsequent liquidation might do so. My tentative conclusion was that, and still is, that yes, they might if one views teaching as a profession and if due process offers some protection to freedom of professional judgment in common occupations of life. So let me just fess up to a couple of my priors here. I think teaching is a profession. maybe more controversially, though I hope not, but if it is, okay. Barriers to entry into a profession are per se problematic, frequently odious, and as a con law matter, they tread on thin ice. And IJ has been in the forefront here. Now, some barriers to professional entry have too solid a history and tradition basis to be seriously questioned as a con law matter. I mean, think of Lincoln's career, there were, after all, informal bar examinations even before there were formal ones. Medical licensing has a pretty firm foundation in tradition and in common sense. The Middle Ages had guilds, which had their pluses and minuses, etc. But there are also absurd barriers to professional entry out there, as IJ's book of business attests. Renee talked to us briefly about her work on the college degree requirement for daycare centers in DC. And then there are barriers to entry whose constitutionality is also undermined by their intrusion into other constitutional rights, including, yes, parental rights, except that Meyer and Pierce are at most only secondarily and derivatively about parental rights. Susan is right that they are really not parental rights cases, at least in the first instance. So their real payload here comes in their teaching on professional freedom and common occupations of life. This was not a new concept when Meyer was decided. As Michael has pointed out, the right to pursue a lawful calling had also been important in a Florida state court decision in 1916, striking down a law that prohibited whites from teaching blacks in public schools. Now, this was clearly a common occupation of life, professional freedom kind of decision. It's not that the Supreme Court, or this one, the Supreme Court, this is a Florida intermediate court, but it's not as though an intermediate court in the Deep South in 1916 was a panel of civil rights activists. You know, it was. Here we see Lochner constitutionalism advancing a civil rights value. Okay, so reading Meyer and Pierce in this way, and by that I mean as freedom of profession cases in the Lochner tradition, this has the advantage of meeting them on their own terms. It has the disadvantage, if such it be, of requiring a more benign look at Lochner than has been the custom for about 80 or 90 years. In that time, most everybody on planet con law, first liberals and then conservatives, have more or less taken anti-Lochnerism as their point of departure. Okay, I'm going to talk a little more about barriers to entry. One barrier to entry is teacher certification. The assumption is far-flung and spreading, even in diocesan schools. I'm sorry to say, my school is not an official diocesan school, that no one should be allowed near a student without an ed school degree or at least a certificate. Like all barriers to entry, this one has a good commercial, assuring competence by teachers. It also has the effect, purely accidental, I'm sure, of protecting the present in-group from new competition. Some would also argue, though I'm not taking it up today, that it serves ideologies and agendas. I mean, perish the thought that the education establishment should have any such, or use this power to promote them. Actually, Michael's Yale Law Journal Forum article has plenty on this. I'll refer you to that. Meyer does indeed note that education requires organized schools, and, as the opinion itself says, especially qualified teachers. But it prefaces this with practically, meaning, I think, not almost, as we tend to use the word practically today, but I think it's mainly a circumstantial observation, one that doesn't cabin the holding. My article in 2014 in the Oklahoma City University Law Review goes into some details about the practical side of American schooling as seen in decided cases in the states before Meyer. And I believe I showed there that some forms of homeschooling are indeed deeply rooted in our history and tradition. And also that when public schools became available, many parents and courts viewed them as a sort of smorgasbord service provider, such that parents, as educational decision makers, could take all or just some of it. It's a bit like that Liberty Insurance commercial, only pay for what you need, except in this case, only send your kids for what you think they need. So I think the concept of parents as teachers is not novel. In fact, it's probably deeply rooted in our nation's history and traditions. The product of researching this issue for me is that I came away with a much improved opinion of Lochner. such an improved position, in fact, that I wondered how I had gotten there. I did not quite end up at the position of, yeah, unenumerated rights, Ninth Amendment is judicial empowerment, let's go. But I did notice that the rights protected in the tradition we're talking about, the slaughterhouse dissents, Allgaier, Lochner, Meyer, and Pierce, had a better grounding in our legal history and traditions than either New Deal liberalism or 1980s conservatism would concede. So yes, Meyer and also Pierce are Lochner cases. So then what about the judicial revolution of 1937? Well, for one thing, I follow Barry Cushman here in believing that there's been a lot of myth-making about that. I refer you to his book, Rethinking the New Deal Court, but for one thing, there was no switch in time that saved 9. We know now, we have the memo traffic, that Justice Owen Roberts was planning to uphold the statute in West Coast Hotel before the court-packing plan was announced. More relevantly here, in 1944, the court decided Prince v. Massachusetts. If we call this just Prince, just remember it's with the usual spelling, C-E, it's not Prince T-Z, the 11th Amendment case. Prince v. Massachusetts, 1944. If there was ever a fact pattern that exemplified hybrid rights, as the court would later describe them in Employment Division v. Smith, this was it. You had a religious motivation, and the free exercise had already been incorporated against the states 4 years earlier in Cantwell. Plus, the person acting the act was in loco parentis to the kids, so parents' rights should have carried it even if free exercise didn't. Well, the court upheld the labor law in this case, the one that the aunt had violated in having her kids distribute religious literature, and it upheld it against both those objections, the free exercise and the parents' rights theory. But even as it did so, it dropped a dictum that has since been much quoted. In fact, the dictum may have overtaken the holding. They said, and you all know this, quote, "It is cardinal with us that the custody, care, and nurture of the child reside first in the parents, whose primary function and freedom include preparation for obligations that the state can neither supply nor hinder." So this was the court's signal, or it became such, that Meyer and Pierce would not be flushed away, as Adkins was explicitly, while Allgaier and Lochner entered into disfavor, while not explicitly overruled. Well, from here, the history took Meyer and Pierce in new and, I would argue, unlooked-for directions, but that's not really my topic here. I want to refocus on the cases themselves, especially Meyer, since that's our centennial boy. I hope we'll be back here in 2 years to celebrate Pierce. So back to those two now famously non-overruled cases since Prince. Okay, Professor Ross, well, what I got from Professor Ross's article and from his speech, or maybe slightly different from this, maybe I was misinterpreting one or the other. The theory that Meyer was the first case to use substantive due process for personal rather than business interests. Now, I don't want to, Professor Ross's presentation this morning kind of brought these back together again. My humble submission here is that the implied dichotomy is easily overstated, and that the Meyer court did not see it, and that the interest of a corporation, okay, in conducting its business, or a language teacher in doing his job, or the interest of a hair braider in doing her job, or the interest of a daycare worker in DC in doing his or her job, and the interest of parents in doing their job, as described in Pierce, all differ in appearance but not in legal valence. Judge Jeffrey Sutton, commenting on Justice Frankfurter's position in Gobitis and Barnett, of course he writes Gobitis and then it's overruled and he dissents in Barnett, his position was one very much in the radical judicial restraint school. He was of Thayer. And Judge Sutton writes, that is Frankfurter, was rightly skeptical of the idea that constitutional rights could be fairly divided into economic and liberty rights, close quote. And on that I'll agree with Frankfurter, noting that his dissent in Barnett relied heavily on Pierce as a background constitutional fact, which the Jehovah's Witnesses claim, in light of which the JW's claims could be viewed. Yes, we all know about the 1925 New Republic editorial critical of Pierce. We all assume Frankfurter wrote that. But it's a very important, not just a passing point, but a rather important part of his Barnett dissent. So Meyer definitely employs the 14th Amendment word liberty, and it does so separately from, and this might be sort of what the 1980s conservative perspective would have been, that is that, well, it's all about process, and maybe even only about criminal process, because life, liberty, and property refer to the key penalties available to criminal law: capital punishment, imprisonment, or fines. But confining it that way is not only repeatedly, rejecting that limitation is not only repeatedly accepted by the modern court, it's also within a tradition. Looking at the core of Meyer, okay, contract interestingly comes first. Engaging in common occupations of life comes second. Acquiring knowledge is on the list, and of course Justice Douglas will riff on that in Griswold. Some of the rights mentioned in Meyer are also in the Bill of Rights, but as we saw this morning, a colloquy with Professor Ross, that was in, actually, let's incorporate the free exercise clause. That was in the briefs in Meyer, but when questioned about it by Chief Justice Taft, Mr. Mullen, at least as I read Professor Ross's account of it, did not make that the hill to die on. He didn't want to deny it, but he knew he might need to rely on something else. So what ties these rights together, I submit, is the primacy of contract and professional life, occupation, and the hermeneutic of tradition. As when the court, declining to offer more specifics, says, those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men, close quote. One of the cases in the Meyer string cite is Truax v. Raich, or maybe it's Reich, I don't know, that Mike Raich was an immigrant from Austria. It would have been Reich in the old country. I'm not sure how he pronounced it or how it should be pronounced in the context of the case. Let's go with Truax v. Raich for now. The court said, it requires no argument to show that the right to work for a living in the common occupations of the community is the very essence of the personal freedom and opportunity that it was the purpose of the amendment to secure, close quote. This is vintage anti-slavery constitutionalism, I submit. Funny note here, Justice McReynolds actually dissented in Raich, but only on the 11th Amendment grounds. He thought that the state officials couldn't be sued, but that meant suing the state government. Yep, the old codger didn't accept ex parte Young, but he later mellowed on that. And yes, I know, mellow McReynolds is not on anybody's bingo card here today, but actually there is a recent article in the Supreme Court Review about McReynolds, which acknowledges much of the traditional mythos about him, but debunks certain specific stories that are told about his expense, especially involving the court portrait and Brandeis. So don't give up on him as a person. Okay, since rumors of the demise of Meyer and Pierce were dismissed in the Prince opinion, at least in dicta that has become very influential, Meyer and Pierce have since then been deployed for purposes, I think, rather far afield from the courts that drafted them. Most famously, the majority in Griswold, still imbued with New Deal hostility to the 14th Amendment due process, turned them into free speech cases, an interpretation that is only remotely related to their actual content and is of, at best, rather speculative relevance to the holding of Griswold. As Susan's article points out, Meyer undergirded a range of professional liberty decisions in the 1930s, and as she also shows, it has played a role in the revived substantive due process that realistically began with Griswold, although they didn't really admit it, and expanded from there. And her article is a reference for this development. But what I think one sees in this process is a certain gumbification of Meyer and Pierce rights. Remember Gumby, the toy that was radial rubber, but you could twist it into shapes and make it do something. First, in Griswold, they turned it into an incorporated First Amendment right to pursue knowledge. And then they get turned into a freestanding Casey mystery passage right to define one's own universe. Justice Scalia was very preoccupied with this development, as we see in his dissent in Troxel. I think he may have overcredited it, that is, the modern development, perhaps mistaking an inauthentic development for an integral and inevitable one. It remains unclear how we got from Meyer to this. Susan acknowledges in her article that the use of Meyer in the reproductive rights cases is ironic. Nothing in Meyer or Pierce sets the individual parent up against the universe, bravely defying it with an assist from constitutional law. On the contrary, Meyer and Pierce assume a world of orderly pursuit of happiness by free men, to quote the actual wording. But from that, we can assume also orderly pursuit of happiness by free women, or to close out with a reference to the name I've chosen for the Litigation and Policy Foundation I aim to start, free families. Thank you very much.
Sorry.
So there might be fireworks, Bob. I'm going to bring it. So as Bob mentioned, my name is Michael Bindus, and I head up IJ's educational choice practice. We, as Bob mentioned, help legislators craft educational choice programs and then defend them in court when they're challenged. And in that work, we're oftentimes, always, locking horns with what I like to call the public school establishment. So I'm talking about the National Education Association, its state affiliates, public school districts, public school officials who pursue legal challenge. Well, they challenge these programs in the State House, try to defeat them legislatively, and when they can't do that, challenge them in the courthouse, and we defend those programs. And it's from that kind of perspective that I like to give my remarks. And what I want to focus on is the fact that the language laws at issue in Meyer were no outlier at all. They were part of a long-running, persistent campaign by the public school establishment to deprive parents, primarily religious, ethnic, and racial minorities, of the ability to make the choices concerning their children's education. Now, the public school establishment's championing of the language laws in the wake of World War II was of a piece with its previous championing of the Blaine movement in the 19th century, with its support of laws aimed at inhibiting the ability of private schools to offer educational opportunities to African American children, and its subsequent championing of the compulsory public education law that Oregon adopted in the 1920s, and going up through today, its relentless attacks on educational choice programs. All of these efforts were aimed at standardizing children, at taking oftentimes poor and minority children and trying to make them fit the public school establishment's vision of what a good American should be. Now, these persistent attacks on private schools and the parents who would choose them thankfully have backfired tremendously, and they've given rise to an arc of precedent that bends consistently toward protection for the right of parents to control their children's education. So let's take a look at some of these attacks. As I mentioned, they start with the Blaine movement of the 19th century, which, as you all probably know, was a movement to amend the federal constitution, unsuccessfully, thankfully, and also state constitutions, often successfully, to protect the generic Protestant nature of the public schools of the 19th century while denying any aid to Catholic schools. This movement was championed, in fact, its biggest champion was the National Education Association, which had been founded in 1857 as the National Teachers Association. In 1866, for example, the president of the NEA called for public schools to, quote, train the young to be religious, instilling in them a spirit of devotion and faith in the most important truths of our holy religion. Of course, that was the Protestant religion. And there are numerous accounts of Catholic students being expelled or beaten in their public schools for refusing to go along. You can look up the names of Bridget Donahoe, Tom Wall, Mary and John Hahir. Many of their names recounted in judicial opinions upholding these expulsions and beatings. Now you might ask, why was the public school establishment, why was the NEA so intent on maintaining the Protestant nature of the public schools and denying aid to Catholic schools? Well, in 1891, the NEA's Committee on State School Systems tells us. They say, quote, foreign influence has begun a system of colonization with a purpose of preserving foreign languages and traditions and proportionately of destroying distinctive Americanism. These foreigners, the committee warned, are, quote, among us in large and influential numbers, who refuse to send to the public schools, who insist upon the exclusive control and direction of the education of their children. Why do they do it? The committee asked. The answer is simply this. They are foreigners. They have come unavoidably, bringing their customs, habits, attachments, and traditions of another land, and all in a tongue which is the channel of every thought, feeling, and religious sentiment. And the remedy, the NEA committee declared, is, quote, the assimilating power of a public free school system. Now, sadly, the public school establishment's hostility and its attempts to deny opportunity to minority children wasn't confined to religious minorities. It extended to racial minorities as well. And the public school establishment championed many laws aimed at inhibiting the ability of private schools to provide educational opportunity to racial minorities, primarily African American children. And the, I think, best illustration of this is one that David alluded to. The day after Easter in 1916, 3 Catholic nuns were arrested in St. Augustine, Florida. What was their crime, you might ask? Well, just a couple years earlier, at the urging of the state's superintendent of public instruction, the legislature had passed a law entitled An Act Prohibiting White Persons from Teaching Negroes in Negro Schools. It provided that, quote, it shall be unlawful in the state for white teachers to teach Negroes in Negro schools and for Negro teachers to teach in white schools. These 3 nuns knew about the law, they thumbed their nose at it, and they were subsequently arrested for the crime of educating black children. Fast forward a few more years. In the wake of the First World War, as we now know from today's conference, if we didn't before, there was this drive to adopt language laws. The biggest champion of this drive was the National Education Association. And we know that these laws were fueled by anti-immigrant sentiment, specifically anti-German sentiment, but also there's a good deal of evidence, I think, anti-Catholic sentiment, because in many urban areas, the Catholic Church had set up ethnically based parishes and schools to educate Polish, immigrant, Czech, Lithuanian immigrants. Fast forward a couple more years to the mid-1920s, when the public school establishment tries quite literally to shut down private schools by urging the enactment of laws that compelled attendance not just at a school, but at specifically a public school. And although only Oregon was successful in enacting such a law, they were also pushed in Nebraska, Michigan, Washington, Ohio, Oklahoma, and California. And like the Blaine and the language law movements before it, they were rooted squarely in nativism. Now, Oregon's measure, the one that actually was enacted, was supported by a number of groups, including the reconstituted Klan in the early 1920s, but also by the Oregon Education Association, which also around the same time endorsed an American Legion campaign, which called for instruction in English only and loyalty oaths. And the National Education Journal, the official publication of the NEA, trumpeted Oregon's law as the, quote, most significant educational achievement in the state in 1922. Fast forward a few more decades, we get to what I have the privilege of doing now, which is defend educational choice programs against the relentless attacks by the public school establishment. The NEA, the American Federation of Teachers, the National School Boards Association, either through directly litigating these challenges or lending amicus support, is hell-bent on taking these opportunities, modest financial assistance for parents to opt out of the public school system to get something that will work better for their children. They attack these relentlessly in courts throughout the country. Now, the public school establishment couches these efforts as necessary to ensure that education serves the assimilating, democratizing, Americanizing function necessary to sustain our republic. In reality, however, they're aimed just as much, or I would say exclusively, at protecting the public school establishment's monopoly on education by ensuring that private schools cannot effectively serve parents who desperately want the opportunity that they would otherwise provide. So, how have these efforts fared? Well, let's look at that Florida law that I mentioned, under which those 3 nuns were arrested. The nuns were acquitted, after a court held the law unconstitutional as applied to private schools in an opinion that I think really foreshadows Meyer versus Nebraska. This was 1916, and this is what the opinion had to say. It says, has a white teacher any the less right to sell his services to Negro pupils than a white doctor to Negro patients? Such a law amounts to class legislation depriving teachers of privileges which are not denied to any other class of citizens, and it violates the right of a citizen to be free in the enjoyment of all his faculties and to be free in the use of them. That's 7 years before Meyer. How did the language laws fare for the public school establishment? Well, as we know from the Meyer decision, it backfired spectacularly. Their attack on the language, or their push for the language laws backfired spectacularly. It resulted in the Meyer opinion, which recognizes the constitutional right of private educators to teach and the right of parents to engage them so to instruct their children, and the power of parents to control the education of their own. How did the compulsory school attendance laws fare for the public school establishment? Well, we know in Pierce, a couple years after Meyer, the Supreme Court invalidated the Oregon law in an opinion that recognized that, number one, the child is not the mere creature of the state, that's the court's words. Number two, that parents have a constitutional right to, quote, direct the upbringing and education of children under their control. And number three, again quoting, the fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. And how did the relentless attacks on educational choice programs fare for the public school establishment? Well, in the span of just the last 3 years, we got the Espinoza decision and the Carson decision, which confirmed that the parents have the right to direct the religious upbringing of their children, which recognized that the Constitution protects the ability of parents to do so by sending their children to religious schools, and holds that a state cannot disqualify private religious schools from an educational choice program, whether because of their religious status or because of the religious things they do. So at every turn, the public schools establishment assault on the right of parents to direct the education of their children has backfired. It has secured an arc of precedent, again, that bends consistently toward protection, greater protection, ever greater protection for the right of parents to make the decisions concerning their children's education. I want to thank the public education establishment for this great body of precedent that it has helped create. I only wish that the public school establishment would itself embrace the fruits of its labor. Thank you.
All right, I'm happy to invoke the privilege of guy with a microphone and ask the first question. But so all of your excellent presentations focused very much on history, at least in the sense that they touched on things that happened before today. And so I would like to ask you about tomorrow. It is pretty clear, at least on my read of Dobbs, that Meyer is still standing. There is still some kind of substantive due process right to marry, establish a home, and bring up children. And my question for the panel is, what is that right going to mean? Is Meyer a ship adrift on the sea of the law, never overruled but never cited? Or are there issues percolating now that we can expect to see emerge in the Supreme Court in the next 5 or 10 years where Meyer starts to be used to actually invalidate government action?
I would say in the education context, I think you're going to see Meyer and Pierce used to challenge some of the arbitrary regulations that we're seeing on some of the new models of education that have arisen, particularly in the wake of the pandemic, where education entrepreneurs and parents are coming up with new models to educate and to deliver education to children, and not knowing what to do with those. Government at all levels, state, local, are attempting to prevent those kind of new models of education from flourishing, whether it's through zoning laws, through licensing laws, treating, for example, hybrid schools as daycare centers and subjecting them to all the regulations that pertain to daycare centers. So I think that's an opportunity for the use of the Meyer and Pierce precedent kind of in an area that's very related to what the subject matters of those cases was. And I'll leave it at that. But I think it'd be nice if we could talk about where we think kind of the current court is in its kind of reception to Meyer and Pierce. But I'll give Susan and David a chance here.
Okay, there are not, is this on? There are not, as far as I know, any current cases rising. Sorry. There, is that better? Okay, thank you. There are not, as far as I know, current cases rising that would present this theory of a constitutional right to homeschool, and I don't think that's very realistic at the moment. What I think is more realistic there might be sporadic challenges to the particulars or particular homeschool statutes. Mike Farris, formerly of Homeschool Legal Defense, which he founded, now with ADF, noticed this in the 80s that attempts to use, especially free exercise, to micromanage public school curricula were non-starters, despite Yoder, which wasn't really such a claim. It was a claim of exemption. So he turned his attention to legislative lobbying for better homeschool legislation, and Mike and I have discussed this. For all that he has faith in judicial protections for religious freedom rights, his greatest work and the greatest work of his movement has been in the legislatures. In other words, in practice, he has taken Judge Sutton's advice and gone with state solutions. So today, we have a set of 50 or 51 pretty good homeschool statutes, although, you could, on a theory of rational relation to a legitimate government interest, you could poke at some of them. Some are better than others, and the ones that are worse you could take a poke at. The one I know most intimately is my own, Virginia, and under that we sometimes homeschooled our kids, sometimes sent them to the private school, in fact we sent some of them to Holy Family where I teach now. And my daughter even went to public school for high school. But I got pretty familiar with the Virginia statute, and it's fairly good. It has a religious exemption pass, and the good thing about that is that once you're granted it, your child becomes invisible to the system. The bad thing about it is you have to submit your religion to the examination of a public official. And for me personally, that option is several degrees below drinking bleach. So we went the notice and testing route, which is reasonable. The testing requirements are reasonable. There's a lot of parental involvement in that. The only thing I would quibble with is that you can invoke that only if at least one parent has a college degree. Now, my wife and I both went to Yale, except I finished and then came back and got an MA there, whereas after 7 semesters, she decided she was through. And if that were my situation as well, we would not have qualified. Now, the argument for that will be, well, clearly you have to have a college degree to educate your own children. Really? You sure? I think that could be examined. If courts are upholding college degree requirements for daycare, then they'll probably uphold college degree requirements for homeschooling as well. But, I'd argue they shouldn't, and I hope IJ will keep plugging away at those kinds of barriers to entry.
I think the politics of things are pretty clear. But there's some interesting doctrinal opportunities that I've started thinking about, particularly during today's discussion. There's a part of Roe versus Wade that talks about the right of the woman in consultation with her doctor that drives feminists nuts, because women ought to be able to make their own decision. But let's go back to that. Can we get back to an abortion right based on the professional calling of doctors? Particularly in some of the really tragic cases that are going on now where after Dobbs, the doctors are just so petrified to do things to assist the mother, the health of the mother, not just, oh, I'm going to be mentally stressed if I have a child. That's part of the definition of having a child. But real life and death things. There have been some very dramatic stories in the Times and whatnot. So that's one way you could argue. And then I'm wondering about mounting a constitutional challenge to some of the legislation coming out of Florida using the Meyer's right to information. So those both run quite counter to the current political winds, but I find them intriguing ideas.
All right, we have some time left. We're happy to have questions from the audience.
Hello, my name is Will Miller. I have a question that I'm interested in the interplay or the possibility of an interplay between Meyer and free speech rights, in particular possibility of free speech rights for students. The recent Mahoney area school district, I believe it was, case, I think the court started to walk back at least the old Morse versus Frederick decision. And so I'm curious if you think that there might be a possibility for a future case where they reach back to Meyer to further put a nail in Morse versus Frederick.
Yeah, if you take a look at Justice Gorsuch and Alito's concurring opinion in the angry cheerleader case, they say, while the decision to enroll a student in a public school may be regarded as conferring the authority to regulate some off-premises speech, a subject I addressed below, enrollment cannot be treated as a complete transfer of parental authority over a student's speech. In our society, parents, not the state, have the primary authority and duty to raise, educate, and form the character of their children. Now, they cite Wisconsin and Pierce, or Wisconsin versus Yoder and Pierce for that proposition, but I think there's a great example of how, it intersects with student speech rights.
I love the question because it points to an area where my own views may be in flux. Teaching at Regent, I frequently worked with the lawyers at ACLJ, mooting them for their cases and sometimes, making suggestions for their briefs, et cetera. And, we lived and died by Tinker. We had a micro on the computer, just puts in the Tinker site whenever you need it. When Morse v. Frederick came along, my attention was drawn to the fact that Mr. Free Speech absolutist himself, Justice Black, wrote the dissent in Tinker, maybe because of a Masonic commitment to the public school establishment, given his background, I don't know. And Justice Thomas's dissent in Morse was oddly summoning. I mean, you could certainly make an argument that you either give your kids to the public school system or you don't. And if you do, you got to let them do their thing. In many cases, though, as I think Mike has alluded to, and I think the question is sort of based on this will lead to results that we really don't want to see happen. And as far as history and tradition goes, I just refer back to part of my talk where I talked about, you can look this up in my 2014 Oklahoma City Law Review article, the late 19th, early 20th century cases in which parents alleged and courts agreed that public schools were not, take it or leave it, that you could take some and leave others. So that may actually be the better view, Pache Black and Pache Thomas, that may actually be the better view of the relationship between parents in public schools and between students in public schools.
Thank you. This is a terrific conversation all day, but really enjoying this. I'm Angela Carmella. I'll be speaking a little bit later. I have a question for the panelists about, since we have a national life together, we are Americans, and we have a life in common. And so how do we move in the direction of parental choice for education and for teaching the values we want to teach to our children? How do we move in that direction while still maintaining a sense of the common? Because this will go to questions of, why should I pay taxes for people I don't know, or right. So I mean, like the concern I have, and I'm big on subsidiarity and local, all of that. I love it. But also the concern of how do you keep those two things in a kind of creative tension where you're devolving authority, but you're also ensuring that there are norms that would protect children growing up into citizenship that is, common.
Patrick Wolf at the University of Arkansas, who's he's done a number of studies looking at outcomes of school choice programs in terms of civic values and how well students who participate in school choice programs and attend private schools, religious, non-religious, exhibit later in life civic values. And he finds that students perform better from private schools using the measures that he looks at. So I would, I'd look to Patrick Wolf's research to show that, I don't know that there's a tension there. I'm not sure that there is a tension between, the ability of parents to make these decisions for themselves, so that, kind of power down subsidiarity approach, and ensuring that we, maintain the kind of distinctly American kind of civic life that we have. I think private schools do that quite well.
That's a question that I can best approach from experience rather than theory. I mean, Michael's answer is sort of strong on the theory. You might think from examining the school where I do part-time teaching now and look and say, well, this is as independent of the American mainstream as it's possible to get. It's Catholic, and yet it's not even dependent on a diocese. It's not a diocesan school. It is intentionally Catholic, but not by organizational affiliation. And yet, American history is part of the middle school curriculum. And I myself, judging that the book did not go in enough depth on this, I made all my students read the Declaration of Independence, the full Constitution, and the full Bill of Rights. And shortly we'll be doing the Civil War, and we'll be doing the second inaugural address. And I guess I think that this is just kind of the experiential side of what Michael said, that schools that claim a right to be outside the mainstream may actually be aiding the mainstream much more than their critics would suspect.
I would agree with this in general, but I'm still haunted by the expose in the New York Times last fall about the Hasidic schools in New York City. But that's a failing, not of the constitutional process, but of the political process, because there are standards in place. These children are being instructed solely in Yiddish. They graduate not knowing math, not being able to speak or read or write English at all. So, I mean, I guess there's a constitutional right to try to preserve your culture, we saw that in Wisconsin and whatnot, but at what cost to these kids? When they try to leave, they're illiterate. So, but I think, one of the really interesting trends we see particularly, I think, with Catholic schools and other religious schools is parents going to those schools because the public schools are failing, particularly in urban areas.
I think we have time for one more. JoJo's choice. No pressure.
Nigel Ashford, Institute of Humane Studies. Professor Lawrence, and I apologize if I misrepresent what you said, but you said something like, we assume or normally assume that parents have the best interests of their child at heart, but not all do. So I'm interested if any of the panelists want to comment on what's your criteria for when you think the state should override parental rights?
I think that's very difficult and very challenging. But the facts are that maybe parents do believe they have the best interest of their children, but children are being damaged every day. And we don't have good alternatives because the foster care system's broken. The government doesn't do very well, but the government's never really tried in this area. It's mostly always farmed it out to charitable associations. So maybe we don't have to get to an all or nothing situation. Although part of why I became interested in this initially is the kind of abuse and neglect a child has to have been through before they are available for adoption because their parental rights have been terminated is just tragic. So, I don't know.
Yeah. Never say never, but maybe say almost never. I did a debate on this many years ago when I was involved in child protection issues with an official from, I think it was the Child Welfare League, if I got the name of the organization right, and he said, laid it out there. He said, we're assuming social worker contact, which he didn't have to assume. A social worker should remove a child whenever he or she cannot be absolutely sure that the child will not suffer abuse or neglect. Who can ever have that certainty? You can't even have that certainty if they are moved into foster care. So basically, in practice, that would mean a system in which maybe all children over one house, because then you're taking children away from everybody, but I don't know how that would work in practice. I think this is an issue on which right and left are about to be split, with elements of each going with each other. AEI seems to be sympathetic towards making it easier to remove children, judging from an op-ed I read in the Wall Street Journal last weekend. I checked out some of the opponents that they named, and I found myself sort of more in natural sympathy with those opponents. I mean, they're strong welfareists, okay, so part of their solution is more aid to families. But they also put great stress on resisting parental termination and trying to keep families together. I can see a total scrambling over familiar left and right categories over this issue. And it will be very interesting to watch. I'll be with the families.
And then within the education context specifically, I think Pierce does kind of try to strike a balance here in that while it recognizes the right of parents to direct the education of their kids, it also recognizes the right of states to impose reasonable regulation on private schools. Now, what's reasonable, what's not, is the devil's in the details. But I think in response to Susan's point about the issue with the yeshivas in New York, Michael Helfand, who's a law professor at Pepperdine, had a great piece. It was an opinion piece recently, and I can't remember the publication. But he is an Orthodox Jew, and in layman's terms, but it very, very kind of clearly laid out what he thought was the appropriate balance to deal with that particular situation. And he cites Pierce and kind of the idea that the state can impose some degree of regulations and talks about what he thinks that reasonable balance looks like. So I refer you to that. I wish I could remember the publication, but if you just look for Michael Helfand.
Right, absolutely. Yeah, I mean, my understanding of the problem in New York is the state has declined to enforce the reasonable regulations because of the political power of the constituency. So maybe somewhat distinct from what David said is, I'll go back to what I said towards the end, that I think I'd like to focus less on terminating parental rights and focus more on enabling parents to act in their children's best interest. And that has a financial and social component. Parents need to be able for their children to have health care. Let's just start as basic as that.
All right. Well, thank you, Nigel, for stumping the panel. And thanks all of you for outstanding presentations.
Thank you, Bob.
Anthony, do we have any pre-lunch announcements? Jojo has pre-lunch
Just
announcements.
that lunch is served over here. We'll take a short break and we'll reconvene around 1:15, 1:30.
right, I think we're. All right, I think, ooh, that's loud. I think we're going to get going on the next panel. And this is to acquire useful knowledge, to worship God according to the dictates of his own conscience. Meyer, the First Amendment and incorporation. It's interesting when you read the quote from Meyer on the back of the program, because it encompasses a lot of different rights which have gotten hugely varying protection. Like the right to contract, which is the first thing mentioned, is essentially non-existent now, whereas some of the rights then get some protection. Today, our panel is talking about a right that historically has gotten more protection because it's free speech and First Amendment. We're going to start with James Stern, who is a professor at William & Mary. He is previously the Deputy General Counsel of the U.S. Department of the Treasury, and he writes on property, intellectual property, and privacy, among other things. Next up, we were going to have Dale Carpenter, but he had an emergency, so instead, IJ's very own Bob McNamara will be speaking about free speech. He is the architect of our occupational speech theory and has litigated lots of free speech cases. And he has always interesting ideas about the Constitution. And then finally, we're going to have Angela Carmella, who is a professor at Seton Hall Law School. She writes about religion and the First Amendment, religious land use, among other things. I was impressed to learn she was Teacher of the Year at Seton Hall Law School. As a person who had a lot of really bad teachers, I am jealous of her students. And she's also one of the editors of a book on Christian perspectives on legal theory. So let us start with Professor Stern.
All right, and I'm going to speak from here if that's all right with the... There we go. So the conference is on unenumerated rights by its title, but this is sort of the enumerated part of the unenumerated rights, or how enumeration found its way into unenumeration. And a question that has been of some interest to me for a while, and into which I've done some digging, is just how it is that incorporation of the protections of the Bill of Rights came about. What is to some extent why, to the extent that's possible to answer, but at least sort of how. What were the doctrinal landmarks along the way that enabled this development? And a kind of central linchpin in the story, and I wouldn't claim it is the predominant but-for cause or anything like that, which is beyond my ability to judge. But central to the story is the Meyer case. Meyer occurs at a kind of critical time and in a critical way that leads to incorporation down the road. Before diving into that exactly, just a few words. What is incorporation? I think it's somewhat commonly asserted that Slaughterhouse repudiated incorporation off the bat. That's not, I think, really true. In fact, as far as kind of First Amendment type protection goes, there's some cryptic language in the case. After all, it's not a First Amendment, it's not a free speech kind of case. There's some cryptic language in the decision itself that it could even be seen as supporting some kind of federal free speech right as against state interference, but that kind of lies dormant and is not seriously explored. As far as what incorporation amounts to, one distinction that I think is kind of useful to have in mind, this is very broad, is I think there, on the one hand, there's what I would describe as the kind prevalent conception of what incorporation is today, which is one in which essentially the Due Process Clause of the 14th Amendment is understood to kind of cross-reference the first 8 or most portions of the first 8 amendments and essentially make those constraints originally applicable to the federal government applicable to state laws as well. Another and sort of older view of things is what I have called an overlap view, which is it's more a kind of convergence or a coincidence of things that, as it happens, the protection you get as a matter of due process sort of coincides with enumerated protections under the first 8 amendments, but not it's not actually sort of linking back to them, and it doesn't. The protections don't have to have the same contours. And what occurred in constitutional law is originally an approach that's more like the latter, in which it was concluded as an element of due process, you get protections that look a lot like certain protections under the Bill of Rights, but it's not that it kind of literally applies. And then over time, there's a shift for reasons that I think are kind of interesting in the way these things are thought about. The other thing about incorporation of the first 8 amendments is sort of misleading in a way. It sounds like there are like 8 specific protections that get applied to states, but that's not. That doesn't really describe what's happening. There's some things that have never been incorporated, like the Third Amendment. Some things that have only very recently been incorporated, like the Second Amendment. So that's sort of that is the kind of end state of things. That's not. A part of the kind of how did this come about story. And beyond that, there are kind of, I think, 3 basic baskets of protection. There is the takings clause, which is a kind of a funny story. It is incorporation of the takings clause is now linked to an 1897 decision that may be anachronistic. It may not be. In any event, it's there, but it doesn't really do very much. It doesn't. The decision doesn't have, as it were, legs. It doesn't lead to a kind of cascade of other protections being applied to states thereafter. And then the other 2 pieces that are significant are the First Amendment protections, speech and religion, broadly speaking, and the criminal procedure protections. And so that's really the big movement incorporation-wise. The thing to study and unpack is those 2 things. And part of what I would contend is that it's the First Amendment piece that is the most central to the story. That's what comes first. It is only after the First Amendment has been very conclusively applied to the states that the criminal procedure piece comes into being, and that really starts in the 60s when there's a very strong majority for those kinds of results on the court with Mapp versus Ohio, and thereafter the court proceeds to apply almost every one of the specific enumerated protections against the states, one after another, and in doing so, I think in every situation overrules a prior decision. In fact, a relatively recent prior decision stating that the particular protection involved does not apply to the states through the Due Process Clause. So the First Amendment is really central to the story. That's what this is all about. Pinpointing exactly when that takes place is also a little bit murky, and of course there's a certain amount of anachronistic ex post thinking that comes into superimposing end state concepts onto the original ones, but basically that happens somewhere around 1925 or in the years thereafter. So what is the state of play with the First Amendment? The Supreme Court has a case in 1922, Prudential Insurance against Cheek, which involves a state statute that requires employers or former employers to provide a letter explaining why an employee has left the company. There were a bunch of these service letter statutes that different states had adopted, and the story of what's going on there is a bit complicated. But there's a labor law piece to this, it's kind of disclosing why it is that the employee has been let go. And a number of or several states had found these to be unconstitutional measures, basically on what we would today call a kind of compelled speech theory. And so one of these statutes comes before the Supreme Court in this Cheek case, and the court wastes no time in dismissing the challenge by a 6-3 vote. Neither the 14th Amendment nor any provision of the United States Constitution imposes on the states any restrictions about freedom of speech or the liberty of silence, nor, we may add, does it confer any right of privacy upon either persons or corporations. So this is 6 justices in 1922, and those 6 include Brandeis and Holmes. There are 3 dissenters. They are Chief Justice Taft, Justice Van Devanter, and Justice McReynolds. They don't explain, it's a silent dissent, there is no opinion, but the 3 of them dissent. In 1937, so 15 years later, an employee of the Associated Press is fired by the AP and brings a challenge under labor law seeking reinstatement. The case is Associated Press against NLRB, and it is one of a series of cases, along with, I think more famously, Jones and Laughlin Steele, upholding New Deal labor regulation. And the court there says, this challenge won't fly. There is a very vigorous dissent by Justice George Sutherland, one of the 4 horsemen of the anti-New Deal apocalypse, and he is joined by the other 3 of the 4 horsemen, and he speaks in very stirring language. Freedom is not a mere intellectual abstraction. It's not merely a word to adorn an oration upon occasions of patriotic rejoicing. It's an intensely practical reality capable of concrete enjoyment in a multitude of ways, day by day, and so on and so forth. When applied to the press, the term freedom is not to be narrowly confined, and it obviously means more than publication and circulation. Very rhapsodic. He goes on defending the First Amendment in a kind of terminology that is, it's quite stirring and not, I think, not all that typical in Supreme Court decisions of the period. So if you just had these 2 pieces of data to go by, you might think, well, the freedom of speech applied to the states was a sort of a neo-Lochnerian thing, and there is some truth in that. That's part of the story that I want to tell. Now, along the way, that leaves out some things that that occurred. Brandeis and Holmes, at some point, rather famously, kind of begin to switch their mental orientation on speech questions. And some of that has been touched on before. Both of them, in decisions along the way, say something kind of to the effect of, well, gosh, I'm not sure about this whole 14th Amendment due process thing to begin with, but if we're going to do it, and if we're going to do Lochner and all the rest of it, we might as well do this too. So that experience helps to bring them on board. But the question is, what is it that brings the court as a whole on board, and what drives this? In the years. In the run-up to the Cheek decision, the first one that I described, in which the court just says in 1922, there is no free speech protection under the Due Process Clause applicable to the states. The court had faced a handful of First Amendment challenges along the way, rejects them, never quite saying anything as definitive as the Cheek decision does. So it puts to rest finally Cheek, or at least if it had been followed, Cheek would have put to rest the idea that due process has a free speech component. The cases leading up to that basically sort of say whatever freedom of speech means, it doesn't override the police power, and so reasonable measures for the public good can all be sustained. So that's sort of the background going into the Cheek case. And yet, by 1925, 3 years after Cheek, the court flips its position and says in Gilbert versus New York, for present purposes, we may and do assume that freedom of speech and press, which are protected by the First Amendment for abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment. We do not regard the incidental statement in Cheek, which does not strike me as being particularly incidental, the incidental statement in Cheek that the 14th Amendment imposes no restrictions on the states concerning freedom of speech as determinative of this question. So what has happened between 1922 and 1925? Well, one development at least is the Meyer decision. And in Meyer, part of what's remarkable, and I think some other speakers have talked about this, I know they have because I was here, is how much broader the ratio decidendi there is than it needed to be in order to sustain the challenge. The briefing in the case centers on very conventional liberty of contract, freedom to pursue any lawful calling ideas. It's the right of an instructor to pursue his livelihood as he sees fit. At oral argument, things change a bit, as I think there was some discussion of earlier. Counsel for Meyer stresses liberty of conscience and religious liberty, and there's a colloquy with Chief Justice Taft, who sort of pushes that even farther. So Taft says, surely religious liberty is or you incorporate freedom of religion as part of that provision, and counsel says, surely religious liberty is a privilege and immunity guaranteed by the Constitution. Taft then says something else, and counsel says the right to study, the right to use the human intellect as man sees fit, this is all protected. And then we get McReynolds' rather striking decision in which he goes well beyond the right to pursue a lawful calling, and we all know the passages, but the right to marry, establish a home, and children worship God according to the dictates of his conscience, and so on and so forth. All of that is really reaching out, and in doing so, McReynolds cites a whole bunch of kind of Lochnerian precedents, none of which support this kind of, at least directly support anything like the sort of right that's contended for here. But mixed into the citations that he alludes to are various Lochnerian precedents in the liberty of contract realm and rate regulations and so forth, and it creates a kind of a synthesis that brings all these things together. What motivated this? I think I'm not enough of a biographer of Justice McReynolds to be able to discern, what his particular motivations were in sculpting the opinion the way that he did. But what I would stress is that his wing of the court was, through the service letter case, sort of brought on board, at least with the principle that freedom of speech was something that the Due Process Clause protected, and the idea that the Due Process Clause embraced these fundamental liberties was something that was well developed in the jurisprudence with which McReynolds is linked today. So those pieces coming together helped I think, helped to do that. And so in the years that follow, there's a bit of a tug of war, and what you might think of as the more progressive wing of the court as against the more conservative wing of the court sometimes takes the lead in these First Amendment cases. But in others, like the AP case, it flips around. What you do have is a unified commitment to the principle that this is this fundamental liberty that's part of due process, reliance on kind of real, you might think of today as sort of originalist analysis going back to the English experience and so forth. Invariably, the reliance is only on precedents that would be relevant to the federal First Amendment, so that there's the protection that's given is really the same at the federal and state level. And in fact, there's more to that than it may sound like, because there really was no protection. There was no established case law on the freedom of speech side at the federal level. So when the court starts to subject the states to freedom of speech protection under the Due Process Clause, they're not just applying the First Amendment to the states, they're sort of inventing the First Amendment as they go, because there just wasn't anything there. No federal law was struck down on First Amendment grounds until the mid-'60s. So this really, the incorporation of the First Amendment really is the invention of it. What's interesting in here, or one thing that's interesting to me in this, is they're writing on a blank slate. The claim is made, well, look, the Due Process Clause protects those fundamental liberties. Who at that level of abstraction would deny that freedom of speech is a sort of fundamental liberty of, within the English common law tradition and of this nation? And if you put it like that, and there was so little that was particularly entailed by it that it makes it a lot easier to do. Unlike the criminal procedure amendments, it's not specific, and there wasn't even, this sort of built-up body of case law. No one knew how rigorously the First Amendment would come to be applied in the years thereafter. So it makes it, I think, a principle that you can get broad buy-in on. It doesn't do a whole lot, and you don't really have to make that distinction between what I earlier described as the kind of overlap conception of what's going on versus the cross-reference. Like, you literally apply the enumerated rights as against the states. But that then being in place, it paves the way, along with other things like a robust majority for this result. But conceptually, it paves the way for the later application of the more specific, more particularized amendments in the criminal procedure realm against the states, and thereafter, there's a clear aim, I think, there on the part of people like Brennan and especially Douglas and Black to create a floor. In time, this overall approach works, this kind of more formalistic approach works to create a kind of a ceiling instead, so that you don't get new unenumerated rights being recognized. But that's the sort of the dynamic of the sort of competing formalism versus open-endedness that drives all this. In any event, Meyer is central to that story, and I will stop there.
All right, I will follow your example, and it's on. It may not be, there we go. I'm just too tall. I will follow your example and speak from here. Thank you all for coming, and thanks to Anthony for inviting me when it became clear that literally no one else was available. But no, I am excited to be here. I am excited to possibly, for the first time in my life, not be the person on the panel who talks the fastest. So that's a personal achievement of mine. No, this is, if I could have chosen a panel, it would have been this one, because I think the intersection between Meyer and free speech is fascinating, mostly because I think it's an important aspect of what I think of as the modern effort to save Meyer from itself. And the modern effort to save Meyer from itself is important because Meyer is part of what you might think of as the supercanon. If there's an anti-canon, there's a supercanon. And it's commonly said that for an originalist theory to be valid, the originalists have to be able to explain how Brown v. Board is right. Because if your theory of the Constitution is Brown v. Board is wrong, you're not in the room. You're a nut. So all originalists have to have a theory for how Brown v. Board is right. Similarly, I think all judicial minimalists have to have a theory for how Meyer is right. Like, look, the government can't ban teaching German. I'm not a nut. You need something to say. But the problem for the modern minimalists is that Meyer is part and parcel of the Lochner tradition, right? this person's occupation is teaching German, therefore he has a right to pursue his occupation. And what people go to in trying to save Meyer is that Meyer, as we have discussed, doesn't speak narrowly. It speaks broadly. Right? A prohibition on teaching German to kids violates rights. It violates a bunch of rights in a bunch of different ways, and we don't particularly feel obligated to identify the specific right that is the font of the prohibition on the government banning the teaching of German. It seems to violate basic rights in a number of ways, and that is the end of the story. And one of those ways is it violates the freedom of speech. And I think a lot of people, both judges and academics and lawyers, looking back on Meyer, try to console themselves by saying, look, Meyer is secretly a free speech case. Teaching German to kids is speaking, and if Meyer arose today, we don't need to worry about how our theory of judicial review of economic regulations would interact with it, because we in our more enlightened time would recognize that teaching German to kids is speech. And therefore, our modern theory, our more enlightened view of the Constitution, would say this falls under the free speech clause, and that would end the controversy. We wouldn't have to worry about Meyer. And the reason I think that's an interesting story is that it's not true. It's certainly not true in a lot of modern case law. Probably the best example of this is a controversy that arose in California, where California adopted a law in 2009 requiring all vocational schools to limit their instruction to students who either had a high school diploma, a GED, or had passed what's known as the Federal Ability to Benefit Test. There's a long-standing requirement for schools that accept students who take subsidized federal loans, that the students taking the loans have to be ability to benefit students. The school needs to be able to demonstrate that if a student gets a subsidized loan to come to my school, I'm not, they have the sufficient capacity to learn the secretarial skills that I'm teaching at my vocational school. California decided that wasn't enough. They transformed that from a regulation of subsidized loans to a regulation of who schools were allowed to admit. And so the Pacific Coast Horseshoeing School, founded and run by Bob Smith, got a letter in the mail in 2017 threatening him because Bob had been enrolling students who hadn't graduated from high school. And at the Pacific Coast Horseshoeing School, they teach horseshoeing. Putting on, not throwing. It teaches the ancient art of being a farrier. And being a farrier is a useful skill. It is in high demand, and it doesn't require that you be particularly good at math or English literature. And so a lot of people who were attracted to the Pacific Coast Horseshoeing School were people who didn't succeed in high school for whatever reason, for family reasons or personal reasons, but who wanted to learn a useful skill. And of course, people have been teaching other people how to shoe horses since before high schools were invented, right? People have been teaching other people how to shoe horses since before the state of California was invented. It seems unnecessary to have formal education before you're allowed to enroll in a horseshoeing school, but we're assured by the moderns, in our modern enlightened realm, everyone would recognize that teaching kids German is a First Amendment case. And so I should disclose, the Institute for Justice represented the Pacific Coast Horseshoeing School. So IJ sued under the First Amendment. Teaching people how to shoe horses is speech. Teaching is speech. This is a regulation of who we're allowed to teach. And it's not Meyer. The state isn't forbidding you from teaching because it wants to ensure that all kids grow up speaking English. It is, in a sense, worse than Meyer. It's the state prohibiting you from receiving this information because in the eyes of the state, you are too dumb to hear what Bob Smith has to say. You cannot benefit from Bob Smith because we don't think you're smart enough to really look at him holding that hammer and learn how to shoe a horse yourself. And the state's response was that this isn't a free speech case. This is a restriction on the ability to contract. Because before you enroll in a school, the school sends you an enrollment agreement. An enrollment agreement is a contract, and all California is saying is you're not allowed to enter into this contract. You're not allowed to make this sale, provide this commercial service to this class of people. That's an economic regulation. And if that's an economic regulation, then we're outside of the First Amendment box. We are in modern rational basis land where the state has a free hand to decide who may transact with whom, because we've all decided, we all know, that the Lochner era was wrong, that freedom of contract is gross, that the right to pursue a common occupation is yucky and has been abandoned. And all you're doing is pursuing a common occupation. You're entering into a contract and the state has forbidden you from contracting. And it won. The district court held that, in fact, a prohibition on teaching people skills on the grounds that they hadn't graduated from high school did not infringe on the First Amendment because it wasn't triggered by communicating a message. It was triggered by entering into a contract. In the alternative, the district court noted that this law was not triggered by communicating a message. It was triggered by being in California, as, of course, all California laws are. And our position, eventually adopted by the Ninth Circuit, and by that point the case was Pacific Coast Horseshoeing School v. Kirchmeyer, if anyone wants to read it, was that this is, in fact, a restriction on who may say what to whom. Bob Smith teaches vocational skills. He teaches you how to shoe horses for a living, so he's covered by the prohibition. If he taught avocational skills, if he taught you how to throw horseshoes for fun, he would not be regulated, and people who didn't have a GED would be free to pay him money to learn skills for fun. That is a restriction on speech. We ultimately prevailed in the Ninth Circuit. It's not entirely clear to me that we would prevail on that argument in all the circuits across the country. I can think of at least one where that claim is probably foreclosed. The point is that the district court decision saying this is an infringement on the liberty of contract is not crazy. I can say that now because the case is over and we have won. But it's not insane. There are actually a lot of people in the country who look at that regulation and say, this is an economic regulation. We don't do these anymore. But it's an economic regulation in exactly the same way that the restriction in Meyer was an economic regulation. Meyer is about someone pursuing the common occupation of a teacher. He happened to be pursuing a common occupation that was engaged in speech, but it was a common occupation nonetheless. And I think the lesson we can draw from Pacific Coast horseshoeing is that the modern idea that we can save the cases we like, we can go back to the early 20th century and pick out the cases, the supercanon cases, and reformulate them around rights we like, instead of around what they actually say, is a fraught and ultimately dangerous proposal. Because what I think is illustrated by the Pacific Coast horseshoeing case is that if you pick and choose among rights, if you try to select the rights that you deem most important and deem them protected and deny or disparage other rights, the denial and disparagement of those other rights will inevitably leach into the rights that you're assuring yourself are still protected, which is exactly what happened in the trial court in the California case and which continues to happen in courts around the country. That it is very difficult to have a stable regime of favored rights and disfavored rights, which I might venture to suggest is why the framers specifically warned us against denying or disparaging rights that were not specifically enumerated in the Constitution. But what do I know? Precisely because there is, I think, the inevitable temptation to defer to government power. And I think the lesson we might draw from that is that rather than save Meyer from itself, the centennial of Meyer might be a good time to look back to that approach to see if perhaps Meyer can save us from ourselves. That perhaps the better approach is rather than aggressively trying to identify the specific right, the specific right that is being violated, we take a more holistic look at the government's interests and at the broader rights of individuals to decide for themselves. I always think back to, it's an example I'm stealing from my old friend Clark Neely, but he always gave the example, and it resonates more now, as you will see in a second, but when he was talking to students, he would say, now imagine that the government issued an order that said you weren't allowed to leave your house. How would you feel about that? And the students would instantly say, oh, well, that would be terrible. That would be wildly unacceptable. And Clark would say, wait just a minute. I'm pretty libertarian. I'm not sure I agree with you, because I think the question I would want to ask is, why? Why did the government say you can't leave your house? Is there, in fact, a virulent virus being spread throughout your town, and the government needs to hold everyone until we figure out whether everyone has been infected? Or is it that there's an election next week, and you're an especially eloquent supporter of the opposition? I think we would need to know why. And that is actually where, if you read Meyer, where the frame of the inquiry is. It's not, we need to identify the sort of right that is being infringed when I tell you you cannot teach German, because an infinitude of rights are being infringed when I tell you that you're not allowed to teach a kid German. That child's family's right to be German, certainly being infringed. My right as a teacher to speak, being infringed. My right to earn a living by working as a teacher, being infringed. Those parents' rights to decide their kid's going to be taught German, being infringed. The child's right to sit in my classroom and hear from me, being infringed. And we could, if we wanted, go on and rank all of those rights in the order of importance in the Anglo-American tradition. But ultimately, that's a fruitless exercise because the question remains, why? Is teaching children German causing forest fires? If you can support that, by all means. What's going on is that the state doesn't like teaching German. It doesn't want the children to learn German. And the question, much more than can we identify a right in the panoply of human rights that we are going to decide in our infinite wisdom is important, is much less important than the much more fundamental question of on what basis does the government presume to tell you that you may not, as an individual, make your own decisions? It seems actually like a much more fruitful frame, and in that sense, I think a lot of the strenuous efforts to save Meyer from itself are really just efforts to pull constitutional analysis onto dangerous shoals and to pull individual rights along with them. So as we look back at Meyer 100 years later, it might behoove us to think a little less about how we can fix Meyer and a little more about how we have gone astray from the things that Meyer, for my money, quite plainly got right. And on that note, I will stop. Thank you very much.
Okay, good afternoon, everyone. Thank you so much for the opportunity to be here. Such a great discussion. I'm going to be talking about religious liberty, or focusing particularly on the Free Exercise Clause. I was very happy to hear Professor Ross say that Meyer is a fundamentally free exercise case, the free exercise of the Lutheran Church. They were the Missouri Synod leading the charge with respect to the litigation. Now, courts have long protected parents to choose a religious school, also to opt children in public school out of things like sex education, and to make faith-based medical decisions. And I'll talk a little bit about this. But I think Meyer takes us in even deeper in sort of religious exercise relationships. First, it really solidifies the notion that the child is the extension of the parent's religion or religious exercise. But in addition to this direct relationship between parent and child, Meyer implicates the relationship between parent and school, teacher and child, teacher and school, church and school, church and business. So I'll talk about those relationships too, and I think we'll be able to see that just as Meyer is pluralist and libertarian, the direction of the Supreme Court, that's sort of the current direction that the court is heading in its free exercise jurisprudence. Now, obviously, Meyer's not a free exercise case, because it wasn't, we didn't have an incorporation at that point, but it could have been. A parochial school teacher reading the Bible in German in a religion lesson, violating a language law, that would be a straightforward violation today. It would not survive strict scrutiny review. And additionally, we could view it as a religious school being told how it should teach religion, and that would violate both free exercise and the Establishment Clause. Now, Mr. Meyer's students were sent to Zion Lutheran by their parents, so we can explore the parent-child relationship. First, in connection with the choice of education, the Supreme Court, as we know, signaled very robustly in Wisconsin versus Yoder that the Free Exercise Clause gives parents tremendous flexibility with respect to choice of religious school, private school, other kinds of possible homeschooling for one's community. In Yoder, the court recognized not just an unenumerated right, but also a right explicitly tied to the Free Exercise Clause for parents to direct their children's religious upbringing. And it did this on the basis of sociology. The parents were afraid that their community would be decimated when their children were enticed into a different lifestyle by attending public schools. So it really wasn't a faith-based claim, at least not in the narrow sense that we usually think of faith-based claims. The court has also signaled that the clear free exercise right to raise children in religious enclaves and to keep them in such communities. Now, languages often go along with those enclave communities: German, Spanish, Yiddish, Hebrew. And as we saw in the last panel, the extent of educational choice and the extent of enclave isolation are under some intense scrutiny. I'll come back to this in a bit. Second, parents have long enjoyed opt-out rights for some courses in public schools, especially sex education that may contain religiously objectionable material. And it's worth noting, though, that there is no general right to opt out. Most courts say that mere exposure to ideas does not violate a parent's right in religious upbringing. But again, we see renewed scrutiny of this mere exposure concept. Back in a little bit. Now, in the medical context, parents are generally able to consent to medical treatment for their child, a long-standing common law presumption. But parents have sometimes been precluded, particularly in abortion and contraception decisions, laws that have allowed court-approved abortions for minors and the provision of contraception without parental notice or consent. Here, too, we're seeing intense scrutiny and a lot of change. For states that have restricted abortion, consistent with what Dobbs now allows, the Supreme Court recently vacated a law that allowed minors to seek permission for court-approved abortion. And on the question of contraception, a federal district court recently held that parents can challenge regulations that allow provision of contraception to minors without notice or consent. The father of young daughters sued Health and Human Services for subverting his authority as a parent, loss of assurances that his children will be unable to access prescription contraception, and, most importantly here, weakening his ability to raise his children in the Christian faith, and the court agreed with him. So now I'd like to go a little deeper where Meyer takes us into a variety of relationships beyond parent and child. First, the parent and school. The court has long recognized it's a parent's religious exercise to send their children to religious school. That's with Pierce, right? But the court used to tell parents that this choice could not be subsidized by the state, that under the Lemon test, Lemon versus Kurtzman, 1971, most forms of school aid actually were held to violate the Establishment Clause. But now Lemon is dead. So thanks to the efforts of Michael Bendis and IJ and other organizations, the Free Exercise Clause is now interpreted to require religious schools to be included in programs. And the difference here is that Lemon was looking at programs that entangled the legislation provided for some kind of state aid that went directly to parochial schools. And so there were concerns of entanglement and other issues. As soon as folks began to create programs of choice, whereby the dollars or whatever aid could be directed by the parent, that's when the court started to make its 180. And so now programs that allow parents to direct aid to the schools of their choice, we see in Espinoza, we see in Carson, and of course the building blocks before those decisions. The court is affirming these because we're talking about parental control. The next big question will be whether religiously affiliated charter schools can exist or whether those schools must be public. So I think that's kind of the next issue on the horizon. Now, we know that Mr. Myers taught the Bible the way the Lutheran Church wanted him to. So we can consider the relationship between the teacher and the child, the teacher and the church, and the teacher and the school. Now, the court has recognized nearly complete autonomy for churches and their schools to decide who is involved in any religious formation of children. It's a doctrine called the ministerial exception. Under this, a teacher who is involved in passing on the faith to children is deemed a minister, regardless of their title or training. And this is to the great surprise of many women throughout the country who are teachers in parochial schools who can't be members of the clergy, but they are still considered ministers because of the role they play in faith transmission. Now, this is based in part on the assumption that parents trust the school to teach the faith properly, so that sending your child to the school means that the teacher will be faithful to those teachings. But the ministerial exception doesn't just protect children from heretics. It actually gives schools complete authority to fire teachers who are ministers for any reason or no reason. So teachers who are fired, cannot sue their churches, even if they're alleging some kind of discrimination, sex, age, race, and the like. A little bit more on this later. Now, the Supreme Court takes this a step further to protect the church and related entities that are not schools. The court allows churches to control other entities, healthcare, social services, so that they are consistent with mission and faith. The court recently protected a Catholic foster care agency that refused to include same-sex couples in its foster family program. Philadelphia did not want agencies to, in their terms, that was discrimination. So the city refused to place foster children with people who partnered with that Catholic agency, even though the need was great. So those prospective foster care parents, along with the agency, sued Philadelphia, and they prevailed. The court signaled a pluralistic approach, allowing agencies that promote non-traditional and traditional environments for raising children. But most importantly, it also signaled that foster parents can rely on religious entities to provide service consistent with mission, much like parents who rely on their church schools to provide an education consistent with mission. Now, another relationship that the court explores is between, and this is a little bit off topic, but when we're talking teacher and child, public school teacher and child. We have this recent case of the football coach who prayed after football games, and many of his players joined in. The court gave a lot of weight to the facts on the record that the coach had never explicitly required his team to pray with him, and that only a few parents had complained over the years. Now, because of that, the court decided the case was really about the coach's free speech and free exercise and not about his influence on the children. So it's not clear to me what this means for parental free exercise rights. In situations where the students are predominantly of one faith and the teacher is of a different faith, maybe we will get clarity on what it means to, whether that's coercive, whether there's any coercion involved. Now, finally, a word on religion and business. Now, Mr. Myers was a teacher by occupation, and the school was the church's, I'm going to call it, it's business, right? We've talked in entrepreneurial terms. Now, of course, schools are nonprofits, but for-profit businesses now explicitly enjoy the protection of free exercise clause and its statutory analog, the Religious Freedom Restoration Act. Hobby Lobby, you may remember the case, the court exempted the company from having to pay for contraceptives for their employees. And in this term, the court will decide whether wedding vendors who refuse to endorse same-sex marriage are constitutionally protected, this time under the free speech clause. Now, so we have this tremendously robust free exercise jurisprudence, but a kind of byproduct of that is that sometimes the child or the teacher or the parent become invisible. And I think, for instance, in the coach case, you have the invisibility of the child and the parent because we're not quite sure, what that relationship is going to look like. if we're allowing public school teachers and other figures like coaches to have influence over children's religious development. We have so much emphasis on autonomy in the ministerial exception, autonomy for the institution, that we don't really see the teacher as having an occupation. Because there, again, no proof is required that the teacher has done anything against the faith, because the Free Exercise Clause and Establishment Clauses have been interpreted to require a completely hands-off approach. So you have sort of the teacher is invisible in that context. And then if we think about church autonomy going even farther, for decades it was impossible to bring tort litigation against churches that had failed to supervise their pedophile priests and other clergy. For 2 decades, we have litigation that fails repeatedly because courts said we can't intrude. We can't intrude in the church's autonomy. We can't make them liable on grounds of negligent supervision of their priests. We can't get involved in that relationship. So you really have the invisibility of children. And so the Free Exercise Clause, it's just now that we've cut back, at least in that area, cut back on church autonomy using some other doctrines. But so it's just kind of something to think about when we think about robust free exercise. It doesn't always necessarily mean that parents, children, teachers, and institutions are working harmoniously together. Am I out of time or? About 4 or 5 minutes. Oh, great. Okay, thank you. So I did want to talk a little bit about 2 areas where I think we see some cases now. One specifically on religion and language. Obviously, we've talked a lot about that with respect to Meyer. Religion and language and culture are deeply intertwined. And Michael mentioned earlier about the Catholic national parishes that sponsored schools for immigrant children. You ask anybody from Quebec, and you know that the Catholic Church there preserved not only the faith, but the language, culture, all together. So, Meyer rejects coercive assimilation for whites and even Asians in the Hawaii case. But the story is completely different for Native Americans. Starting in the late 1800s, Native languages were banned from Indian reservations. Missionaries were prohibited from speaking Native language. And right now, over half of the 245 indigenous languages are extinct or nearly extinct in the United States. And of course, along with those languages went the religious practices. Native American children were also routinely removed from their homes, placed in government or mission schools. Many were placed in non-Indian foster homes and adoptive homes to force assimilation. And of course, they weren't considered citizens until a year after the Meyer decision. So perhaps the assumption that immigrants would ultimately assimilate, Meyer basically says that, but that indigenous peoples would not do so naturally and therefore had to be coerced. And I just point out that this morning it was reported that the papal document just came out repudiating the discovery doctrine, discovering the Americas, and so take a look at that. It's very interesting and overdue. Not just apology, but a clear need for reconciliation for the impacts, the suffering, for expropriation of land and exploitation of indigenous peoples. So in kind of a modern context with respect to language, Susan mentioned on the other panel the yeshivas. And there we have, in New York State, 170,000 students enrolled in 450 yeshivas. And there is now, there has been an attempt at more robust regulation to enforce a longstanding substantial equivalence requirement, basically requiring that schools teach required subjects in English. And so a lawsuit has been filed, was filed last October, and of course invoking Meyer, due process, free exercise, and equal protection. So there's certainly an open question as to, well, I guess we sort of had that discussion, the last panel. The last thing I'd like to raise is the religion and gender identity issue. Obviously this is an immensely political issue, controversial issue. The House Republicans last week passed the Parents' Bill of Rights. And it's also a religious issue. Many parents come from religious affiliations that reject the notion of gender mutability. And since 2020, there have been about a dozen lawsuits filed. And these are suits by parents challenging policies in public schools. And I won't go on. I think the Fourth Circuit is going to hear a case, but we don't really have a decision yet from most cases are either pending or they have failed, but there is one before the Fourth Circuit. So I think I'll stop there because I don't want to go too much over time.
All right, well, thank you so much to all of our panelists, and we have a nice period of time for questions and discussion. Sometimes I like to ask the panelists to respond to each other. Was there something that you wanted to say about something somebody else said or to discuss? Because if not, I'll ask questions.
I mean, I was curious if I understand Bob's position. It's an argument for, in a sense, somewhat heightened scrutiny of everything. But it also strikes me as an argument against super heightened scrutiny for anything. Is that right?
I don't know that I'd say I'm opposed to super heightened scrutiny. Maybe I'm in favor of super heightened scrutiny for everything. But I do so Professor Roosevelt earlier made a distinction between situations where the government is making essentially value claims and situations where the government is making fact claims. And I think what goes kind of under-interrogated in that distinction is the robustness with which we scrutinize the government's fact claims. It is frequently the case in modern jurisprudence that if we are in the non-fundamental rights realm and the government asserts a factual justification, that ends the case. And it seems like the fact-finding machinery works pretty much the same way in every case, right? We have depositions, we have cross-examination, we have built actually the Anglo-American system has given us a very robust tool for discerning fact from fiction. And it seems like, regardless of whether there are different tiers of scrutiny, I'm not sure there need to be different tiers of scrutiny when it comes to the plausibility of the government's factual assertions. Because we have the same mechanisms to test those assertions in every kind of case. And I think it is puzzling that in free speech cases, that factual apparatus is different from what that factual apparatus is in antitrust cases, is different from what that factual apparatus is in challenges to run-of-the-mill economic regulations. And I'm not sure I understand why that part is true.
Thank you, Ty Gatsiana. If you all are sitting down, I'll stay seated. I'll follow up on that question and a question I tried to follow up with Professor Roosevelt and David Bernstein afterward. Yes, I think it's. I certainly share Bob's interest in heightened scrutiny and government justifications, and maybe it makes. I'm not sure it doesn't make sense to look at the liberty interest underneath. But part of the reason is Professor Roosevelt gave a justification for Lochner that he found compelling that the New York legislature did not. He said it was about unequal bargaining, but that they made it a health and safety. So what government interests should count? Can the government, again, I'm thinking Clark Neely in the back of my head, under, fictitious rational basis scrutiny, the government can come up with, or any judge can imagine anything. We probably don't want to go there. But then, do we hold the government to the ground that was actually at play when the regulation was granted? And you still then would have to factor in animus. And what type of animus counts? Is animus against certain types of competition count? What type of animus then counts and doesn't count? I mean, it's an interesting area if we were writing judicial scrutiny all over again, but this is a conference hosted by the Center for Judicial Engagement.
I mean, I think in terms of the government's interest, a government's assertion of an interest is subject to sort of the same kind of plausibility analysis as anything else, right? Like, you could say that the law at issue in Lochner is in place to even out bargaining power. But that raises the question, why does it only apply to bakers? Is there some evidence that bakers are uniquely unable to grapple with the overwhelming power of the bakery owners? Or is it the case that, in fact, the law is designed to stop immigrant bakers from outcompeting native bakers, which there's a lot of evidence it was? And I think that kind of factual analysis informs a lot of the analysis of what justification you're going to take seriously. And you can, take seriously perhaps the Harlan dissent in Lochner, that there was some contemporaneous argument among scientists that breathing in flour was like breathing in asbestos, and that bakers therefore were unique, and that's the evidence that Justice Harlan took seriously. And I think kind of the question of how seriously we take facts is the question of, in Lochner, do you go with the majority opinion? Do you go with the Harlan dissent, or do you go with the Holmes dissent? Harlan says there's evidence that bakers are special, so it's okay to just regulate bakers. The majority says that evidence is unpersuasive, and Holmes says none of this matters because the government can tell us what to do. In most areas of American life, we've fallen into the third box. Into the Holmes box, and I think that is the least justifiable opinion to come out of that case. So we could have an argument about the legitimacy of the government's interest in equalizing bargaining power, but I think in the Lochner case, that argument has to start with the question of why bakers? And that's the question that I think on that justification you have a lot of difficulty answering it, because that's not, in fact, what the New York legislature was trying to do.
The question for Professor Carmela. You mentioned, over here, sorry, this disembodied voice. So I think you mentioned that today Meyer would be resolved easily under the free exercise clause. And I wonder, number one, is that true after Employment Division versus Smith, given that the law at issue in Meyer was neutral toward religion and therefore would be subjected only to rational basis review? And if that's the case, does that mean Employment Division Smith versus Smith was wrong? Or does it mean Bob was right when he said, the right question to ask is just why, not what the protection is or what the right is?
Well, two things on that. First, with respect to Employment Division versus Smith, I think you would use or at least I would argue the hybrid, even though it's made up. Justice Scalia made it up, and but that was how he saved the Yoder decision, because rather than overruling it, Yoder was considered not to, because there was a general law, a general and facially neutral law as well for compulsory education in some school up to the age of 16. So the hybrid would be parental and religious rights. But I think that we are headed for an overruling of Smith, that all the indications, I think Justice Barrett, Justice Kavanaugh just don't know yet what should replace Smith, but they weren't thrilled with moving right into strict scrutiny. But I think Justice Alito's 77-page concurrence to the Fulton decision, which is we've got to overrule Smith. So I think Gorsuch and Thomas agree with him. So I think that we are headed there, and it will just be the next right case for it. But so that's how why I saw it as an easy case.
So I have a question. Oops. Meyer, when it's giving its list of rights, it's listing both enumerated and unenumerated rights. And I guess a question I would ask is, why did it do that? And what are we to make of the fact that it's listed enumerated and unenumerated, incorporated and unincorporated rights? They're all in there. That might be a question for you.
I will take a crack at it. I think the thinking there is that the fundamental rights expressed in the due process or that emanate from it are not they are not fundamental because they've been enumerated, and the ones that are really enumerated in a kind of particularized way, the court continues through, that is, say, the criminal procedure ones. The court continues to go out of its way to deny are applicable to the states, even as it replicates them. So there's a case called Powell where the court strikes down as a violation of due process a compelled coercion, but it's a case of kind of particular abuse, and it's very kind of overall facts and circumstances, and they go out of their way and say, this is not the Fifth Amendment that we are applying here. This is just justice under the Due Process Clause. To say, to the same move or the same distinction on the First Amendment side is sort of a distinction without a difference, because freedom of speech is by its own terms very formless. You don't know what it means. And so you can say, well, look, we're just policing for really abusive cases at the edges. No, it's not necessarily the same protection at the federal level. But by the way, the fact that it's in the Bill of Rights is further evidence, if you needed any, which you don't, that this is a fundamental protection within our tradition and our system.
I think kind of one way I like to just sort of conceive of that debate is the question is whether rights are enumerated in the Constitution because they're important, or whether rights are important because they're enumerated in the Constitution. And I think the Meyer approach and the approach of a lot of the late 19th century and early 20th century scholars is that those rights are enumerated because they're important. The fact that they're there is evidence that they are important. Modern jurisprudence and some thinkers like Kurt Lash have pushed more towards the idea that those rights are important because they're enumerated, that what the 14th Amendment does is incorporation and just incorporation because the importance of those rights stems from their enumeration, instead of their enumeration just being evidence of their importance without prejudice to other rights also being important in the Anglo-American tradition.
So I can't remember if it was when Professor Stern was talking or Professor Ross was talking earlier, but regarding the oral argument at Meyer, there's a part where I think it's Mullen is saying among the privileges or immunities of citizenship or what have you are the rights that he's arguing in that case. And that, of course, brings to mind another provision of the 14th Amendment that we're not talking about today because it was long buried. That is by this time, which is the Privileges or Immunities Clause. So, question to all of you, but particularly Professor Stern, was there in either the kind of revivification of the push for incorporation of the time, or in Meyer itself, or around that we know the privileges or immunities clause is there, and we've never done anything with it, and perhaps it has to do with the Bill of Rights, and this is a way to shore up that error, and coming out in that colloquy, or is it just coincidental that they're talking about?
Let me just say something quickly and tell me if this is responsive. So they're just case after case, they say privileges or immunities like the criminal procedure rights are not those, that doesn't apply. On the speech side of things, there is this remaining murkiness. Slaughterhouse and Cruikshank have these weird statements in them suggesting there is a kind of a federal, rights of national citizenship. Does this include the right to petition the government? And maybe the protection is one against state interference with trying to speak about matters of federal concern or petition the federal government. It's murky just what the sort of federal hook that they're imagining is there. So there is this piece that's out there. There's a 1920 dissent by Brandeis where he tries to strike down or would strike down a state law against interfering with draft recruiting. So basically, sort of saying bad things about the war effort. And he makes this kind. It's very hard to unpack, but this kind of weird. It's like implied preemption by the federal government's like military power plus privileges and immunities, and working in some kind of weird. It's not fully specified combination, but it's a kind of proto First Amendment piece. They're playing with that, but it never they never really return to that. But there is this weird language. This is what's striking to me. There is this weird kind of preservation of something having to do with freedom of speech coming out of Slaughterhouse that really doesn't seem to go anywhere. It doesn't seem to have any legs, but it's never put to bed either.
Doing that on purpose.
Thanks. So I don't know if this is a question or so much a thought, but it was prompted by Dana's last question and then Professor Stern's last answer and the kind of enumerated versus unenumerated rights. But something that I thought of while we were talking about the two is this whole idea of, or renewed emphasis on history and tradition and how that played out last term. On one hand, you have a case like Dobbs, where the court looks to history and tradition to determine whether an unenumerated right is protected. Then you have a case like Bruin and Kennedy, for that matter, that look to history and tradition to determine the scope of protection or the consistency of a law with an enumerated right. And I wonder if you have any thoughts, if there's anything there. Again, I don't know if it's a question or a thought, but any thoughts on that?
I'll just mention with respect to the Kennedy versus the Bremerton case, that's the coach. It was an establishment clause. Well, it's establishment clause, but it was turned into free exercise and free speech because it was determined that there was no establishment clause issue, and it's really a very striking restatement of how we're going to determine what's an establishment. When there's an establishment violation, and we're looking to history and tradition. And because the case came out last June, I spent the entire last semester, teaching and basically asking the class, and we tried together to figure out what does it mean? Because what history, what tradition? I mean, are we really talking about, is it sort of the Bruin kind of, are we right at the 1791, or are we talking about the long history of religion, state religions from the medieval period or are we talking about the 19th century? And what you were talking about, the Blaine Amendments, the treatment of Catholic children, the beatings, all of that. Are we, what's the relevant history and tradition for interpretation? But that's this really fascinating question of how does history and tradition. I I don't know if they're going to be on like parallel tracks. I'll leave that to my colleagues to answer. But it opens up. If the court wanted history and tradition to be an anchor, it failed, at least on the Establishment Clause, because it now just opens up many more questions than it answers.
I mean, I too don't know the answer, but I do think history and tradition plays a role in the court's modern rights jurisprudence, regardless of whether the right is enumerated. And I think maybe the clearest place you see this is Timms v. Indiana, the court's most recent incorporation case, it's a case about an enumerated right. But when you read the analysis of the opinion, it really is a discussion of the historic scope of the right and how that applies to modern circumstances, such that I'm not totally sure that enumeration needs to make a difference. Because the question with an enumerated right is, okay, you have an enumerated right. Does the analysis of history and tradition tell us that your instant claim right now falls within that enumerated right? And if you have an unenumerated right, the question becomes, okay, does our analysis of history and tradition say that your claim before us right now falls within the protections of the 14th Amendment? There's an argument. I don't know if it's an argument that the people actually writing the opinions would agree with, but there is an argument that it is fundamentally the same analysis, and that you could see a lot of the pages in Timms being written exactly the same way if it weren't talking about incorporating a specific enumerated right. And I think that's certainly something for us all to think about in the future as we watch the court.
And on the history and tradition thing, I do think there are two kinds of questions that come up. One is this sort of fundamentality question. Is this deeply rooted in our history and traditions? What is it? This is maybe a nice right and all, but is it is it a showstopper? Whatever. A different question that comes up, depending on the degree of originalism one subscribes to, and to some extent, everybody views history as somewhat relevant in figuring out what an enactment means. A different question that comes up, certainly in another area that I work in, the Fourth Amendment, is figuring out, all right, so we have this English history, and then the colonists did this thing, and when they did this thing, drafting the Fourth Amendment, were they endorsing that history with its limits, the limitations of protection that were there, or were they repudiating it? Because we have a lot of clear examples in that context, certainly, that it was what the Crown was doing was what they didn't like, and that's the reason for the Fourth Amendment. So you have to sift between those two things. In one of the early First Amendment cases, Grosjean, I think it's Sutherland writing it, he goes through and says, well, the history tells us like this. Here's some stuff that's really important to protect. And then there's this other stuff. There were limitations on the protection at common law that just clearly are not right, so we have to get rid of those. So there's, and I don't mean to make fun of that, it's just to say the distinction between the history that you are embracing and the history that you are repudiating is not totally clear. I mean, one difference might just be we always like when it's pro-right, we're for it, and when it's anti, we're against, but that probably is not very intellectually satisfying. So there's some work that has to be done to sift that out. I think that's inevitable, when you're just trying to look at the context in which an enactment arose, but it's challenging.
All right, we're out of time. I think we're reconvening at 3 o'clock in 15 minutes. Have a snack. And thank you to our panelists.
All right, I think it's right about 3 o'clock. So we are here for our final panel on the future of unenumerated rights. I'm Alex Gervasi. I'm the executive director of the Georgetown Center for the Constitution. And at the request of the panelists, I will try to keep their bios very short, but just know that they are way more impressive than I can ever give them credit for in the short time we have. So first we have Elizabeth Wydra. Elizabeth is the president of Constitutional Accountability Center, where she was previously chief counsel. She's filed more than 200 briefs on behalf of CAC and her clients and argued important cases in the federal courts of appeals, including on issues related to immigration, habeas corpus, and sovereign immunity, just to name a few of those issues. Then we have Julia Mahoney. Professor Mahoney holds the John S. Battle Chair at the University of Virginia School of Law, where she teaches courses on property and constitutional law. Her recent scholarship includes work on eminent domain, regulatory takings, and feminism and common good constitutionalism. And finally, we have Anthony Sanders. Of course, Anthony is the director of IJ Center for Judicial Engagement, and he's the reason we're all here today. He's also the author of the imminently forthcoming book, Baby Ninth Amendments, How Americans Embrace Unenumerated Rights and Why It Matters. I was fortunate enough to receive a review copy, and it is very good. Pre-order it today. Be like Jane. That doesn't make sense right now, but I promise it will eventually after you read the book. And with that, let's kick it off. You'd like to start, Elizabeth?
Oh, yes, okay. Great. Thank you so much, Alexa, and thank you so much, Anthony, and everyone else at IJ for organizing this and inviting me to talk with all of you today. So I'm really excited for this conversation, and I know that we are the end of the day, so we are all that stands between you and a happy hour. So for my part, I won't do too much to slow us down with opening remarks, and I really do look forward to a robust discussion. So as Alexa said, I am president of the Constitutional Accountability Center. When I started, I was chief counsel. I was their first employee hired in 2008. And we are a nonpartisan but avowedly progressive organization that is a nonprofit think tank and public interest law firm. We do mostly amicus briefs in the appellate courts, mostly the Supreme Court, but we also do scholarship. And we work with folks across the ideological spectrum, including often IJ. We've also worked with Cato, Republican former and current officials. So we, I think, are unique amongst our progressive legal movement brethren in that we focus on what has been called, for lack of a better term, and I'm totally open to better terms, progressive originalism. We take very seriously the Constitution's text and history and make arguments that are situated in that context. And so when I was preparing for this conference today, it reminded me of those first days in 2008 when CAC was founded. And one of the reasons it was founded was because our visionary founding president, Doug Kendall, saw that there was a gap where a lot of arguments that were deeply focused on constitutional text and history that could be made on the progressive side weren't being made. And a lot of those arguments that we saw in the beginning were related to unenumerated rights. And so I went back and was reading, and I think this might be the one like actually from 2008, one of our first publications, which you could see is like tattered and in like some like kind of like, we didn't have a lot of money back then, like not a fancy, cover. And we wrote about the Privileges or Immunities Clause. And so when I thought about the future of unenumerated rights, which is the title of this panel, I thought back in history to the founding of CAC and our focus on Privileges or Immunities Clause of the 14th Amendment, and of course then back to the Reconstruction period. And one of the things that I find that is, I think, most compelling when we think about the future of unenumerated rights, and one of the reasons I think we need to go back to the Reconstruction moment now when we're talking about the future of unenumerated rights, it might seem counterintuitive to think back to Reconstruction, is because that was a time in our nation's history when we were deeply confronted with the question of what does it mean to be free, and how can we construct words in the Constitution that protect that freedom? Because the 13th Amendment, of course, had ended the institution of chattel slavery. But then we said, okay, we are going to ensure that there is freedom from enslavement. And then the 14th Amendment answers that question of what does it mean to be free. And the Joint Committee on Reconstruction, when they were drafting the 14th Amendment, took volumes and volumes of testimony about what type of unfreedom existed under the institution of slavery, what brutal limitations of liberty existed under the institution of slavery, and what types of legal protections needed to be written into the Constitution to ensure that those brutal deprivations of equality and liberty did not recur. And that is how we got the words of the 14th Amendment. And that is where we see the textual protection, in addition to the 9th Amendment, and I look forward to Anthony talking more about that, for unenumerated rights. If you go back and read the history of the 14th Amendment, it was unquestionably clear that the drafters of the 14th Amendment knew that they were protecting unenumerated rights. Now that, I think, is the most important part of looking at the 14th Amendment. But when you look at where they thought they were doing that, it wasn't so much in the substantive due process clause, it was rather with respect to the privileges or immunities clause. And of course, we're here to talk about Meyer versus Nebraska. And Meyer versus Nebraska basically could have been, the key paragraph that I'm sure you've been talking about all day, could have been taken from one of Senator Jacob Howard's speeches in Congress around the time of the drafting and ratification of the 14th Amendment. So this is what Senator Howard said when he made clear that the privileges or immunities clause would afford broad protections to substantive liberty. He said that the privileges or immunities clause would encompass all fundamental rights enjoyed by citizens of all free governments: protection by the government, the enjoyment of life and liberty, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety. To this, he added, of course, that there should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. So basically, you get their incorporation and the key words of Meyer versus Nebraska. But Meyer versus Nebraska, of course, even more plainly articulated the rights of heart and home that are so much the subject of debate when we talk about the future of unenumerated rights. And, I think that in some ways, as a progressive, one of the things that I find exciting about the future of unenumerated rights is the potential to go back and look at the privileges or immunities clause again. There have been efforts to get the court to reverse its gutting of the privileges or immunities clause that it started in Slaughterhouse and continued on in the Cruikshank cases. In McDonald, there was a cross-ideological effort, a brief that I wrote and we filed at CAC on behalf of a group of cross-ideological scholars, ranging from Randy Barnett to Jack Balkin. We certainly made that argument. It was definitely not embraced, to put it lightly, by members of the court, not all of them. But one thing that I was thinking about today when I was thinking about coming here this afternoon is, when we first started talking about this as progressives in 2008, there was a lot of consternation because, this was obviously pre-Dobbs. This was in a period where people wanted to keep the gains that they had won under substantive due process and the protections for unenumerated rights that were so valued to people's rights of heart and home that had been recognized under substantive due process, starting with Meyer, going up through the abortion cases, through to Lawrence versus Texas, and then, of course, later Obergefell, et cetera. And so now, of course, in a post-Dobbs world, I am really interested in the way that progressives in particular, because that's my world, but the way in which we all together think about the future of the way that the Privileges or Immunities Clause protects unenumerated rights, whether it matters really, fundamentally, which part of the text that you ground it in. I tend to think it does. I'm a constitutional lawyer and a student of constitutional history, and so to me it matters to get it right. But in a way, we saw the court say to us it doesn't matter. In McDonald, they basically articulated all the history that related to the Privileges or Immunities Clause and basically said, like, but now we put this with the Liberty Clause. Okay, I'm glad that you're recognizing and that it's in there. It's not really where it came from, but okay. So I'm excited to talk about that with respect to the future of unenumerated rights. And I guess I would say that I am, well, again, as a progressive, it's certainly a depressing time to think about unenumerated rights of the Supreme Court in a post-Dobbs world. As a native Californian, I tend to look at the sunny side of the mountain, and I'm always optimistic. I am optimistic about the future of unenumerated rights because, to me, the cramped vision of liberty that was put forward by Justice Alito in the Dobbs opinion, to me, cannot be tenable when it comes to the realm of unenumerated rights that are protected by this Constitution, which speaks so sweepingly of equality and liberty. And so I do think that through whatever inspiration we take from the text of the Constitution, we will see a more robust understanding of what unenumerated rights are protected by the Constitution. Maybe not anytime soon, but I think eventually, because there are promises made in the Constitution that I definitely have faith will be promises kept. And I look forward to hearing what my colleagues on the panel have to say and having a discussion with all of you. Thank you for having me.
Thank you.
Thank you. A lot of what I say is going to, I think, kind of build on what Elizabeth has just said. So thank you, Alexa, for the introduction, and thanks to the Institute for Justice for organizing this terrific conference on what is, in my view, one of the Supreme Court's most important and fascinating precedents, and for including me. So the subject of my comments is the future of Meyer v. Nebraska and unenumerated rights, and I will explain why I think that Meyer has the potential to continue to function as a very powerful precedent, notwithstanding the skepticism expressed in some quarters about unenumerated rights under the United States Constitution, and also why I think Meyer is likely to retain significance even if, as I believe possible, the two other major clauses of the 14th Amendment, the Privileges or Immunities Clause and the Equal Protection Clause, come to the fore to assume more prominent roles in constitutional interpretation and construction, including constitutional interpretation and construction with respect to economic and related liberties. So, go back to 1923. As Professor William Ross noted in his conference keynote address this morning, the court's decision in Meyer articulates the notion that the Constitution provides something of a bulwark for a variety of individual rights, including rights to make a living and rights to contract. And in doing so, Meyer, as Professor David Bernstein has observed, followed on the court's 1917 decision in Buchanan v. Worley, in which the court articulated the idea that the police power of state governments, while strong, cannot be exercised in such a way as to violate fundamental rights, including those of property and contract. After Meyer, the court reasoned along roughly similar lines in Pierce v. Society of Sisters in 1925 and in the Farrington case in 1927. But the next decade brought the New Deal, which included significant and in certain respects discontinuous changes in constitutional doctrine. By the close of the New Deal era, the Supreme Court looked poised to withdraw from the project of systematically enforcing constitutional rights against legislative majorities. Now, to be sure, footnote 4 of the Caroline Products case, which of course cites Meyer, intimated
a potential role for the judiciary in certain instances involving government actions disadvantaging minorities. And the court remained at least somewhat active in the First Amendment arena, which helps, I think anyway, explain why the First Amendment has ended up serving as, at least occasionally, a potent vehicle for economic liberty claims that would ordinarily probably be brought under the due process clauses. However, for the most part, or so the standard narrative held, judicial review would be limited to instances of egregious irrationality or abuses, obvious abuses, of power by public officials. Now, of course, that did not happen. As time wore on, it became apparent that the court was taking on the mantle of enforcer of constitutional rights. In 1954, the court decided the desegregation cases, Brown v. Board of Education and Bowling v. Sharp. Roughly a decade later, in Griswold v. Connecticut, the court ventured onto the terrain of personal rights relating to access to contraception. A decade after that came Roe v. Wade. In the area of property and what are generally referred to as economic rights, however, the court exercised a low level of scrutiny. And the emergence of a dual review standard, drawing a sharp distinction between economic and non-economic rights, was never, so far as I can tell, persuasively defended. As said earlier today, it just kind of happened. Now, these rights, I emphasize, did not become complete dead letters. As my colleague Ann Woolhandler and I devoted a fair bit of space to explaining in our recent article, Federal Courts and Takings Litigation, published in the Notre Dame Law Review. I don't want to tell an oversimplified story, but judicial withdrawal went so far that in 1954, the same year it handed down Brown and Bowling, the Supreme Court shrugged off a constitutional challenge to a major urban renewal scheme for the District of Columbia, an urban renewal scheme that involved property we can see from those windows, and that displaced a lot of people. Once the object is within the authority of Congress, the right to realize it through the exercise of eminent domain is clear, wrote Justice William Douglas for a unanimous court in Berman v. Parker, rejecting the argument that the condemnation of lower and middle-class owned properties was not for public use and thus prohibited by the Fifth Amendment to the Constitution. In the near term, Berman cleared a path for the displacement of tens of thousands of residents and businesses in the nation's capital, together with increased racial and economic segregation. In the longer term, hundreds of thousands of property owners in the U.S. were forced to relinquish their properties as urban renewal was undertaken on a vast, large scale, with devastating results for many communities in the U.S. The court's opinion in Berman v. Parker gave no sign of any awareness, much less concern, about its tension with what else the court was doing this year. Berman was no anomaly. In both analysis and outcome, the decision was in accord with other ultra-deference decisions of the 1950s and 1960s in the area of economic rights, broadly defined, most prominently Williamson v. Lee Optical, sustaining as constitutional a law protecting ophthalmologists and optometrists from competition from opticians, and Ferguson v. Scrupa, rejecting a challenge to a statute restricting the business of debt adjusting, except as incidental to legal practice. As legal historian and my colleague G. Edward White observes, the court adopted a, quote, nearly toothless deferential posture in these cases, one that reversed, as Ted puts it, the familiar locution. Instead of affirmatively finding that a law bore some reasonable connection to a regulatory power of the state, the court stated that it needed only to conclude that it could not say such a connection did not exist. Now, it's hard to overstate the chasm between the court's reasoning in Williamson v. Lee Optical and Ferguson v. Scrupa with its reasoning in Meyer. Meyer can be characterized as rational basis with real bite. To translate doctrine across time is tricky, I realize, as Professor Kim Roosevelt observed earlier today. That said, I don't think I'm wrong to say that roughly speaking, we can call Meyer basis rational basis with call Meyer rational basis with real teeth. Williamson, on the other hand, the optical refused to see what is obvious. It is, to me, a postmodern case, a case about seeing that refuses to see what the state legislature is up to. And Ferguson v. Scrupa is very much along the same lines, blatantly protectionist legislation passed by lawyers to help lawyers. Things in the property and economic rights area began to change in earnest in the 1970s when it became evident that the court was taking claims of unconstitutional deprivation of property rights more seriously. In 1978, the court decided Penn Central, which, although resulting in a loss for the owner of New York City's Grand Central Terminal, at least subjected the government's conduct to more than cursory oversight, and victories for property owners soon followed in a number of cases involving regulatory takings claims. The trend was clear. Property rights were looking more like other constitutional rights, or at least like other constitutional rights that were enumerated in the constitutional text. In particular, those enumerated property rights became, at least not so much, the stepchild of the Bill of Rights. This trend has continued, culminating in the court's Cedar Point nursery decision in 2021. At the same time that property rights cases were becoming, up to a point anyway, winnable, the needle has not moved substantially in the area of so-called economic rights, like rights to make a living, of the sort that involved Williamson v. Lee Optical and Ferguson v. Scrupa. These remain good precedents. Now, from one perspective, precedents like these are ripe for overruling, at least under the factors that the Supreme Court has recently told us that we should look to in terms of figuring out whether cases are ripe for overruling. Stare decisis is important, but it is not everything. And when might stare decisis not apply, or at least not apply with its normal vigor? We are told to look to 5 factors: the nature of the error, the quality of the precedent's reasoning, the workability of the rules imposed, disruptive effects on other areas of the law, and absence of concrete reliance. I would also add a gloss to that. If one thinks of the Constitution as having a framework of individual liberty and as having an anti-oligarchy and anti-corruption and anti-redistribution up aspect, then yeah, I would say that cases like Williamson v. Lee Optical and Ferguson v. Scrupa look even weaker. So where does Meyer v. Nebraska fit into all this? Very simple. The version of Meyer v. Nebraska that features in post-New Deal constitutional jurisprudence, I argue, is only a fraction of the case. That is, there is an unrealized value of Meyer, and it lies in its use for helping to determine the contours of unenumerated rights. Whatever the methodology, broadly speaking, for determining the content of unenumerated rights is, Meyer will be helpful. If we are indeed looking to whether rights are, as Justice Alito put it in his recent majority opinion for the court in Dobbs, looking to whether rights are deeply rooted in our history and tradition, and whether rights are essential to our nation's scheme of ordered liberty, then Meyer is invaluable. Not that it will answer all questions, of course not. What could? And even if the Glucksberg framework turns out not to be so influential, which is possible if there is a significant change in the makeup of the court, just to give one example, it still, I think, will be useful, for I cannot think of a more succinct distillation in all of Supreme Court precedent than we have in Meyer of a vision of the relationship between the individual and the state. This is a vision in which there is no stark divide between economic and non-economic rights. Rather, there is a recognition that the freedoms that are referred to are part of an organic whole that reinforce one another, and that while the state, as Justice McReynolds put it, may, quote, do much, go very far indeed, in order to improve the quality of its citizens physically, mentally, and morally, it is clear that the state is precluded from imposing a particular vision of what constitutes an ideal citizen. Now, the rights explicated in Meyer are not original to Meyer, and they are not unique to Meyer. But what Meyer does serve, in my view, is a reminder. It's a reminder that the rights to make a living and rights to contract and rights to acquire, use, and alienate property were all essential components in our nation's history and tradition. They were not made up by Meyer, not in the least. And that it was individuals who enjoyed these liberties that envisioned, constructed, and maintained the United States' unique scheme of ordered liberty. Now, that Meyer contains so much rich material, even though Meyer is a short opinion about the nation's traditions, makes Meyer valuable, I think, even if due process arguments in economic liberty cases continue to fail to gain momentum. I stress that I think that arguments like the one that the Institute for Justice advanced in its recent cert petition in the Tawari case concerning Kentucky's Certificate of Need law have substantial merit. I am not suggesting that you all give up on this front, not at all. However, those who see themselves as defenders of liberty need to look further than the Due Process Clause and also beyond the First Amendment, which, although as mentioned earlier, potent vehicle, perhaps even one that is punching a little bit above its weight these days, as the panel just before us, I think, suggested from time to time. There is the Privileges or Immunities Clause, which I believe has extraordinary possibilities, as Elizabeth was just discussing, and I would add to that the Equal Protection Clause. Privileges or immunities and equal protection did not, of course, just come out of nowhere to appear in the 14th Amendment. I believe that there is a rich history to be drawn on. That will, of course, involve a great deal of research and a great deal of sustained consideration of at what level of generality do we harness our nation's history and tradition. Property rights, freedom of contract, the right to make a living, the right to have a home, to have a space that is not impinged upon by the government in terms of crafting family life and other intimate associations. That is not something that ever writes itself, and I am acutely aware that developing federal constitutional arguments along these lines generally requires playing the long game, sometimes the very long game. And that is, I believe, a game that is absolutely worth playing. However, in the shorter term, I believe, more action concerning Meyer v. Nebraska and unenumerated rights is likely to take place on the state level. And with that, I turn it over to Anthony Saunders, the author of the forthcoming Baby Ninth Amendments, How Americans Embraced Unenumerated Rights and Why It Matters.
Well, with that lead up, I'm sure to disappoint everybody. So I'm sorry for that in advance. I'm glad, though, that I am now the last speaker of the day. So that means that everyone before me failed to heed the advice of what a wise man once told me, which is to never let yourself be invited to a conference when the organizer puts himself on a panel. But everyone failed to heed that advice, and I actually, I should say, as I've told them, I did not plan this conference with the idea of putting myself on a panel, but after we were putting panels together and getting people to accept your invitations, and after we got these two amazing women on this unenumerated rights panel, I thought, they're going to cover the whole boardwalk. There's not much more to be said except at the state level, and I know a thing or two about that, so I'll fill that little void. And I do have a book coming out soon. So I'm going to talk a little bit about the book. This is not a full-blown book talk. There'll be a chance for that if you want to see what I have to say at various times and events in the future. But I'll say a little bit about what I say in the book today. Also tie it in with Meyer versus Nebraska and give a little bit of speculation about the future, because when it comes to the future, that's really all we have anyway. So I took a look, preparing for this, at how Meyer has been cited in state courts. Now, Meyer, of course, 14th Amendment decision, it has nothing to do with state constitutions, and so it's surprising that it's been cited. This is just Lexis's shepherdized numbers, so take it with a grain of salt, especially with some of the older cases. But it's been cited a little over 1,400 times in federal courts writ large, and a little over 1,400 times in state courts writ large. And I'm sure that leaves out of all kinds of state trial courts where it's been cited. Now, of course, you can make federal claims in state courts. So a lot of these are, could have been made in federal court if it was just came up a different way. But often they're in family law cases, which should not be surprising, especially in recent decades. And where there's a due process issue, of course, with parent termination or whatever the case may be. But it also comes up in kind of more, if such a thing exists, run-of-the-mill unenumerated rights cases, where there is, especially with a little bit older cases, as David Bernstein was talking about earlier, on economic issues from either the New Deal period or shortly thereafter, but it's in state court, or in just all kinds of other cases where a court is talking about a liberty broadly defined, and it's looking for something good to say about broadly defined liberties, and my goodness, that's Meyer versus Nebraska. So the famous passage that you have on the back of all of your programs, that is cited quite a lot in state courts for various reasons. Now, we've been talking all day about what is going on in Meyer versus Nebraska, and there's a lot going on there, but I think one thing that is kind of bubbling up is an American urge to protect rights broadly. Now, that's kind of easy to say, but it doesn't always bubble up in court with judges at the U.S. Supreme Court or at any Supreme Court. But I think it's an example of kind of something that's tried to keep under wraps, and for whatever reason in Meyer, because of the weirdness of that law and the time and place and all the other political stuff we've been talking about earlier, it came out. So what is this American urge? Well, from early in our history, we had this new thing that we had to deal with. What are the implications of that? And that is a written constitution. So from the earliest days in 1776, when the first state constitutions were written, even before the Declaration of Independence, we have the question of, well, what's so special about a written constitution versus the old British Constitution, where, despite a little bit of talk from time to time about natural justice, really everyone realizes that the king in Parliament is the sovereign, and if Parliament says that, you can't get around it. The invention of judicial review, I think maybe some people very much disagree with this, but I think once you have a written constitution, unless you have certain other institutions, judicial review is inevitable. And that started happening in the state courts. It also started happening in the federal courts before Marbury versus Madison. But if you really want to go, Marbury versus Madison is when this was full-fledged, sure. But by 1803, everyone's on board. Yeah, we understand. Maybe we don't like it or not, but we understand this is a thing that's going to be around. Now, then you have to turn to what the written Constitution says. And from May 1776, when George Mason is drafting the Declaration of Rights of the Virginia Constitution, you have language in state constitutions that's pretty darn broad. It's actually broader than due process, life, liberty, or property without due process of law. The language that's at issue in Meyer, and then that we've been fighting about for 100 years ever since and before. That language, there's more than one example of it, but the main example of that is the Section 1 of the Virginia Declaration of Rights, which I don't have the full text in front of me, but you've all seen it. It talks about life, the right to life, the right to liberty, the right to pursue, protect, and defend property, and the right to pursue happiness. This is then cribbed by Thomas Jefferson and put in the Declaration of Independence, but really its origin is George Mason, as Steve Calabresi has shown in great detail, is ultimately cribbed from John Locke. And so Calabresi calls these Lockean natural rights guarantees, and which I think is an accurate description. Maybe it doesn't mean Locke's second treatise of government is part of the Constitution, but that's ultimately where the ideas are driving from. These are then placed in various state constitutions. They kind of spread like wildfire. You can get the full story in Calabresi's article, which he wrote with a student of his. And then they're adopted in various constitutions. Some courts take them at their word. This is how slavery was recognized as being ended in Massachusetts in the 1780s. Some courts see it as more hortatory language, even though there's nothing in the Constitution that says, well, this Section 1 is hortatory, Section 2 is like a real right about freedom of the press or whatever it is, and on. It's just listed like the rest of the Declaration of Rights. Then we get to, along the way, we get the Ninth Amendment. And one thing I want people to walk away from today, to have maybe meeting people like me halfway from where they were before, if you're very skeptical of unenumerated rights before, is if you don't think the 14th Amendment protects unenumerated rights, and you don't think the Ninth Amendment protects unenumerated rights, maybe you can at least agree with me that at the state level, at least some state constitutions really are designed to protect unenumerated rights, and that they are judicially enforceable. So we have the language of the Ninth Amendment, which is its own whole conference that's been held many times, so we're not going to go to that. But we have the language there, which many people argue protects unenumerated rights. Some people argue it protects federalism. Fine. But then we get to 1819. And in 1819, two states, Alabama and Maine, write their own constitutions. They're both about to enter the Union, and so they write their first constitutions, and they both take the language of the Ninth Amendment and put it in their state constitutions. Okay, it's a state constitution. There's no federalism going on there. It's the state with its sovereign people writing its own sovereign law, and there's this Ninth Amendment language. What is that doing there? Well, seems to me something about protecting unenumerated rights, because it's rights that are not, in addition to the foregoing rights, others not to deny, disparage those retained by the people. So you fast forward many, many years of American history through the course of westward expansion, the Civil War, Reconstruction. There's a little bit of ebb and flow here and there, but you end up having, as of today, 33 states have one of these, what I call, although I should credit Akil Lamar and John Yoo for coming up with the term, but they're called baby Ninth Amendments. In addition, there are these Lockean natural rights guarantees with maybe they're enumerated rights, but they're pretty darn broad enumerated rights. The right to pursue happiness, okay, it's enumerated, but that's broad. Right to liberty, right? And so those are in a number of states. And if you add those two lists together, because many states have both, you get to over 40 states that have something that's pretty much an unenumerated rights clause, and that doesn't even get to due process clauses or law of the land clauses. If you interpret them like the Supreme Court did in Meyer, then you have an unenumerated rights clause there, and that would pretty much be every state. So as Americans are having state constitutional conventions and writing these documents, which has had basically happened 200 times in the history of the country, they are adopting these clauses. And although there's not usually a lot of robust discussion about them, to the extent there is, and this is all in my book, it seems like people are agreed these protect unenumerated rights. It's not just some helpful suggestion to the legislature that the judges aren't supposed to, go there. So that, to me, shows that there is this American urge to broadly protect rights and to protect unenumerated rights. Maybe not quite in the way we would argue at IJ in the course of a case, but it's at least very open to being the law. Now, at the same time, judges have often been very reluctant to protect unenumerated rights, and also judges have either been reluctant or just not interested in interpreting the text of these constitutions. We often talk about judges not following the text of the U.S. Constitution, and we have the whole textualism, originalism versus whatever debate, and when you're being a proper originalist and when you're not. But set all that aside, if that worries you about judges ignoring the text of the U.S. Constitution, then you should check out the state constitutional interpretation. Now, often, I should give credit, often over the course of American history, state courts, state Supreme Courts have been very serious about how the framers put our Constitution together, how the voters maybe made an amendment to the Constitution, of course happens constantly, what the text actually means. So I don't want to say this happens all the time, but there are a lot of examples of state courts just not caring what the text of the Constitution is, instead just kind of looking around at what other courts, including the U.S. Supreme Court, are saying about, the law or about rights without regard to what the Constitution actually says. For example, Wisconsin has one of these locking natural rights guarantees. There is no due process clause in the Wisconsin Constitution, which was adopted in 1848. It's been amended since then, but basically the Bill of Rights is the same as it was in 1848. It has no due process clause except for a clause that explicitly only applies to criminal defendants, and it has no equal protection clause. And yet when the court, and this has happened when conservatives in charge of the court is the last few years, and also when liberals have been in charge of the court looks at this section and says, we're going to call this a due process and an equal protection clause, and we're going to pretty much interpret it exactly as the U.S. Supreme Court currently interprets the 14th Amendment. There are a number of errors in that reasoning that I don't have to spell out for you because they're pretty obvious, but that just shows a disregard for what the framers of the Wisconsin Constitution wanted to do. I don't know if it quite reaches slaughterhouse, but it gets pretty close in my view. And that happens, that's just one example, that happens a lot. Now, what is happening today is the last few decades, of course, we've had the whole originalism, textualism movement, mostly from the conservative side, but also from some progressives. And when you start doing that because what people are really, well, not what people really care about, but a lot of the driving force of that, of course, is a very small set of words in the U.S. Constitution, right? So from one perspective, you're going to talk about the Takings Clause, the Commerce Clause, Privileges or Immunities Clause. So you're arguing over, if you add them all up, 50 different words. When you look at the state constitutions, there's all kinds of things times 50. And when you start taking these words more seriously because you've heard, we're all textualists now, you're probably going to start engaging with the Constitution differently. This came up in Iowa in a case last year that was about one of these Lockean natural rights guarantees. And to tell you the truth, I can't even remember what the case is about. I think it was an economic liberty decision. I blogged about it at the time, about a year ago. But a couple judges took it very seriously and said, it talks about the right to acquire, protect, and defend property and pursue happiness. That's pretty expansive stuff, and I think it applies here. And this other justice, kind of a more standard conservative type, he said, look, it can't actually mean that. I mean, if it meant that, that would like cover all kinds of things. So we can't interpret it to, like they did in Meyer versus Nebraska. He didn't say that, but I think that's where he's coming from. We're going to just interpret it, to be kind of hortatory language, and you get that in some constitutions, and like the preamble, and then we'll go on with, with stuff that actually makes sense later in the Bill of Rights. But as there is less and less judging like that, and more judging of trying to take the text seriously, counterintuitively, I'm sure, in upholding or advocating textualism, Justice Scalia never thought this would be the result, is that we're going to have more protection of unenumerated rights when we're in state court under one of these state constitutions. So that is some hope I have in the state courts. Now, maybe it won't always happen under one of my baby Ninth Amendments or a Lockean natural rights guarantee. Maybe it will be under a due process clause or a law of the land clause in a state constitution, but kind of reading that with that, other text in mind to inform its meaning in a way that you don't have as much if you're interpreting the federal Constitution. So I think I'll close on saying that this is a long, I've never written about this, but I think it might be something I'd like to in the future, that there is a long unresolved tension, and I think it's a problem, whatever ideological side you're on, in American jurisprudence of our common law heritage of judges doing the common law process and protecting liberty as a result often, and also the revolution of the written constitution and the sovereign of popular sovereignty over parliament, and interpreting that sovereign language in a way where you look through the common law process to what it means, and that often means you kind of cast around to other common law courts, other state Supreme Courts or the U.S. Supreme Court, to see, what are we trying to protect here? How do these constitutional principles work? Instead of looking at what that text actually says. So I may be coming off a little bit more textualist there as some of my libertarian brethren, but there's a tension there that as the kind of the originalist textualist project works its way through the states, I think that is going to be needed to be worked out, and I think it's worked out, whatever kind of a policy ideology you come from.
Thank you. And I will take Dana's moderating lead and see if you all have any responses to each other and what you heard and any reactions that you want to share.
I have a question for Anthony. Can you say a few words about the cross-pollination between federal constitutional interpretation and state constitutional interpretation? We have certainly seen state constitutional interpretation have profound influence, from time to time anyway, in the area of property rights. And other examples?
Yeah, no, I mean, it is a common thing, and by my last comment, I definitely didn't mean that it is, we shouldn't have it. But that when it happens, it should be done with the constitutional text in mind, which it often isn't. But no, so using Meyer as the example, a lot of these cases from, that are about economic regulations that I wrote about many years ago in the decades following the New Deal, that nevertheless in state courts were giving a little bit of a serious protection of economic liberty, would look to cases, even though the New Deal had run its course, they would look to cases like Meyer, and even at times Lochner is cited as examples of how you operationalize due process of law when you're talking about economic regulation. And sometimes these cases would be like under the state due process clause and the 14th Amendment, so the private the private litigant would raise both. Sometimes they're just about the state constitution. If the state constitution has a due process clause, then I don't see too much of a problem of looking at other courts, interpreting the same language. I have much more of a problem with the court interpreting completely different language where it seems like the drafters are getting at something different.
Any reactions? Well, so I had a question. I thought you said something really interesting, Julia, about Meyer, which is about the way that Meyer articulates a holistic understanding of unenumerated rights without artificial distinctions between economic and personal rights. And, I think that's interesting for a couple reasons. One is because I think that's how people, and not lawyer people, but people understand rights. Like no one, when to the average American, you don't like have this clear distinction between the personal and the economic. Your ability to thrive as a person is tied to your economic, what we lawyers might term your economic rights, but you just think about like your life, like that's your life. And so I really liked that insight because I always like when, one thing that I love about constitutional law and the Constitution is that as opposed to some statutes, it should be something that resonates with everyone, whether you're a trained lawyer or a trained historian or not. And so I feel like that insight gets to really what rights look like in lived reality. And, certainly from my perspective, when I thought of an example of how not segregating those could lead to a greater understanding of equality and liberty, I think about what Justice Ginsburg did as she kind of shifted abortion jurisprudence after Roe and its privacy-based underpinnings to, starting with her dissent in Carhart, to tie reproductive rights to the ability to participate as a full and equal person with full and equal citizenship stature in the public square, including economic participation. And so I was wondering, so that's what I thought of, and I was wondering an area where you would see an improvement in an understanding of rights by not having an artificial distinction between those two.
So I think that for most people, there is not a strong cleavage between, quote, economic and non-economic rights. I've never thought that made sense. As I said earlier, I've never seen it defended terribly well conceptually, and it leads to absurd results where you, in effect, might be barred from making a living because there is some blatantly protectionist legislation passed, and yet have some right to pornography or something. I mean, I think to a lot of people that was like, what? You've got to be kidding. That just, as you say, it's about people's lives. When it comes to these very interesting arguments that were advanced at least up to a point by Justice Ginsburg, it always interested me that they weren't pushed further. And one thing that I have puzzled over in the Dobbs dissent is that it did not say more about economic rights. And one thing, or at least sort of full participation in society considerations. And it seems to me that that abortion supporters did not build out that infrastructure in the years between Casey and Dobbs for reasons that I could never quite understand fully. If abortion is crucial for women's participation in society, then a lot of other things would be too, which Justice Ginsburg never had much difficulty. For example, significant regulation of medical technologies and devices and treatments.
Your own to give the company that makes medical technology.
Yeah, I mean, thinking exactly right, but I mean precisely right. There are some diseases that impact women more than men, and I was always just waiting for more of that constitutional infrastructure, and it never quite came. So going forward, I hope that whoever's on the court, that the court will take a page from Meyer and will not pursue this undefended and, at least from my perspective, indefensible cleavage between economic and non-economic rights. That said, I think when I think about the history of abortion jurisprudence, I suspect that it will be a long time before we see this area of or this line of argument about women's full participation in society. I'd be surprised if that got traction because of the difficulties that I just mentioned. But we will see. It's an interesting area.
Yeah, I think I'm definitely a lot of the briefs filed by women themselves made that argument.
So why,
including personal stories about how it enabled them to have careers and so on.
Why then did the dissent just have stare decisis and not pick up on those arguments, do you think?
Yeah, I mean, if I were on the court, I definitely would have talked about that. I mean, I think actually, I think there's a reason why we started to see the shift in articulation of the right in reproductive rights cases change when you had women justices, in part because of that lived understanding of how rights operate. And, the idea that previously the underpinning was a right of privacy was really shifted in some ways to a very public right of, the right of equal citizenship stature is public. That's not like a private thing you do by yourself. That's a thing you do with society. The ability to be a full and equal participant in society, in every meaning of that term, is public. And I think it took having, frankly, women justices on the court to articulate that better. Not that men couldn't, but they didn't. So I think that, I do think that there will be more of that, especially as we have, I do think that the briefs were very articulate and compelling on that score, although I also wish it would have featured more in the dissent, although I think it did, they did cite some of the data on that. But yeah, I think it'll be interesting, and I think as we see some of this litigation go forward in the state courts as well, how those different bases for the asserted right are articulated. But certainly, when I look back to the Reconstruction period, there similarly was not that cleavage. And it was very much one and the same. The idea that the ability to control one's own body and the ability to have personal autonomy and dignity was intimately tied up in the right to control your own labor. So the right to decide things for your own body and the right to control your own labor and the right to be secure as a person was all tied up together in a concept of freedom that, when you put it against the backdrop of the institution of slavery, is obvious. But as we have gotten further away from the drafting of the 14th Amendment, I think we've kind of lost that holistic idea of freedom and liberty.
So you actually mentioned something that I wanted to pick up on with this panel. Elizabeth and Julia, you discussed kind of what do we do post-Dobbs? How do we protect rights in this new era? And then Anthony talking about the state courts, and something, a conversation that's been happening is that where we go next? Is we have these fights, we take our fights to the state courts primarily while we wait to see what happens with the court and who ends up there. And I'm just curious about your thoughts on that, and how should constitutional litigators be refocusing their attentions on the state?
Anthony?
Yes.
I think both. I think there are really important, the dialogue, I think, is very important between the state constitutions and interpretation and the federal constitutional interpretation.
Yeah, I think both as well. I think certainly, also I'm a federal court litigator, so of course I'm going to say that. But, I think it's important not to cede the field. I think Julia talked about a long game. And certainly I think to the extent there are shifts in constitutional conversation, they often take place over a long period of time, even if sometimes they might look abrupt. And so, certainly from my perspective, continuing to press these arguments, even in a court that might not be willing to take them on as majority opinions, is still important. But, I do think the states are really interesting. Obviously there's the baby Ninth Amendment context, but there are also states, we were involved in a case in Kansas where the Kansas Constitution invokes the Declaration of Independence. And so, then you kind of get this interesting mechanism where, when the drafters of the 14th Amendment were writing that text, they thought that was going to be the place in the U.S. Constitution where the Declaration of Independence would finally be immutably placed in the Constitution. And so then you have a state constitution that specifically invokes the Declaration, and then we used understandings of the 14th Amendment to then import into that conversation. So I think it's both, and I think there is this cross-pollination.
Yeah, and it's important in all kinds of areas. I mean, Dana and I had a case a few years ago about Fourth Amendment protections, but in state constitutions, and we're still litigating that IJ at IJ, and there's all kinds of other provisions that you have in state and federal constitutions, and I think the meaning of what those are should be reminded that they are based in the text of that Constitution, but all too often courts, especially state courts, and there's so many kind of political economy reasons for this, but they look to what the federal courts are saying about a different document when they're interpreting their own Constitution, and it's important for us as the bar, and as well as for judges, to remind us that that they can interpret their own constitutions just fine. And when they do, that can influence then what the federal courts see as possible. I mean, this script has been run many times, of course, but with gay rights, with the civil rights movement, and other instances as well, that is how constitutional change happens. It's not just, I file a case in federal district court and it bubbles up, and that's all you need.
Great, thank you. And I guess we'll take questions from the audience. Make them good, because this is how you earn your open bar afterwards.
Wow.
Yeah.
David Wagner, Free Families Foundation. I guess my question is for Elizabeth in the first instance, and anyone can take it. One semester teaching con law, too, we did a particularly deep dive on the civil rights cases of 1883. And I came away with the conviction that Justice Harlan I was wrong about state actors, that is in the 14th Amendment, but he was right about the 13th Amendment, i.e. that it should be read as carrying badges and incidents of slavery content, which, if it had, not only could it have provided a vehicle for upholding the statutes in that case, but it would have eliminated the necessity to go a somewhat unconvincing Commerce Clause route 90 years later. And I'm just wondering what you think about the 13th Amendment. Does it contain badges and incidents implications? Could we read it that way?
Yeah, that's a great question. And that sounds like an awesome semester of con law. That certainly did not happen in my semester of con law. I think that's a really good argument. And, there are certainly, I think, very good arguments for that. Again, like what was the point of the 13th Amendment? Obviously there was the very basic point of ending the institution of chattel slavery, but it was intended to end the institution of slavery as it existed in America, and that includes badges and incidents of slavery. And, I think probably if you'd asked the drafters of the 13th Amendment after they saw, the proliferation of black codes and the ways in which, many authorities and governments basically reinstituted slavery under another name, they probably would have written it a little differently. I don't know that, so that's just my guess based on the conversations during the 14th Amendment. But I do think they thought that the 14th Amendment would try to get at some of that. But I think they could have accomplished it also by being plainer in the 13th Amendment. But I think it's a very good argument, and it's the way in which the Supreme Court really thwarted the promise of the Reconstruction Amendments, the 13th and 14th Amendments, is one of, I think, the greatest tragedies in American constitutional law, because there is such promise there, and we've really never seen it fully blossom. And so I think there are lots of arguments to be made there about what that looks like. And I think some of them come from the 13th Amendment. Probably many more of them come from the 14th Amendment, but powerful ones, I think, can come from the 13th Amendment. And I think that also, the 14th Amendment was drafted, it was after the 13th Amendment, but it gained some of the lessons of what the drafters saw after the 13th Amendment maybe did not accomplish everything they thought it would.
Anthony, do you have a response?
Yeah, no, I have a follow-up question, because this is very intriguing to me, and that my limited knowledge about some of that history, but an argument that I really like is that the 13th Amendment, right, has to be understood with Dred Scott in mind, and that once you didn't have slavery, these people that were talked about in Dred Scott as not citizens, that once you de-enslave them, they're citizens. And once you're a citizen, you have all the rights of citizenship that everyone else had. So with that understanding, if you had said in 1864, okay, we're going to have this 13th Amendment, but then later we'll need this 14th Amendment stuff, the response might be, why are we going to need all that? They're going to be citizens, and they're going to have free right, everyone is citizens, because everyone understands that citizens are on an equal footing. Of course, that didn't happen. But then we have the first sentence of the 14th Amendment saying everyone born here is a citizen, with that same understanding of what citizenship means. And this came out a little bit in a teasing way in the last couple of years, where Justice Thomas had, I can't remember if it was a concurrence or dissent, where he's saying we should do more with the citizenship clause, and I might be more into that for doing equal protection stuff. Do you see a future for the citizenship clause, or would you like there to be a future citizenship clause, and how should we do that?
Yeah, I think, like Justice Ginsburg, who saw the citizenship clause as essential to, the equality for women in particular. I do think there's a lot in the citizenship clause. It ties, of course, to the privileges or immunities of citizens, and I think it all comes together to articulate a version of equal citizenship stature that applies for all. And, I think, the experience after the Civil War and around the time of the 13th Amendment and immediately after demonstrates that the institution of slavery obviously was defined by the enslavement of Black people through chattel slavery, but it was perpetuated by a larger code of laws that instituted subjugation and defied the promises of equality and liberty in the Declaration. And so the 14th Amendment was necessary to make that true, because, as was seen by the Joint Committee on Reconstruction in their in the testimony they took, the way that the subjugation of the institution of slavery was perpetuated was also by infringing free speech rights from abolitionists, Black and white, by infringing the ability of movement by union men, as well as men and women of color. And so I think that the broader context of the oppression that was meted out through the institution of slavery was needed the 14th Amendment, even if the 13th Amendment had been understood to immediately grant citizenship on an equal basis to Black and white.
I feel like there's a lot of pressure. That was long. Thank you. So I was originally going to ask about how our unenumerated rights jurisprudence today would look if Justice Goldberg's concurrence in Griswold got 2 more votes. But in light of the fact that Anthony invoked H.G. Wells' Time Machine on the most recent installment of Short Circuit, I thought it would be perhaps more timely to ask whether, when considering unenumerated rights, and this sort of underpins what's going on in Dobbs and Bruin, although Bruin's, of course, not an unenumerated right, it's Second Amendment, to what extent and to what point do we look and have to time travel when looking for unenumerated rights? Do we look to, or try to find the genesis of that right? Do we look to any particular point in time, like the framing, Reconstruction, or some other point in American history? And in light of what Anthony said earlier about George Mason, does this time machine have a window with a Lockean tint?
I think we look to everything, with particular emphasis on the founding era and the second founding Reconstruction era. But it seems to me that it all comes in one way or another.
Yeah, I think we look. Sorry, I'm going to sound what I said earlier, but I think we look to the text. Depends on what provisions we're interpreting. We're after all, the way judges make their rulings in constitutional law is not through just principles of natural justice, as much as we'd like that to be. And so if the provision is the enumeration of certain rights in this Constitution shall not deny or disparage others retained by the people, we interpret what that means. Now, what is the timing of that particular text? Well, that is a question we could have. But I could see, depending on how your Constitution is written and then the other structural reasons you have to interpret the Constitution, it could be you look to 2023 for what the text means. It could be you look to 1868, you look to 1819 if you're talking about the Maine Constitution, 1970 if you're talking about the Illinois Constitution, or it could be that the constitutional writers themselves wanted to create kind of a protection that would change with the times. And it wasn't just judges thinking we need to update the Constitution to change with the times. It was that the framers actually wanted you to change with the times. And so, unfortunately, I can't give a satisfying exact answer, but I think sometimes you need a little bit of a time machine, and sometimes you need less of one.
We have a minute for another quick question.
I'm going to let Dana get the last one then, just to over.
Well, I don't know if this is quick.
Well, no. Well, first, can we have our guest there, and then.
Okay, well, Eyal Moses, no affiliation. My question is about the privileges and immunities clause. If it were to be put more forward as a basis for protecting unenumerated rights, what would that mean for the rights of non-citizens? Since it's explicitly about protecting citizens, I have heard the argument that once the rights of citizens are protected under the privileges of immunities clause, the equal protection clause can then be used to extend them, but that seems a rather brittle way of protecting the rights of non-citizens. So I was wondering what that means,
Yeah, I think that's a great question, and it's definitely one that we have thought a lot about. And I do think the most obvious way is any right that is recognized for citizens, you have to have a good reason for denying under the Equal Protection Clause to non-citizens. So I do think that the Equal Protection Clause would operate very powerfully there. I think there's also, I know that jurists and maybe law professors and law students like things to be very categorized and cabined off from one another. But I think as we've seen, particularly with Justice Ginsburg's articulation of equality, is that it's not so easily cabined of this comes from this clause, this comes from this clause, this comes from this clause. And so I think the idea that, as she put it, of equal citizenship stature is obviously, the clause speaks to citizenship, but I think the idea of having equal citizenship stature also comes in through the Due Process Clause and the Equal Protection Clause as well. But it's definitely something to think about, and I think it's a really important part of that calculus when you're talking about rights. Whether they would be, whether it would provide less of a basis for rights for non-citizens than, kind of what we have now.
This is kind of a change of topic at the very last moment, but I wanted to ask about property rights. One of the themes, I think, from today is that rights aren't as easily cabined as just being one thing or another thing. And property rights are kind of partly enumerated and partly non-enumerated. And they've been treated largely by the court as unenumerated, although part of it is actually in there. And I guess I'm wondering what you think about the future of property rights, both like, are they going to count it as enumerated? Are they going to count it as unenumerated? Or what will be happening with that?
A recent trend is to characterize property rights as enumerated rights and as being somehow in the family of the other enumerated rights. Now, how much difference does that make? Not entirely sure. But this is the trend. What does it mean for the future? I think it means possibly a reconsideration of Penn Central, as it becomes clear that kind of nibbling around the edges, like we saw, I believe anyway, in Cedar Point Nursery, with an incremental protection, additional protection of property rights, if the regulation can be analogized to a recognized property interest, in this case an easement. I mean, there are limitations to that methodology. It will get you only so far. And when I think about the 5 factors that make a precedent weak, Penn Central looks pretty weak.
All right, thank you. And before I turn it over to JoJo to give parting instructions, please join me in thanking the panel and thanking IJ for putting this together.
Thank you all for coming very much. And this proceeding is now adjourned for further proceedings at the bar downstairs.